Except 2:30, no other mentions to be made. And any mentions I'll hear on Tuesday. Already the board is full today.
My lord, this is actually there is an urgent matter.
Huh?
IA has been rejected for appointment of the commissioner. It is scheduled for final chance for arguments on 28th.
When was it dismissed?
It's quite some time now. This is
Then I
second
have
time
I have no
I've
time
moved the
for that.
memo.
One submission, madam. Only one suggestion. The petition has been issued against it for injunction. The trial court has issued emergency notice. Challenge which since the trial court did not.
Is it a fresh matter?
Status quo has been passed by this court. My
Yes.
suggestion is, madam, petition itself may be disposed of. Status quo
No.
will continue.
For that, I have to hear the matter. There are so many matters. In 2026, stays are granted in thousands of matters. Every matter I cannot vacate. Please accept, I am specifically saying, except the 2:30 matter, no other matter to be mentioned. And don't take any memos, fresh matters, because there's a clear direction to post the fresh matters. Remaining others, giving a specific reason, if they give a memo, look at the memo. If the memo gives a specific reason, then take it. Call the list.
One small submission.
That is a memo, isn't it? That is a memo which should be given to the court officer, which I will look at it and assign a date. Sorry. So please don't make a mention.
Madam.
Despite that, they could have gone to stay, my lords. And the stay is on the ground that they have to answer a question of law. And it's listed on the second is 41st matter, my lords. Second is an urgency. Two coordinate bench directions are there.
Is it an urgency? If two coordinate benches have passed an order, that will be heard when the matter reaches. No. I will not take up. And please don't waste the court's time when I am not granting it. Yes. No.
Pending up.
When it is going to expire? Then what are you doing all these days? And even on that ground, the matter has to be taken up today at 2:30. No, I will not take up. Let the interim order expire.
Serial.
We have filed this writ petition on Monday, my lord, sir. The impugned order was passed on 16/7, my lord, sir. IF for representing through SPA has been declined, my lord. IF for ex parte is also been declined, my lord. This is a suit for partition, my lord, filed by the children.
Why it is not listed? Because office objections are not.
No defects, my lord.
Tell the court officer. In that case, tell the court officer. Court officer will find out. For that, a memo is not required.
Some urgency, my lord. Respondents may create bona fide apprehension, my lord, sir. Respondents
No
may
reprehension. I will hear it on Monday. It will come on Monday. Court officer will look into that.
Serial number,
This number 2, serial number 34.
It's an ancestral property.
What are you doing from Monday till now?
My lord,
No, you can't. Whenever you come to the court, that is not the urgency. I will not take up. I have already enough matters. I won't be able to take up any of the matters. Yes, let it come. Let it come.
Serial number 69, my lord.
Call the list, court officer.
16, my lord, 69.
List number 2, serial number 31 will be taken up at 2:30, my lord. My lord.
Give the memos to the court officer.
Less on small submissions, my lord.
Specific reason that matter, sir.
My lords.
Even then I had taken process against it on 13/7 itself. The order did take expired by today.
That's why till the nick of the moment, what are you doing?
No, actually, today only I have saw that.
Whenever you see, that won't be the reason for the court. And court has enough work. Please understand. And I'm not going to take any matters today. Yes.
My lords, one small submission, my lords.
Serial number 80, memo for conversion. Serial number 80, my lords.
I will hear it. I'll take it up.
I am practicing. I am to give the memo for conversions.
Yes, I will take up later.
My lords, one submission, my lords. My lords, list number 2, 31, my lord. It may be taken up at 230, my lord.
One humble submission, my
Call
lords.
the list.
My lords, list 2, serial number 30 is posted
Writ
for.
petition is dismissed with cost of rupees 50,000 to be paid to the respondent.
Serial number 2.
Yes.
My lords, one humble
My
submission,
lords,
my
may I
lords.
make a submission in this, my lords?
Yes.
Serial number
Kindly
1.
have this matter, but tomorrow.
My lords, one humble submission, my lords.
Pass the order.
Dismissed with cost of rupees
I only
50,000.
request this. We have this been kept in abeyance for some time. Party may want to approach the Supreme Court. Kept in abeyance for about 4 weeks. Just one
But you can
opportunity.
see seek the Supreme Court. We can't indulge in
There was an
that.
interim order in this matter from February onwards. Just at least a couple of weeks because we won't have time to file it. But
Yes.
there was a stay order from February and this order has been stayed time and again since the last couple of years.
Serial number 8.
No, no.
2 weeks, my
No,
lord.
after, no.
2 weeks, my lord, just for the opportunity to go to approach the Supreme Court. Because the consequences are very
In
serious.
none of the cases we grant any leave to go to Supreme Court. You can go to Supreme Court. Will not keep any order in
That's
abeyance.
true. That's true, my lord.
Not
The
with this kind
consequences
of.
of this order, my
No,
lord.
Mr. Senior Counsel, with this kind of litigation, I'm not inclined to. Yes.
The consequences, my lord, will consider that the police are now going to try and evict, which my lord has taken a view that they are entitled to do so. I am only requesting that an opportunity be given to approach the Supreme Court.
The
weeks.
orders of the court has to be honored. It can't go on, keep on
Of
going
course, my
like
lord.
this.
Of course. We had a contention, my lord. If that contention has not found favor with your lordship,
Yes.
2 weeks, just for an opportunity to approach the Supreme Court.
Yes.
Serial number 2, Srinivasan T for petitioner.
Grateful, man.
Petitioner, my lord.
Yes.
The plaintiff's petition, being agreed with the order of the miscellaneous appeal, divergent findings, sued for declaration of title as well as permanent injunction.
Yes.
Trial court holds that prima facie case is made out by the plaintiff as such, page number 66, para 18, my lord.
60?
66, para 18.
Yes.
From the scan of the documents, it is very clear that the plaintiff and defendants are having prima facie case and balance convenience and hardship lies in favor of the plaintiffs and defendant through the documents. It is well settled law that while deciding interim application, the trial court should not hold mini trial for which I place the decision report in so and so. Wherein it is held that the court should not hold any.
What is the suit for?
Suit for declaration of title and permanent injunction
Yes.
in respect of 16 guntas of land in Kattihalli village.
Court
Defendants
has ordered to maintain status quo.
status quo.
Hmm.
First appellate court holds that the status quo order is not proper and
Set
rejects.
aside that order. Please come to the appellate court's order.
Apex court order is at page number 57.
50,
7. Sorry.
page number 30.
25.
Hmm.
Reasoning is at page number 25.
Where is the reasoning starts?
Reasoning starts at page number 25, internal page 11.
What is this litigation between the parties? It is a case of the defendant that OS number 161 of 2009 filed by the defendant herein against the plaintiff seeking the relief of injunction in respect of the property has been decreed and the same is confirmed by the first appellate court. Is it correct?
That is correct.
Then how are you entitled for
As
injunction
against
now?
that, regular second appeal has been filed and that appeal is pending consideration. Further, my lords may
No,
kindly see.
only
page-
on that point, when there is an injunction in favor, as of now, that injunction is subsisting. How are you entitled for
Very same
injunction in your declaration suit?
My lords may kindly appreciate, the very same defendant files another suit, page number 28.
What is the suit number?
That is 47 of 2012.
Hmm.
page number 28, in the middle of page number 28, the filing up of suit number 47 of 2012 by the defendant herein against one Venkateshappa, abated against defendant and the plaintiff herein defendant number 1 for the relief of injunction in respect of property of the defendant and the plaintiff. The schedule has mentioned so and so. It is for the fact of dismissal of the said. Another suit filed by this very defendant is dismissed in OS 40.
Against another person, not against you.
I am defendant number 1.
But anyhow, there is a judgment and decree as of now
Please, ma'am,
in his favor,
please.
in
But-
against you, an
And-
injunction against you
Injunction against,
in respect of the very same suit scheduled property for which you have sought for declaration.
please.
It's there or not, is it a fact?
It is a fact.
Then in that circumstance, in those circumstances, where is the question of status quo? Whether you have filed the second appeal, in second appeal, there are no interim orders passed by the court.
No.
Please come.
Actually, even the first appellate court for that matter holds that the location of the property, a commissioner needs to be appointed. First, it's the opinion of the first appellate court that the location of the property is not established. And further, it holds that a commissioner needs to be appointed.
But unfortunately, the first appellate court has failed to consider this aspect. But anyway, I will not go into that aspect, give any finding on that. I will just affirm the order of the appellate court. Or if you want the matter to be remanded to the court, I can only issue notice.
Notice may be.
Yes, notice to the respondent.
Then number 3.
In addition, hand summons. Yes, 3.
3, MM Ashoka for
I
petitioner.
appear for the,
Okay, in all the matters.
appear
4th
for
of
the
August.
petitioner, my lord.
Hmm.
The subject matter of the suit is for rejectment, my lord. And
What is the IA?
IA, there is no IA, my lord. Only thing, there is inordinate delay in proceeding with the matter. So my humble submission to your lordship is to grant
2024
time.
matter.
But it is a simple suit for rejectment. Whenever the matter comes up before
The
the court,
Bangalore court.
they take on the ground of we will compromise the matter. Then I filed a memo stating there is no possibility of compromise. So my humble submission is
court, I will
a
not-
time bound, time may be granted about 6 months time to dispose the matter. It is very simple matter. Even my
For you it
evidence
is-
is also completed.
For
my
you, it is simple. But
It is
there are
a-
so many other matters pending in
That's
the
true, my
file
lord.
of the court.
He's aged about 70 years. He is no source of income. He's a chronic defaulter in making payment also. Only a time may be fixed to dispose the matter, either 6 months or 7 months. Even the evidence is also
In
complete.
the normal circumstances, I wouldn't have not granted any order. He is 70 years old. But I will say expeditiously, but not fix a time frame. The present petition is filed the following prayer. When counsel for the petitioner submits that the petition is aged 70 years and on one pretext or the other, the respondents are dragging on the matter. In the normal course, this court will not grant any, will not issue a mandamus directing the court to dispose of a 2024 matter. Considering the fact that the petitioner is aged about 70 years, this court deems it appropriate to pass the following order. The writ petition is disposed of directing so and so to dispose of
The outer limit may be fixed.
the matter as expeditiously as possible.
Till number 4, Maya Ullah.
Suit for partition, because I'm challenging the order where Malats, the defendants 5 and 6 were initially not made parties. Malats, they were impleted. Malats, that order was passed on 28th of January. That's 6/6/2025. Then Malats, they entered appearance before the court in April 25. Malats, sufficient time was granted. They didn't file written statement. It was taken as nil. Malats, 4 months thereafter, Plus, they file an application for recalling and to permit them to file the written statement. Plus, without recording any reasons, if I may request Manoj to come to
Why
page.
is your suits were unnecessarily, why do you want to stay your suit? Ultimately, it will be allowed.
Plus, I have not sought for any interim order. Plus, I'm only saying, Manoj, the trial court should have assigned any.
No, at best, we will grant some pause. Otherwise, it's all waste of your proceedings will be stayed unnecessarily. Because filing of written statement with that kind of not an inordinate delay. That reason, if we say the court will again pass the order giving the reasons. So how is it going to help you?
That's the only thing is, Manoj, the Honorable Supreme Court recently has also said that even though it is not mandatory, time prescribed under Order 8 Rule 1 is not mandatory but directory, but it has to be strictly implemented
But
by
I
the court.
understand. Now,
Yes.
this is not an inordinate delay also. How many days after they appeared?
No, after it was 3
Summons.
months after they appeared, well, it's, once the application for impleading was allowed, they were granted 3 months to file written statement. They didn't file. It was taken as nil. Then 4 months thereafter, an application is filed for recalling.
We'll order notice when they come. We'll allow it on call.
May I request Manoj to issue notice only to those two respondents? The other Manoj notice may be respondents 5 and 6.
Seeking dispensation of notice to so and so. Issue notice to respondent.
5 and 6.
Respondent 5 and 6. Petition is permitted to take out hand summons and shall file a memo to that effect by 17th of August. If the memo is filed, list the matter on 18th.
Okay.
Yes.
Then number 5. There will Adappa for petitioner.
Appearing for the petitioner's matter, my lords.
Yes.
My lords, the impugned order is at page number.
What is the suit for?
My lords, it's not a suit, my lords. It is actually an execution petition, my lords. The DHR in the execution petition files a memo saying that he does not have the original of the award passed in an arbitration, my lords. On the basis of this memo, my lords, the honorable lower court passes an order saying that the execution cannot go forward because the original order, the original order is not to be found, my lords. The order is of the year 1999, my lords.
1999 execution is filed.
No, my lords. The award is passed on 7/11/2003, my lords. The arbitration is of the year 1999, my lords. Post which, my lords, the section 34 was filed by the JDR in the year 2007, my lords.
Oh, that is that 2000 order is the execution you are seeking.
Yes, my lords.
Please come to the order.
Yes, my lords.
Page number.
My lords, the impugned order is at page number 98, my lord.
Page number?
The
90.
operative portion is 131. Impugned order is at page number 98. Operative portion is at page number 131. At para number 5, my lords.
What is that?
This
judgment of the-
I think High Court order, what
Unless
is
certified
mentioned in.
copy of the award is placed on record.
Yes, my lords. If I may take my lordships to that MFA order, my lords.
Will
That-
order notice?
My lords.
Will order notice?
Please, my lords. Please.
Notice to the respondents. Same hand summons. Memo shall be filed, if the memo shall be filed by 18th of August. If it is filed, list this matter on 19th.
Obligement.
Number 6. Petitioner.
Hearing for petitioner, my lords.
Yes.
Let's hear, my lords, proposed dependent number 4 has filed an application to implead himself
What is
as
the
a
suit
defendant. Suit for partition, my lords. My lords, here, my lords, he claims to be.
You are the
is-
plaintiff.
I am the plaintiff, my lords. My lords, I am only on the point that, my lords, before filing of him, my lords, I have filed an IA for impleadment for another defendant number 4, my lords. Let's technically, my lords, he has to become defendant number 5, my lords. Now, my lords, the trial court ordered, my lords, allowed IA number 2 and asked us to amend the petition, my lords. Technically, my lords, the facts of the, my lords, IA number 2 is different and facts of IA number 3 is different, my lords. Now he has narrated the facts of IA number 3 and ordered to amend as a defendant number 4, my lords. Initially, I have
That you
filed.
could have brought to the notice of the court.
My lords, we have told that, my lords, now, no, we have passed an order, you please amend, he has told, my lords. That's
What it says?
My lords,
I have already passed an
the
order, go to the High Court, she said.
My lords, he asked us to amend the petition, my lords. Amend the plaint, my lords. My lords, this is the IA number, kindly refer to.
Come to the order, take that, come to the order.
My lords, page number 43, my lords.
Page number 43.
43, my lords.
This is an IA number 2.
IA number, this order on IA number 2, my lords.
Yes.
Let's now just I passed on. my
No,
lords.
no, we'll see that.
Yes, my
Then
lords.
order under IA number 2.
Yes, my lords.
Filed under order 1 rule 10. What
Rule
is this order? Applicant permitted to come on record as defendant number 4. Plaintiffs are directed to amend the plaint by including the applicant. You should have become the defendant number.
5, my lords.
Already 4 is there.
Oh, my lords, I have just.
But how can the court say like that?
My lords, that is a difficulty to us, my lords.
Where is your IA? Where is their IA?
My lords, it is at page number.
No, for this, why should an appeal be the
Page number
Reputation will
25,
file.
my lords.
Huh?
25, my lords.
20?
5. It's subsequent IA filed by proposed depend number 4, my lords.
He
And
says
he
that
says
it has to be implemented as defendant number 4.
4. My lords, before that, my lords, plaintiff himself have filed an IA for impleading the
That
tahsildar.
order is when? When is that order?
That order is not passed, my lords. Only notice has been issued on that, my lords. This is at page number 2, my lords, which I have produced. This is I have filed in the year January.
Simple would have been, this order, so far order is not passed. Without passing an order, how will the defendant, this proposed party will say, assuming that he will be impleaded, implead me as defendant number 5, he would not say that. Now your pending application,
Yes,
you
ma'am.
can seek amendment saying that, let the other person be impleaded as defendant number 5. That will cut the issue. Why should you come to the court for this? And where there is no order is passed.
Yes, my lords.
I leave it open that this pending IA, that you will seek amendment.
Let's also, my lords, in this, let's yes.
If that is the objection, it can't be. Other than that, if there is any objection, you want me to look at it on the merits of it, I'll look at it.
Yes.
What is on the merits of it?
My lords, this is a suit for partition, my lords. This is a partition filed against the brothers, my lords. My lords, now the proposed defendant number 4, who is now allowed, my lords. My lords, he claims that he has purchased the property in the 2005, my lords.
2005.
2005. My lords, later on, my lords, in the family, my lords, kindly, I have filed my objections, my lord, detailed objection, stated that in
He
the,
purchased from which defendant?
my lords, I am not a purchaser. It is an ancestral
No,
property.
not you.
My lords,
This implead
this
applicant.
impleading applicant has purchased a property by another person, my lords, who is not related to in this suit, my lords. He claims that he has purchased from the ancestor by other brothers, my lords. My lords, I have not sold the property to them, my lords. My lords, pending 2005, my lords, he has purchased the property.
The person from which this impleading applicant has purchased a property, is he a party to the
No,
suit
my lords,
or
he is not a party to the suit. That is my ground, my lords. My lords, the thing is, my lord, 2005, my lords, he has purchased. He said he has purchased the property.
Please,
My
let's
lords,
see
at
your,
that time,
let us see your objection.
my lords, kindly.
Page number?
My lords, page number 35, my lords. My lords, para number 19, my lords, I have categorically stated, my lords, from
No.
the suit was
Come
pending.
to paragraph number 2. You said Shivappa had 5 sons. You belong to which branch?
My lords, I belongs to Rudrappa, my lords, 5.
You belong to Rudrappa.
Yes, my
And
lord.
which person has sold the property in favor of the impleading applicant?
My lords, Dodda Muniappa, 1.
Dodda
First clan.
Muniappa. Was there any partition between all the brothers?
Yes, my lords. My lords, I have stated that I have stated it is in para number 22, my lords. It is submitted that though the judgments and decree passed and the revenue documents are stands in the name of other joint family members, the plaintiff and defendants and his family members are in possession and
So
joint.
when was the partition?
My lords, it is in 2012, my lords.
When did you purchase?
My lords, 2005. My lords, before that, my lords, in the year 1992, the suit is pending, my lords. There was appeal was preferred, and my lords, during the continuation of the suit, my lords,
Notice is response.
Number 7.
Same hand summons,
my lords,
like in the other order.
to respond number 1, my lords,
Only respond, huh?
2 to 5 notice may be dispensed.
Memo is filed seeking dispensation of notice to 2 to 5. Only one notice to respondent number 1. Hand summons also to 1. Yes.
Question number 7.
Please, Lordship.
Sanat Kumar.
Challenging the impugn order dated 25/3/2026, which was
What is
a
the suit for?
suit for declaration and permanent injunction between the family member, brother and
You are?
brothers. Between the brothers.
You are
I'm for the elder brothers, please.
plaintiff?
Plaintiff, please.
What is IA? Impugn.
IA for seeking an amendment of inclusion of a prayer, which is application I
Notice
filed.
of which year?
Please, Lordship.
Notice of which year?
2006, please.
Please come to your application for amendment.
Please, Lordship. Page number 51 to 54, please. Please, Lordship. In that, the
50,
clearly,
51.
please.
Yes.
So main plaint has been filed on the.
Let's read you.
Please. That the proposed inclusion of additional prior is declare the plaintiff is entitled to off share in the scheduled property according the partition of the same meets the bound while placing the appellant plaintiff in the
I'm
share.
looking at your affidavit. What did you say?
Please, Lordship. There was a suggestion by the opposite persons regarding the joint family properties. And the same said suit scheduled property has been purchased by alienating the ancestral property, which is admitted by the respondents and the defendant before the trial court. Same has been considered by the trial court itself. Without changing any nature, please, Your Lordship, that I am seeking only amendment of inclusion of the prayer. This honorable court has.
What was, no, what, we don't require judgments at this stage. We
Please,
require
please.
the clarity on facts.
Please, please.
Come to your original prayer.
Please, Your Lordship.
Where is it?
That I have produced the appeal copy in a page number.
Plaint.
Actually,
For now, in the appeal, you want to amend
appeal,
it.
please, Your Lordship. In appeal that I am seeking.
What is the plaint? Let's see.
Plaint is only that I have only sought for a declaration and permanent injunction. One is there was a will which is executed by my father.
No, you say that there is you wanted to declare that the will is not binding on you.
Please, another one is there was a partition which was entered by me and the defendant and my father by partitioning the property which was
Have
ancestral.
a copy of the plaint.
Please, Your Lordship.
Please pass on. Take that.
Certified copy. So I was in the position and seeking a court to put me in a proper position as per the partition deed.
Oh, when you say that you're seeking a relief that you're the absolute owner, there is a question of partition now.
The main thing is it was an
You're
unregistered part.
introducing altogether a
It
new
was an
case.
unregistered partition between me and my brother and the father. I was put in a position and I was enjoying the position. By violating the particular partition it happened between me and my brothers, my father has executed a bill in the year of 1991. And please.
It is very clear. Number one is to say that that is invalid.
Please.
Number two, that you are the absolute owner of the property.
Please.
That's a declaration you sought.
Please.
Suit was decreed.
Please.
Now you are in appeal. Now you say that it is a joint family property and give me, please partition the property.
There was a
Inconsistent,
suggestion.
please.
There was a suggestion made by the opposite parties in the cross-examination by putting.
Come to the order now.
Please, Lordship. 58 to 60, please, Lordship.
50.
58, page number 58, and the 60 main portion is 60, please, Lordship. The court has rejected my application only on the basis of that I couldn't sought the same relief before the trial court. That's the only ground. For that purpose, Your Lordship, this honorable court has clearly passed a
No,
judgment.
it is
Please,
altogether
please,
a
please.
different plea I am saying.
In the same ground set of facts.
No.
Please.
You say that you are the owner of the property.
Please. As for the unregistered partition, which was not considered by the trial court. Even when there is an admission in the said sale deed which was produced by the defendants that the property has been purchased.
This is altogether a different plea. How can it be permitted in the at the time in the appeal?
The one thing is nature of the suit doesn't change even if it include the pair of the partitions. The declaration of the
according to you, that is your own property.
ancestral property, which I.
No, you are the absolute owner of the property.
As for the unregistered partition deed,
Hmm.
which was not considered by the trial court because there was an execution of the will, registered will. The only court has considered execution.
Because now the will is going to be proved in the with that apprehension, or you will change the entire prayer itself.
No, my father doesn't have any rights to execute such kind of a will. As for the partition, unregistered part, I was put in the position, I was enjoying the property since 1982. Same was been disturbed in the year of 2006.
No, amendment will not be allowed basing on a question put forth in the cross examination.
My one more submission, please. It's an ancestral property. Even if the court doesn't consider the partition did happen between the parties, only consider the will, then there is a law which is obstacles to
What is the order, what is the judgment and decree of the trial court? Let's see.
trial court judgment has not been placed before this honorable court. Since that I'm challenging only the application.
No, we
to
have
seek
to
the-
understand in the light of your pleadings.
Please, Lordship, that I'll praise before this court.
This is
Kindly
matter.
have it on Monday, kindly. Please.
Next Monday.
Much hope.
Cell number 9. Devraju HV.
I appear for the petitioner.
I seek apology if there is a posture for an argument and final posture for judgment. In meantime, kindly be and an interim order.
I'm not convinced. Unless I convince it, I can't. Monday? Yes.
Cell number 8. Nischal S. 8 Nischal S.
You call some other matter. 8. Yes.
The plaintiff has filed this writ petition, please, Madam. Suit for partition before the trial court. An application filed under order 6-17 for amendment of the pleadings. It has come to be rejected and
Suit is of which year?
number 89.
Suit is of which year?
Suit is of the year 2009.
2009.
2009.
Suit is, original prayer is for partition.
Suit is for partition.
What is the present prayer you're seeking?
Present prayer is at the time of filing of the suit. I have not disclosed the document number and other particulars. I have sought for declaration that the gift deed dated 22/1/2005 and 19/5/2006 are invalid. But I have not mentioned anything with regard to document numbers because I was not aware of it. Secondly, the fifth defendant who has been arraigned hearing, she has sold some of the properties and there is an internal partition among their family members. And those documents I have learned later and I have implemented the purchases also in this suit.
That's already ordered.
Yes, please, madam.
That is already ordered.
That is already ordered. They have been implemented. They have also filed written statement. Now it is posed for cross-examination of PW1. And I have sought for amendment of pleadings wherein I intend to add the document numbers. And secondly, the document numbers
Yes,
wherein
let
the
us
fifth
read, let us read your affidavit.
application is at page number 59.
59.
59. The proposed amendment is at page number 61, please, madam. I sought for the document number, and the second deed is to declare the partition which is among the family members of defendant number 5. It is not binding on my share.
No, please come to the order.
The order is at page number 89, please, madam. 84. The operative portion is at page number, paragraph number 14 itself.
Let's read from paragraph number 11, internal page 5 of the order.
The plaintiff seeks amendment of the plain mainly to incorporate additional reliefs challenging certain partition deeds and sale deeds and also to introduce pleadings relating to the will dated 6/4/2010, which has been executed by my father. Said to have been executed by defendant number 1. The plaintiff contended that the proposed amendment is based on subsequent events and existing pleadings and the documents sought to be challenged are already produced and marked in evidence.
You can come to paragraph number 14.
14. In the present case, the sale deeds, gift deeds, and partition deeds sought to be challenged in the proposed amendment are of the year 2005, 2006, 2007, 2009, and 2012. These have come to my knowledge only after the filing written statement.
Let's read it.
The purchaser and some of the impugned transactions have already been implemented as parties to suit. The plaintiff has also produced and marked the relevant document during the course of evidence. Therefore, it cannot be said that the plaintiff had no knowledge of these transactions until the filing of the present application. No satisfactory explanation is forthcoming. This application is dismissed only for the reason that there was no due diligence and no sufficient cause has been shown. Please.
What is the present stage of the suit?
It is posed for cross-examination of PW1.
So the evidence is not yet started.
No, my evidence has commenced. It is posed for cross-examination by defendant number 5. She is the only contesting defendant.
No, everything has to go to the beginning. You have to frame the issues. Everything has to start. 2009 suit.
I have learnt of these documents only after the proposed defendants have come on record and they have filed the written statement.
And then the notice to the respondents.
My lord, notice to defend number 5, respond number 5, may kindly give. Only against respond number 5.
We will take notice only to respondent
Respond number 5. She is only.
The other respondents.
Other respondents are family members and some of them are purchasers. But they are not.
The number,
The
you have to
numbers.
file a memo to dispense with their notice.
Only notice to respond number 5 only. Respond number 6
Notice
only.
to
please.
respondent number 5.
Six,
Give a
six,
memo.
please. Yes, please.
A memo is filed, second dispensation of notice to so and so. Dispense with. If the memo is filed by 18th, list the matter on 19th.
Much.
Section number 9. P. Devaraj, petitioner.
That compensation matter, where not that with regard to the trees, now that plants which have been cut and removed. The horticulture report has been secured, compensation has been paid 6,38,931.
6 lakhs
38,931.
was earlier paid as per the
Paid.
DC's this thing.
Before filing that petition before the land district judge. Now the land district judge has taken so far as that the plants instead of plants has taken as an yield trees. Multiplied compensation has been awarded
What he has
15
done,
lakhs.
he has taken
Yield basis as a trees, the yield calculation and awarded compensation, enhanced compensation 8,61,569. The saying that there is no age mentioned, the horticulture report exhibit R9 specifically mentioned age 3 years, 4 years, 5 years.
He has taken the age as?
Age has not taken note as saying that there is no documents. Specifically when that we have marked horticulture report also exhibit R9.
Yes. Deposit some amount.
I'll deposit, not that.
Entire amount.
Not that 50% I'll deposit enhanced.
The land council for the petitioner submits that the court has enhanced the compensation without even considering the material on record. And when they have already filed, when they have already paid the amount for the trees, now that is enhanced to another amount, an enhanced amount of rupees 8,61,597 is granted.
569.
8,61,569.
569.
569 is granted. Considering the submission, there shall be stay of all further proceedings on the condition that he shall deposit 50% within a period of 4 weeks. Notice to the respondents
Before the land trial court I will deposit.
before the trial court.
Much.
Yes, next. Cell number 10, Chandrasekhar CM, petitioner.
Yes.
This is the defendant's petition merits. The petition, the plaintiff filed a suit for specific performance for execution of the sale deed in his favor by the defendant. Accordingly, some amount has been left with the defendant. At the time of the executing the sale deed, he should have paid the said amount, balance amount, and he has to come forward the said execution of sale deed matters. But he has issued the notice and all, he has taken the contention. And on receipt of the notice from the trial court, I entered appearance before the honorable trial court. And there is a delay in filing a return statement about beyond the 120 days, about 74 days in filing the return statement.
Suit is filed when?
Suit is filed by the plaintiff.
Year.
25. Sorry.
Which month?
Yes, ma'am. This is that I referred. Para number 6, ma'am.
You can tell the date.
Summons was received on 8/9/2025.
I'm asking when is the suit filed?
Suit for filed, date of filing.
Yes.
Yes. That was on 6/8/25.
After the amendment.
Yes, ma'am. And
So now how much is the delay?
74 days there is.
Please
And
come
in
to
the
the council.
similar circumstances, there is a stay by the
Counsel for the petitioner submits that the court has failed to take the written statement on record as it's filed with a delay of 74 days.
Yes.
It is submitted that a coordinate bench of this court had stayed the operation of the amended provision of CPC. Considering the same stay.
Please.
Notice to the respondents and summons and memo shall be filed by 4th of August or else the stay granted by this court stands vacated. Yes, 11.
Number 11.
Please.
Srinidhi P.
Suit for partition, my lordship. I am for the petitioner is the defendant number 5 in the court below, my lordship. Has filed application under section 150 and for recall and reopen of the filing of the return statement, my lordship. The written statement was not filed in time because the petitioner is
What is the delay?
It's a 4 years, 6 months delay, my lordship. Because he's suffering from chronic pancreatitis, my lordship, is not able to walk and all this. Continuously taken.
He was being represented by the advocate.
Yes, my lordship, but he is not able to give the instructions or.
Notice to the respondents. Petition is permitted to take court hand summons. The memo is filed by 24th of August.
6th is in trial court is for arguments, my lordship.
24th of August. The memo is filed. This is matter.
Otherwise, the repetition become infectious before 6th, my lordship.
Before?
Before 6th of next month, in it, my lordship.
This is the, if the memo is filed by 4th of August, this is the matter on 5th.
Cell number 12.
But this can't be allowed, 4.5 years. Contesting the matter and saying the written
certificate, my
statement.
lordship,
Even if not considering the amended provision, but prior to that also.
Have medical certificate, he is not able to walk also, my lordship.
No,
That
he
is the
doesn't
reason.
have to come to the court, isn't it?
To
He has
give the
he has an
instructions, I have
advocate
to
representing.
swear before the notary also. That is what the problem he has faced, my lordship.
And that the advocate can't ask the court, saying that this is a difficulty and at the earliest point of time.
But he is not able to instruct, my lordship.
But
That's
4 years' time is an inordinate delay. Yes.
Cell number 12, Satish TS.
I appear for the petitioners. Lords, the petitioner is the defendant number 2 and 3. Lords, the suit is for declaration and mandatory injunction. To set aside this declaration so as to set aside the sale deed dated 15/2/2002, and the suit is filed in 2014. Lords, what happens is the defendant evidence.
So what is the IA now?
Yes.
What is the present IA?
Order 6 rule, Order 16 rule 1 and 2, summoning of documents. But what happened is, I am the defendant, I have said that my sale deeds has been mortgaged with Bajaj Finance Life Private Limited. And I have mortgaged it. All these documents have established my title and my possession of the property, suit scheduled property. I have constructed, I have been living from 2002, and the suit is filed in 2014. Notice the learned trial court, after completion of the defendant number 1 evidence on 23/3/2026, post a matter for on 27/3/2026 for arguments without considering my evidence. Then I file an application for recalling. Then I file this application saying that kindly summon these documents. Plus, the trial court, only considering the age of the suit, says that you have been dragging the matter. Hence, I am not allowing this.
Come to the order.
What's the order? Order is, I think, page 20 minutes. The only contention what the learned trial judge says that in the is that since it is an old suit, we cannot give.
How can you, 2014 suit, why should after the evidence, why you want?
No, my stage is not at all over. My evidence is not taken on record. The defendant number 1.
Evidence would have been marked much prior to this.
No, I have not marked. I have not stepped into the witness box. Because on defendant number 2, the evidence or plaintiff evidence is completed on 17/3/2023. He completes his evidence. Then cross-examination of PW1 is completed on 7/11/2025. And DW1 witness is concluded on 23/2026. And I am defendant number 2 and 3. Without even considering me stepping into the box, the learned trial judge posts the matter for arguments. Then I file a recalling application. That recalling application comes to be allowed on a cost of 2,000 rupees. I have stated in para number 14 minutes.
Order is not there before the court.
That portion of the order is not there before the solemn court because I have not challenged that. Because I have 2,000 rupees cost was needed, I paid it.
What are the, how the matter was going on from that order?
Yes, my lords. Notes para page 14, round X10. I've stated in the petition. Thereafter, my lords, I filed this application for summoning of original documents. My lords, a suit for declaration and injunction. My contention is that I have acquired the suit scheduled property in 15/2/2002 2 by virtue of a GPA
Certified
executed
copy
on.
of a registered sale deed dated 15/5/2002 is already produced and marked as exhibit.
Correct. But it is not a suit for injunction, it's a suit for declaration. My written statement, I say that I have acquired the title in by virtue of a general power of attorney executed executed in favor of defendant number 1 on 13/2/1997, basing on which a sale deed has been executed.
No, what is the
Subsequently,
purpose? What is the purpose
one
now?
minute, I'll just complete. Please, my lords, just bear with me for 1 minute. The title documents and the possession documents are mortgaged with the bank. This is suit for declaration of setting aside the sale deed and mandatory injunction to remove the construction and hand over the possession. My possession, my construction documents, my khata, my taxpayer receipts, my original title deeds, everything is been mortgaged with the Bajaj Finance Limited. I have asked to be summoned that documents. Without that, if this kind of order is passed, it is pronouncing the judgment against me.
No. The document is there before the court. Who is denying it about your registered sale deed?
Correct. It is not only the question of denying of the registered sale deed. There is a mandatory injunction. I have to prove my possession. I have to prove, I have to get marked how I have acquired the title. My GPA, original GPA has to be marked. Only sale deed, registered sale deed has been done. I have acquired the title through an unregistered sale deed coupled with consideration which was executed in 1997, and I have got the sale deed in 15/3/2002. The suit is filed in 2014. But if this is the case, and how do I establish my mandatory injunction? How do I establish my possession? How do I establish the GPA which has been executed in my favor if I don't mark that document?
Where is your written statement?
My lords, it is at ink page. Annexure D, page 45, my lords.
Let's look at it.
The plaint is at ink page 34.
No, we'll look at your written statement. That is
Yeah,
all.
please. I have also produced my evidence affidavit also. Kindly come to para 9, page 47. Or brief facts of the case in 46 para 5. It is submitted that Bangera farmed Bangera farmed the land owner of the agricultural land in survey number 2 and so and so and so situated in Algia Vaderelli. It is submitted that the late G. Verna farmed a private levy consisting of residential sites in the year so and so and so.
Then counsel for the petitioner submits that. When an application is filed under order 16 rule 1, 2, 3, 6 and 14 dead to 16 under section 151 CPC to summon the documents in the Bajaj Finance that came to be dismissed. It is submitted that though the sale deed dated certified copy of the sale deed dated 15/5/2002 is already produced and marked as exhibit, but the other particulars with regard to the GPA, the loan available by the defendant, and other particulars with regard to the construction are very much necessary for adjudication of the dispute, and that was not considered by the court. Considering it the same, there shall be stay of all further proceedings pursuant to the order dated so. Notice to the respondents and a memo shall be filed by 4th of August or else the stay granted by this court stands vacated.
Cell number 13.
Stay, madam.
Harish Jaykumar.
Stay up for the
Yes, sir.
I said stay.
Oh, oblige. I didn't hear it. Sorry, oblige.
Harish Jaykumar, a petitioner.
Manoj, this is a suit for partition of the year 2016. The petitioner is the plaintiff before the trial court. Manoj, prayer is at page number 23. A mandamus is sought for expeditious disposal with an outer limit
Of the year,
2016, Manoj.
which court is this?
For the JMFC Anikal, Manoj, civil judge and JMFC Anikal. Manoj, there are three principal grounds on which a mandamus is sought for expeditious disposal. First, my lords, is that the suit is in fact ripe right now for expeditious disposal. Why? Is because it is a straight contest between the plaintiff and the defendant number 17, who's the ultimate purchaser. No other defendant's release is not sought against any of the other defendants because all of them have successively transferred their interest to the defendant number 17. So either my rights in terms of it being a joint
It
family.
will not be the ground to consider a mandamus, to issue a mandamus.
There are other.
Mandamus is only one. One is that about the senior citizen.
Yes, this is a
Number
senior
two,
citizen.
number two, what is the pendency of that court?
Yes, my lords.
If the pendency of if there are old matters pending, that is, I mean, before 2016 any matters are pending, this court will not be granting a mandamus.
My lords, leads me to ground 2 and 3. Ground 2 is, my lords, that petitioner is a senior citizen. She's also having her health-related ailments. Notwithstanding that, ground number 3, my lords, is that the frequency of when the matter is called before the trial court as well, my lords, is highly, there's an inordinate delay in each adjournment that is granted. On average, my lords, the suit is called only 3 times a year. So virtually, my lords,
So that speaks about the pendency.
my lords, be that as it may, my lords, by the time that the suit, it's not even come for plaintiff evidence yet. My lords,
In that case, how can this court fix a time frame?
my lords, at least it
The
may be.
court will not hear any other matters and only have to concentrate on your.
I'm not asking for 3 months or 6 months. I'm saying within an outer limit of 1 year, I will cooperate. I will not take any adjournments, my lords.
But that is not what High Court is not supposed to do.
My lords, there's, in fact, can I just request if your lordships may take, there is a judgment, in fact, passed in respect of this. If I can just produce some citations.
Then I can also give you one citation, what the Supreme Court said.
My lords, I have produced a Supreme Court judgment
No,
that
there
Asian
is a judgment of
resurfacing.
the Supreme Court.
Correct, my lords. That
3-judge judgment.
this is 5-judge bench, my lord. They say they lay down the guidelines in terms of when matters may be disposed of expeditiously in rarest of rare circumstances. Moreover, judgment number 1 and 2, judgment number 2 is, my lords, a judgment by your lordships itself of disposing a matter of the year 2016 within 6 months time frame. Judgment number 1, my lords, references the Supreme Court judgment which are produced at serial number 3. There, my lords, what is taken into note of is the Karnataka Case Flow Management Rules 2005, which, my lords, sets various grades for various categories of suits, civil suits. And, my lords, it makes a.
CB proceedings of the year 2016, suit is not of the year 2016.
I see that, my lords.
Judgment which you place, because I'm very conscious in passing orders.
I understand.
And my orders are always uniform.
Yes, I understand.
So I can, even without looking at it, I can say why and how I have passed it.
I understand.
Yes.
So serial number 1, my lords, if your lordship takes.
Yes.
There, the rules that are referenced is the Karnataka Case Flow Management Rules 2005. My lords, that is one more ground which I'm advancing as well, wherein various grades are given to various categories of civil suits. As for suits for partition, after the service of summons, what it mandates is that from time period of 24 months.
These are all ideally how the thing should happen.
I understand.
But that idealistic picture is not how the proceedings are going on now.
Correct, my lords. Correct.
In family courts, the matters have to be. In commercial court, this is the pattern.
Yes.
That is an idealistic picture, which doesn't happen.
My lords,
And so we will not go to that. So come to the Supreme Court judgment.
My lords,
What did
Supreme
they
Court
say?
judgment, page number. My lords, page number 51.
Yes. Yes.
My lords, what they say is at para 33, there is another important reason for adopting the said approach. Not every litigant can easily afford to file proceedings in the constitutional courts. All of this, my lords, they say that do not pass orders for expeditious disposal. But in the end, what they say, my lords, is therefore the judges of the High Court should be allowed to set their priorities on a rational basis. Thus, as far as setting the outer limit is concerned, at the very end, it should be best left to the concerned courts unless there are very extraordinary circumstances. This, my lords, is interpreted positively, however. They say that.
This is precisely what I'm following.
Yes, my lords. In fact, why I plead that mine is in the rarest of rare, my lords, if your lordship may kindly take page number 19 of my writ petition, I have extracted a table. In the last 4 years, my lords, the matter is.
No, that's the same thing to all the cases, not your case alone.
My lords.
You have to understand that. Because of these kind of orders from the High Court, we're giving importance to everyone who come to the High Court and dispose of the matter. No, they are not able to deal with it. It's for them to manage their board. And I can understand, like, if you want, I can call for a report from the court. If there are any matters, I mean, the matters are pending before 2000, because in fact, I have called for the report from Anekal Court in respect, somebody else has filed a petition. There are so many matters which are much prior to this happening.
My lords, then could the matter be kept pending? Because my difficulty is this, my lords, I do not have any other legal heirs. I'm 62 years old right now. My lords, in my lifetime at least, I've not even started my evidence because all the other defendants are dying, and then I'm putting LR applications, and then because of that, my lord, 10 years, 3 times only the suit is called, my lords, in a year.
The present petition is filed seeking a mandamus to dispose of the look at the suit number, OS number so and so.
My lords, OS
The
number 309 of 2016.
2016, the, the, uh, the registry is right to call for a report from the concerned court. Yes,
Was, any date may be fixed, my lords.
this is a matter on 11th of August.
Because last date, in fact, before trial court was in February. Next date, my lords, is day after tomorrow in July. Next date, my lords, maybe next year. This is the way it is happening.
That's what, that must be the case in respect of all the cases.
Because I am ready, my lords. It is a straight contest. It is only between me and the defendant number 17.
Yes, yes, next part.
Yes, ma'am.
14, P. N. Harish.
No representation. Yes.
That a suit for partition suit has been decreed, and there is an FDP is also been allowed, and there is a internal bidding. There is that parties are exploring the internal bidding among the sharers. Milord, the court commissioner was appointed, and before that, Milord, there are some Kannada versions. Just pass on the translated. Some of the documents exhibit. The court commissioner was appointed, and he has given a report stating that the value of the properties were around 1,15,90,000. And the first respondent, who is the only person who is stating it, because rest of the sisters have already executed relinquishment deed in favor of the brothers. I have produced in the as per annexure E to E3. All the other sisters have executed relinquishment deed. This particular sister is not ready to settle the matter with us. Lord, she has filed a memo after the report been obtained that she is ready to purchase the property on the same rate, accepting the valuation given by the court commissioner. That is kindly said annexure B. I have produced the annexure B. It is the first respondent who has filed a memo. Then the matter went on for some other time, and there was some discussion. Then Milord,
That relinquishment deed is in your favor.
yes, I have produced it, except the decree holder.
No, she says that whatever relinquished, the others have relinquished, that share also she will purchase from you.
Milord, that may be
That
Milord.
is what is her case.
No, she is not saying that. She is saying that she is ready to purchase the property in the valuation that has been fixed by the court commissioner. He is accepting by accepting the valuation made by the court commissioner. She has. Now, kindly say page number 15, annexure B.
This is it,
No, not in that, in the original writ petition. That is in English. Petitioner submitted, just read. She is prepared to purchase the petition property at the rate assessed by the court commissioner, totally valuing the property at 1,15,90,000.
Yes.
Milord, then what has happened is I filed an application. Milord, kindly see in the execution petition that is filed in the FTP. After the completion of FTP, Milord, I filed an application in IA number 1. Milord, kindly see page number 20, annexure D. I filed an application saying that I am also ready to purchase the property. I will pay her portion of 15,90,900 because that is the value. See, 1/11th share she has got. I will deposit that amount. It may be closed. Then in that application, Milord, along with that application, Milord, kindly see page number 26, Milord. I have produced the relinquishment deed executed by other sisters in favor of.
Yes, yes, I have seen. Yes.
Yes. Then, Milord, what has happened is learned trial judge, Milord, all of a sudden, without giving any opportunity, any of the parties, suddenly raised the market value, that is the value of the property is 2,25 lakhs.
Where do you get that?
Milord, that is at page number 61, Milord. Minimum bid price is 2,25 lakhs. Without affording any opportunity to any of the parties. Because the learned trial judge refers some sub-registrar's notification on its own, which says that it is 32,000 rupees per
Please
square.
come.
Please.
The petition is agreed with the order dated 9/4/2026, whereby the court has fixed minimum bid price at rupees 2,25,000. It is submitted that when the advocate commissioner was appointed,
No, not advocate, he is a engineer.
the engineer, when the commissioner was appointed
Please.
to assess the value of the property, it was assessed at rupees 1 crore.
Milord, 1,15 lakhs 90,700. 1,15,90,700. Milord, page number 14.
No, just now we have seen her
That is page number 15, my lord.
Page number?
15, annexure B. That is the memo filed by the first respondent.
It is stated that she is ready to purchase the property as per as assessed by the commissioner, totally valuing it rupees 1,15,90,700 and deposit the 1,15,90,700. It is after, it is, and council submits that. Now, without any basis, the court has fixed the value at so and so.
2 crore
I've already
25
said
lakhs.
so. At so and so, considering the submission.
Lord, another issue is that the other sisters cannot be permitted to bid also.
Accordingly,
Please.
there shall be stay of all further proceeding. Pursuant to the order dated so and so. Yes.
Pleasure.
Yes.
15, Sudhindra SA.
I appeal for the petitioner.
Yes.
The petitioner is the second defendant in a suit for partition filed by respondents 1 to 6. Initial stage, the first defendant made an application IN number 15 for inclusion of certain properties as joint family properties. The plaintiff subjected that application, contending that they are not the joint family properties, therefore that application has to be dismissed. Again, in the evidence also, they admitted that these properties are not, we are not making any claim.
What happened to that application?
That application came to be dismissed. Then again, IA number 35, that application came to be dismissed in 2016. IA number 35, again, it is filed for inclusion of same properties by the plaintiff.
That is allowed.
That has been allowed.
What was the earlier IA?
Earlier, your lordship may kindly come to page 41. The application is filed to add the properties, and they have filed objections at page 46, annexure D. Second paragraph. The plaintiff respectfully submit that the properties mentioned by the defendant number 1 in the above application are all the properties not connected with the family of the plaintiffs and defendants.
This order is not questioned at page 47.
Yes, ma'am. This is not questioned.
This is dated?
This is dated 2/4/2016.
Where is the present application?
The present application is at,
Present order.
yes, page 87. Annexure K is the application. At page 87, IA number 35. So they have sought for inclusion of all these properties. And we have filed objections narrating the whole thing that in IA number 15, that has been dismissed on their objections, that they are not the joint family properties. What the learned judge says, even though they have filed the written objections, the trial court says that it was orally objected. Page 107, the relevant para,
Please.
para 8
When
at page
earlier,
108.
when I number, what was the I number you said? 25.
35.
Earlier.
Earlier 15.
Earlier, an application is filed to add certain properties as a joint family properties that came to be dismissed in the year 2016. Now, a similar application is filed by the respondents herein, and the court, the court, though earlier was dismissed, again has allowed the same application. It is submitted that such a course is not available to the court without when the earlier order has attained finality. Considering the same, there shall be stay of all further proceeding quotient. And someone's memo shall be filed by 4th. Yes.
Lord, I have sought for an interim order of stay
Stay
for
granted.
annexure. Please.
Number 16, Ali Shantappa.
That is 16. Yes.
That I am appearing for the petitioners, Mother. Petitioners are the dependent before the trial court, Mother. That respondent has filed the suit for bare injunction in the year of 2023, Mother. I produced the plain copy, Mother, annexure A, Mother. What had happened was that in the year of
IA.
IA for seeking amendment of the plaint was that. They are seeking a declaratory relief. The court must not go into merits of the case. No prejudice will be caused to the defendant if this application is allowed. On other
Where
hand,
is the affidavit?
please, ma-
Affidavit in support of the IA?
please, mother, your lordship may kindly see that 33, mother, page 33, mother, in para 4, mother. There is no, in the absence of due diligence, mother. I submit that dependent entered into appearance and filed the written statement on 10/1/2024. I am the advised to submit that in the of the plaint averments and allegations made in the dependent in the written statement. It is now become just and necessary to amend the plaint.
Yes.
This is that stated in the affidavit, mother. What had happened, mother, in the year of 2018, this respondent has and he has admitted the registered sale deed, mother. And he filed the suit for bare injunction in the year of 2023 after lapse of 5 years for the execution of the sale deed, mother. Now, without any due diligence, mother, he made an application, repeated all the paras of the unamended plaint, mother. Your lordship may kindly see in prayer of the amended plaint, mother. Amended application, your lordship may kindly see that so far as the prayer is concerned, mother. To declare,
Page number?
page 32, your lordship may kindly see, mother.
Yes.
To declare that alleged registered sale deed dated 19/11/2018 executed by the first dependent in favor of the second dependent, mother. The prayer is also an ambiguity, mother. What they are seeking, mother, to declare that alleged registered sale deed dated 19/11/2018 executed by the first dependent in favor of the second dependent, which is registered so and so before the sub register Lagere, Bangalore. It is not binding on the plaintiff. That the plaintiff himself has executed this registered sale deed in favor of the petition number 1, mother. They are seeking relief that first dependent executed the sale deed in favor of the second dependent.
How can it be?
That is the prayer sought by the plaintiff before in the amended plaint, mother.
Basing on what you are saying that the plaintiff has executed the sale.
I produced the sale deed, mother. Your lordship kindly see, mother. At Annexure G, page 63, mother. That Chris, the 19/11/2018 is page 63, mother. 19/11/2000 Bangalore, Srigandhada Kavalu, Annapurneshwari.
Chandrasekhar Rao is the respondent here.
Please, mother.
Where is his name found?
That in plaint para, your lordship may kindly see.
Not plaint, the 63 document.
63 document, your lordship may kindly see. That second para, mother. Srigandhada Kavalu, so and so, Chandrasekhar Rao, Maganada Sumaru, 45 years age, Praveen Chandrasekhar Rao. Who is the respondent present, mother?
Please come.
ನಾನು ಒಬ್ಬ ಬರೆಕೊಟ್ಟ
Counsel for the petition submits that the The plaintiff has filed an application under 6 Rule 17, seeking amendment of the plaint, whereby he wanted to insert a prayer that the suit is filed for the relief of declaration that the sale deed executed by the defendant number one in favor of defendant number two is bad. It is submitted that the said sale deed is executed by defendant number executed by the plaintiff himself.
In
and
favor
this
of the
aspect
defendant number
In
one.
favor of defendant number
One more that. Margavi, depend number petitioner here in ma, petition number one here in mother.
in favor of plaintiff in favor of defendant number one.
One.
Plaintiff in favor of defendant number one, but not defendant number one in favor of defendant number two. And all the aspects were not considered by the court, since there shall be stay of all further proceeding. Pursuant to the
And now
order
on 17/7 mal that without permission of the
and
court, they-
summons in memo shall be filed by 4th of August or else a stay granted by this court. Stands vacated. Yes.
Chair
Please,
number 17, Pawan Kumar G for petitioner.
Petition, my lord.
Yes.
Lord, application under 1 Rule 10 is rejected in a final degree proceedings. My lord, the first respondent filed suit for partition against the second and the third respondent. Suit was decreed. Final degree proceeding was initiated. I am the purchaser before the filing of the suit. Your Lordship may kindly come to. Lord, what happened here is basically
You are the purchaser.
I am the purchaser.
When did you purchase the property?
I purchased the property in 9/7/2015.
9/7?
2015. 2018 is the suit. Well, what happens here is
You purchased from which defendant?
defendant number, respondent number 3. Respondent number 2, my lord, sorry.
And you filed it in FDB proceedings?
Yes, please. 1 Rule 10 is rejected in final degree proceedings.
Suit is of the year.
Suit is of the,
You purchase the property after the suit is disposed.
before even filing of the suit.
Now this FTP of 2018,
I purchased in 2015.
suit is of the year?
Suit 300 of 2018. 2015, sorry. 300 of 2015, my apologies.
So suit is of the year 2015. And during the pendency of the suit you purchased?
No. Before this thing.
2000, your...
I sale date is 9/7/2015. Suit was decreed on 31/10/2017. Suit was filed in 2015.
When? That's what I've asked. Have you purchased a property?
Well,
after
suit was
filing the
filed
suit?
on 28/10/2015.
Hmm.
Suit was decreed on 31/1/2017. I purchased a property on 9/7/2015.
No, let's have the...
Please, madam.
The suit was filed on?
Suit was filed on 28/10/2015.
Hmm.
I purchased a property on 9/7/2015.
9/7/2015.
Suit was decreed on 31/1/2017.
13/1.
1/2017. 31st January 2017.
Hmm.
In fact, I had filed a injunction suit. I obtained an injunction on 8/1/2018. Lordship, may kindly come to the synopsis in order to be more easier. What happened is here, basically there was partition between the family members of the respondent, including the respondent. This property was allotted to third respondent in the partition. Thereafter, the third respondent executed a gift deed in favor of the second respondent. Second respondent sells the property to me. Thereafter, these three respondents initiate partition suit, obtains respondent number 213 remains ex parte. First partition suit is decreed, then they initiate final degree proceedings. In the final degree proceedings, now the stage is for commissioner report. I file an application of 1 Rule 10, it is rejected.
Come to the...
Your Lordship may come to page 13 onwards, my lord. It simply says, I cannot disturb the final degree. This is the basic finding of the trial court.
So what is to be done according to you?
The FDP proceeding, in the FDP proceedings, equities can be worked out. Whatever share that should be allotted to the respondent and 2 and 3 may be allotted
What
to
is
me.
the case of your vendor?
My vendor ex parte, they are placed ex parte here, there, both places.
Check out notice. Notice to the respondents.
No, interim, my lord. The reason is this, my lord. Commissioner report is there. in
Notice to
place.
the respondents. It is submitted that the petitioner has purchased the property even before the suit is filed and the court ought to have, ought to have allowed the application. Now the matter is posted for the commissioner's report. They submitted that commissioner's report considering the same. There shall be stay of all further proceeding pursuant to the order dated so and so. Notice and hand summons. Memo shall be filed by 4th.
Respondent 2 and 3 hand summons, they are placed ex parte, my lord. As respondent 1 hand summons.
File a memo. It's a memo is filed seeking dispensation of notice.
Respondent 2 and 3.
2 and 3. Give it to the court.
Please.
Cell number
And
18.
notice to the remaining.
18, Shokumar Appa TC for petitioner.
Yes.
Suit for partition. Petitioner is dependent number 2. Filed application under Order 6, Rule 16 for strike out some scheduled property. For the reason the scheduled properties are self-acquired properties of the dependent number 2. Kindly see in page number 41.
Come to the order.
Page number 41, para number 8. Translation copy.
Yes.
The applicant further said that during his lifetime, dependent number 1 gave item number 1 property to him by a registered gift deed dated 12/3/15, which dependent number 2 accepted and Kata was changed accordingly. This property was acquired by KADB, which declared compensation was received by the dependent number 2. Dependent number 1 executed a gift deed for item number 2 on 19/6/15, which dependent number 2 accepted with the Kata changed to his name. Dependent number 1 executed a will bequeathing item number 4 to dependent number 2 on 6/1/2020, and after dependent number 1 is death.
No, by application and order 6, rule 16, you say that these properties have to be.
Self-acquired properties.
Yes.
In para number 14 reason.
How the court can decide all that? Please come. Agreed with the order. Passed in. I number 13. Dated 12 June 2026 by the invoice number 45 of 2016 by the JMFC Heriur. The petitioner defendant is before this court. The respondent herein has a filed suit for partition. Has filed a suit for partition. In that an application is filed. I number 13 is filed under order 6 rule 16, that is section 151 CPC. That the suit schedule item number 1, 2, 4 and 5 be struck off as they are not the joint family properties that came to be dismissed by order impugned. While dismissing the application, the court has observed that under order 6 rule 17, under order 6 rule 16 of the CPC, the court may at any stage of the proceeding order that any matter which is unnecessary, scandalous, frivolous or vexatious or which may tend to prejudice, embarrass or delay at fair trial of the suit or is otherwise an abuse of the process of the court is struck out or amended. In this suit, the plaintiff has taken the stand that the suit property is an ancestral property, determining whether the suit property is the self-acquired property of defendant number 1 to 4 and whether item number 5 is purchased from joint family funds or defendant number 2's own earnings requires evidence. The court has already framed issues on all these points and the suit has been posted for trial. And the court felt that
PW1.
this application cannot be allowed. Then counsel for the petitioner submits that when the petitioner has physically filed a petition under order 6 rule 16 stating that these properties are the self-acquired properties, then they cannot be properties and they cannot be partitioned and they can't be part of the suit. And the court has failed to consider the same and dismiss the application. Hence, he is before this court. This court, having further counsel for the petitioner, peruse the material on record. The order of the court is very clear on the application of order 6 rules 16 and how this application is not permissible. This court, trial court has rightly said that it's a matter of trial and at this stage that cannot be considered and this court finds no reasons to interfere. Accordingly dismissed.
Cell number 19.
Arvind Patil B, for petitioner.
Lords, no order is challenged in this proceedings. The petitioner was the sixth defendant in a suit. He was placed ex parte, and the suit for partition is decreed. Lords, there is a registered partition deed of 1974 to which the plaintiff is also a party. And the plaintiff says that this partition deed was executed by his mother, and the distribution of shares is not
Going
proper.
into all that, why should we call for the records?
No,
Miscellaneous
my lords,
number of-
when I am asking for a mandamus, that I want the expeditious disposal, that prayer is a very lords, redundant prayer. I understand it's a mistake on our part, that we should not, because if I am asking for mandamus, I can ask the records to be brought before.
And,
But can I just persuade this, my lords? If your lords is to have this matter on Tuesday, I just wanted to canvass one point. Lords, the parties to the proceedings, of course, the sixth defendant was impeded later, he is placed ex parte without service of notice is one aspect. But the primary question is, if once there is a registered partition deed of 1974 to which all of them are parties, lords, they collude amongst each other and say that this partition of 1974 in fact did not affect partition of the properties. I am a purchaser of the property. Now the property which is sold in my favor pursuant to the registered partition of deed of 1974 is sought to be deprived. Now they are partitioning the property in the final decree proceedings when my miscellaneous is pending. That's, I just wanted to file that partition deed, not just to indicate.
But even then, why will this court interfere?
Not the reason why I am submitting
And
is that
FDP proceedings, we have to find
there
out
is-
from the court. Ultimately, only relief that I can look into is the mandamus. Even for mandamus also,
yes,
this is an FDP of 2021. And is it the only FDP of 2021 that is pending?
No, no,
or
I am
much-
not seeking for, my lords, if your lords is for to see, mandamus is not requested in respect of the final decree proceedings. It is in respect of the miscellaneous petition, prayer B.
And when was it filed?
Lords, 2021, my lords. Now, the matter is being adjourned on technical or flimsy grounds. The application is not considered on merits despite the lapse of 5 years. Lords, one of the view taken by a coordinate bench of this honorable court is that the miscellaneous proceedings wherever it is filed in respect of partition suits requires to be considered expeditiously. Because the rights of the parties ex parte decided, my lords, cannot be, these are all partition suits. There is no question of any finality to the litigation unless
An
rightly
FDP
decided.
of 2013.
Yes. Lords, 2011, the decree is drawn. The preliminary decree is passed. The plaintiff and the defendants collude with each other in getting getting a decree. And during the pendence of the suit, I am the purchaser from one of the defendants. Defendant does not disclose the fact that the property is sold, etc. So Tuesday, my lords, I just filed that partition deed.
No, I'll ask the court to decide this application. This is 2013. It's only a miscellaneous application.
Please, my lords, if it could be decided within 4 weeks, my lords.
The writ petition is filed, seeking the following relief. As far as the relief number 1 is concerned, before that, Land Senior Counsel has argued in the merits of the matter and how the property is purchased by the petitioner here and suppressing those facts, how they are proceeding in the final decree proceedings. This court is not inclined to go into all those aspects. As far as for the prayer number A is concerned, they cannot be, this court cannot pass any orders. Prayer number B, considering the fact that FTP is of the year 2013.
2021, my lords. My lords, miscellaneous is of the year 2000. Sorry, my lords, I'm sorry.
FDP is of the year 2013 and the miscellaneous is filed in the year 2021. Considering the fact that this miscellaneous is in FDP of 2013 and is pending from 2021, the court is directed to hear the matter expeditiously.
Some time frame could be fixed, my lords. Otherwise, can I just make this request, my lords? If both the matters could be taken up together, miscellaneous and final decree proceedings, if both are taken up together.
No, because we have to find out what is happening. And
Produce the entire order sheet,
how
please.
much time it takes to decide these matters. It's not so simple to dispose it off within 2
Lords,
weeks.
miscellaneous is concerned, my lords. Miscellaneous is only for me to demonstrate whether I was served or not
No,
served
once
with
you
the
pass an
notice.
expeditious, they'll consider it. Expeditious order, yes.
Lords.
Number 20, DL Suresh for petitioner.
Petitioner.
Yes.
Petitioners, the defendant may not, respondent has filed the suit for declaration and other reliefs
petitioner filed an application seeking permission to file written statement. My application has been dismissed, my lord.
Suit is of which year, 2025?
Suit is of the year
When the suit
2000,
was filed?
4th of April 2025, my lord.
4th of April.
April 2025.
On what ground now it is dismissed?
My lord, because IF4 has been dismissed, so IFI has been dismissed. This is IFI, my lord.
IF4 is what?
IF4 was also dismissed, my lord, seeking, we have filed an application to permit us to appear and contest the matter through power of attorney holder. That application came to be dismissed, IA number 4. So as IF4 has been dismissed, IFI has
How
been.
can it be? This is an independent application.
Yes, my lord, this is the order, my lord. I have already, but the IF4 which was filed by the Learned Council for defendant seeking permission to the new SPA holder.
Because that is filed by the SPA holder.
Yes, my lord.
Then where is that question, IA number 5?
I have filed a separate writ petition, my lord.
We'll hear along with that, along with
My lord, the interim stay, my lord, because trial court.
No, that is correct what the court said, list along with so and so on 30th. Which in the first list?
21. Chandan P. Somana.
Was the impugned order, annexure A is at page number 19. Filed a suit for partition, my lord, concerning 3 acres of land. I filed a suit for partition concerning 3 acres of land. I've also filed an application seeking ex parte temporary injunction. My application is not adjudicated. Some suit summons has been issued without adjudication.
Where is that?
Impugned order is at 19.
Yes, please come. Then counsel for the petitioner submits that the petitioner has filed a suit for
Injunction, sorry, partition.
suit for partition. In that, an application 9 number 1 is filed seeking ad interim injunction. The court, without considering the same, has issued suit summons to the defendants, returnable by 4/8/2026. It is submitted that when an application is filed an application seeking injunction, the court has to consider the same independently, and the court ought not to have issued the suit summons. He has relied on a judgment of the coordinate bench of this court and so and so. Considering the same, considering the submission of the Land Council and the judgment of the coordinate bench, this court is passing the following order. The writ petition disposed of directing the trial court to consider IA number 1 within a period of 1 week from the date of receipt of the copy of the order, notwithstanding the fact that the suit summons are not served on the defendants.
Until disposal of the IA status quo may be granted.
That I'll not grant.
22. Rakshita DJ.
For the petitioner in this matter, petitioner is the plaintiff before the trial court. Suit is one for recovery of sum of rupees 1 crore 24 lakhs and odd, my lord. What has happened initially, my lord, it is a commercial suit. In the first instance, my lord, my suit was dismissed. The defendants were placed ex parte. I challenged this before this honorable court, my lord, in commercial appeal. The appeal was allowed. And in the said appeal, my lord, the matter was remitted back to the commercial court, and also the defendants were provided an opportunity to file the written statement on or before 3/11/2025. Subsequently, my lord, written statement is filed by the defendants. In the written statement, my lord, the main defense contention taken up is my lord, the facts of the case is that there was a tender called for by the defendants for construction of a farmhouse.
So what is the instant IA now?
My lord, instant IA is filed for production of additional documents. This document, my lord, is in counter to the defense set up by the defendants that 2016 itself transactions have been completed between the
Are you permitted to produce the documents?
My application is rejected, my lord. The reason why I'm producing these documents is 2018, the defendant themselves have made payment.
So what is the law on that? In a commercial,
Please, my lord. In a commercial suit, I'm aware that at the time of filing of the suit, all the documents which are in possession of the plaintiffs have to be. But my lord, order 11, rule 1C, my lord, when any documents are sought to be produced in counter to the defense set up by the defendants, in such cases, my lord, if just causes show.
Law.
Please, my lord.
Law on that.
My lord, annexure G, page 56, my lord, decisions of the coordinate bench have been placed. 6, my lord. There are 2 decisions I've placed. Please, in this para 7 onwards, my lord. Even here, my lord, the application was allowed. That was challenged by the defendants. Para 7 onwards, if I may read out from page 61.
Please come. Land counsel, the petitioner submits that when an application is filed to produce certain documents that came to be dismissed by the court, it is submitted, she relies on an order passed by a coordinate bench of this court. In WP number 10679 of 2025, in case of Mrs. JSM Corporation Private Limited and Mrs. Brunton Developers and others, and submits that the court has observed that in case in the written statement and the cross-examination, certain factors are brought out by the defendants with regard to the court has observed that
Page 20 onwards is the reasoning in the impugned order. Page 19 onwards.
it's observed that though the court was answering an application the court has observed that Order 11, Rule 1C2 of CPC permits production of documents by the plaintiff in answer to the case set up by the defendant, which ostensibly will be after filing of the plaint. Considering the same, they should see of all further proceedings pursuant to so and so, and summons notice, fourth.
Cell number
Grateful, my lord.
23, Sandesh G.
My lord, the first respondent has filed the
My lord,
two suits.
yesterday only I received the copy, my lord. So I seek 1 week time to file an objection.
Where is
In the
have you
meantime-
filed the caveat?
My lord?
Have you filed the caveat?
No, my lord, they just serve the copy, my lord.
No, we have not served that, my lord.
Why they will serve the copy?
No, serial number 23.
23.
Now it's.
Yes.
Yes, ma'am. My lord, first respondent has filed the two suits. One is OS number 692 of 2016.
What is the impugned IA?
Impugned IA is the amendment application filed by the plaintiff seeking amendment to seeking to declaration relief to alternative relief for partition. They have filed the two suits, my lord, OS 692 of 2016 before the senior civil judge Devanalli, seeking the relief of the declaration by virtue of the will dated 23/5/1987, my lord. Another suit OS about 533 of 6 of 16 was filed before the city civil judge for the relief of partition, my lord. Two suits have been filed. Now, these subsequently, the first respondent has filed the transfer petition before the Samama court in CP number 402 of 2022. Both suits have been clubbed together. Subsequently, he filed the application seeking amendment in respect of OS number 692 of 2016, which was pending for declaration suit, seeking alternative relief. In the event he has not succeeded in the proving the will, he is entitled for partition. In the event of he is not proving the will, he is entitled for partition.
Come to the impugned order.
IA number, page number 52, annexure E.
No, come to the order.
Please, my lord. The trial court, without application of the judicial mind, my lord, given findings that is page number 66, my lord, para 2. The defendant number 3 to 6 filed objections wherein taken condition that will is executed.
No, we'll read from
Page number 66, my lord, IA number 2.
Para 8 we'll read. Para 8 of the order, page
Please,
67.
please, madam. I have carefully perused the pleadings and proposed amendment. The plaintiff has taken contention that will dated 23/5/1987 is executed in favor of his father, Gopalakrishna, who himself taken contention that he is unable to prove the execution of the will. For this reason, he is seeking for his 1/3 share in the property. In their application, he is not saying that the lord he is unable to prove. Next para, my lord, the plaintiff has filed this suit for declaration of his title over the suit property based on the will. Now he has taken contention that he is unable to prove the will. In such circumstances, to ascertain the rights of the parties, the proposed amendment is necessary. Any inconvenience caused to the other side can be compensated in terms of money. That is the reasons given by the trial court.
Please come. In a suit which is filed seeking the relief of declaration that the will, in the light of the will dated 23/5/1987, is the owner of the property.
Yes, madam.
That he has acquired title to the property. And during the pendency of the suit, now he files an application seeking partition in the property. It is submitted that is by virtue of this amendment, he is setting up a new case. What is the stage now?
The stage is now for the, after transposing the said petition suit, my lord, now this, the pendency for other applications for consideration.
No, before that.
Before that, after trial, my lord, when the matter set down for cross-examination of PW1.
Set down for cross-examination, this application came to be filed. Considering the submission, there shall be stay of all further proceeding. Notice same fourth.
Case number 4, Kalpana PV. Kalpana PV for petitioner.
For representation in the month of September.
Case number 25, Sampath A.
Petitioners.
Yes.
For the respondent.
What's the
KNC
petition?
undertakes the wakalat for the respondent, my lords.
No, you have not filed the wakala, filed the caveat. We have to hear him.
What's the against
Sorry,
temporary
my lords.
injunction?
Kindly have it tomorrow.
You are not even on record. Why should we adjourn the matter? We'll hear it. It's a case for preliminary hearing. Yes.
What's the
Yes.
plaintiff's writ petition
Mm.
against temporary injunction order? Initial ex parte injunction was granted. After their appearance it was rejected and confirmed by the first appellate court in MA.
Let's read that order in the MA.
I'll just little facts because that may necessary. Let's say, the constructions, the respondent defendant is putting up a construction. We have no objection.
What is the suit for?
The suit for a declaration to declare that he has to leave a 3 feet passage, 3 feet setbacks. And so he should not construct over 3 feet setbacks. That is my declaration so that I can have my access. And he should not put any construction on that. It's my injunction and the declaration. Declaration to declare that he has no right to put up construction abutting to my property without leaving any setback, 3 feet setback. I also say let them not interfere with that 3 feet setback portion is my content. I enclose the photographs, Annexure K, page 94 is the constructions. Page 94. The construction is done, is carrying.
Which is your property?
It's the property which Lordship sees that staircase attached to the wall, it is my property.
Wall is your property.
Wall is my property, it's my house. I am requesting him to leave some 3 feet setbacks, put up construction. He is not doing so. He placed the reliance on one agreement. Initially, there was a dispute between my father and their family members. The suit was compromised, with an agreement. Which was agreement is to say that I have to construct a joint wall separating my property and his property, leaving 3 feet setbacks. After that property, he can use that wall and he can put up construction. But that was done. After this old building was demolished, he has also demolished the wall also. In the understanding that he will again put up the wall, which will divide our properties. No, he is not putting up he has not constructed a wall. He started constructing the staircase himself. That is my grievance. Let him leave some 3 feet setbacks and put up the construction. So that.
Come to the order of the appellate court.
It's the other order of the appellate court. The order starts at page 16. Annexure relevant at page 29.
Para 15.
15, the relevant law that they are contained, relevant observations finds at page 29.
Let's read it.
Please, ma'am. The copies of the plain return statement.
No, in view of the above, this court carefully perused the material. In 27.
Please, ma'am. In view of the above, this court carefully perused the materials available as rightly observed by the learned trial court at para 9 of the impugned order. It is undisputed fact that the plaintiff is the absolute owner in possession of the plain scheduled property and defendant is an absolute owner in possession of the written statement scheduled property. Further, it is not disputed that towards the western side of the suit scheduled property, the property of the defendant is in existence. It is further undisputed fact that the defendant is putting up construction house in his written statement scheduled property. The real controversy.
Oh, you have constructed in your entire property.
Please, my property is fully constructed.
Oh, you will construct, you will not leave any setbacks.
We left and there was a compound wall dividing our properties. While his old building was demolished, he also demolished that old compound wall also with an understanding. Again, the compound wall will be
Is
built.
it your case?
Please, Mullah.
That whatever the 3 feet that he has to leave,
Please,
is it his property or your?
So it was on the some extent is of my property and also his property. Both, I also have my property because in earlier suit that was the understanding. I left some space and put up a joint wall on my
So
construction.
out of the 3 feet, how much is your property? What
It's
is
out
your-
of my 3 feet.
What is your case? Let us see your pleading.
Please, Mullah.
Come to the plaint. Where is the plaint?
My lords, the plaint lordship filed at
How
annex.
you complete your construction, you will complete in the
Lords,
entire
mine is old
extent.
constructions.
And other person should leave the 3 feet passage
My lords, I
or
left.
setback.
My lords, I left 3 feet and I constructed. My lord, I was also construct joint wall as per the earlier
No,
understanding.
it looks like you have a full compound wall on
My lords,
that.
that is my wall, my lord. That is a house wall, my lords. That's a building wall. That's not a
Let's-
joint wall. My lords.
Let's see, you're pleading, where did you say so?
Please, my lord. Lord, this is one fact I also need to make the lordships regarding this earlier arrangement of all those things, my lord, was not within this knowledge of the son. That's the one, my lord, the Learned Trial Court held that the agreement was.
We'll look at your
Please,
pleadings and we'll understand what it is. Come to the plaint, page number
please, my lord, plaint at annexure D, page 58.
58.
58, my lord, it's the plaint.
Let's see, what did you say about this passage?
Please, my lord. Para 6, my lord.
Yes.
Para 5, my lord, the construction stage. Para 5, it is submitted during the lifetime of plaintiff's father, M.K. Ramagupta. The father had constructed a commercial residential building on the suit schedule property about 25 years back. Since then, the family members of the plaintiff and plaintiff were enjoying the suit schedule property. After the partition, plaintiff is enjoying the suit schedule. Toward the western side of the suit schedule property, the defendant is having a old tiled roof house which is now demolished without obtaining any permission from the town planning panchayat. Now the defendant proposed to construct new RCC house on their property without leaving any setback on the western part of the suit schedule property of the plaintiff. To the knowledge of plaintiff, the defendant is not obtained any building license.
No, the
and
thing is, he has already constructed.
he's only staircase has to be demolished. I don't want his construction house to.
Oh, that not at this stage.
No, Muller, he has also
No, what
started.
is the reason that that is ultimately your prayer?
Please, Muller.
We can understand he has not constructed and the court should stop.
Muller,
He has
court had
already
stopped.
constructed.
No, yes, court had stopped with the interim order. Muller. He has also stopped.
No, after that, now you're filing the photographs to show.
No,
That
Muller.
will be removed. That
Only
will be
staircase
image-
portion. Only staircase.
God, that
Please.
is not at the interlocutory stage.
Lords, initially, Muller, that was stopped. Muller. No, I only request Muller, the staircase portion. Leave some space so that Muller, the water, if the rain comes, Muller, water should not log in my property. Muller, seepage issues. That's the only grievance. Let him, Muller, have construction fully. Let him not disturb that portion. Only my undertaking may be noted, Muller. Only 3 portions. Muller,
What
like 3 feet.
undertaking to be noted?
That I let him have the construction of his property without plan or anything. I will not
He's
disturb.
already done. Whatever is abutting your house, he already completed the construction.
Not fully,
Now,
Muller.
you sought for mandatory injunction also.
Plus, that is the reason, Muller, the suit itself will goes again. I should seek a mandatory injunction. But even divorce of that, Muller.
But he has done it now.
Please,
You
Muller.
have to seek it now. Seek the amendment then.
Muller, the staircase is still yet to be completed. Muller. That's other portions he has done.
Photograph shows that as far as your building is concerned, abutting that they have done it already.
They have done it. Only staircase because they have done the house portions, Muller. The
Yes,
staircase
now
portion
come
is
to the understood, come to the finding of the court.
That's final. Sorry, Muller.
We'll go to the findings.
Findings, Muller. The court, first appellate court's Muller at page 34.
23, that's what
20,
is the
on the
relevant-
contrary, material placed on record disclosed that the defendant has already commenced the construction and invested substantial amounts towards the same. Granting an order of temporary injunction at this would cause great hardship and prejudice to the defendant that its refusal would cause to the plaintiff the balance of convenience. And Muller, I pressed into service, there is no building plan and other things.
That is, you have a remedy.
Well,
And you have
that-
not made the municipal authorities.
Muller,
so not-
Muller's municipal authority, I gave a complaint and also seeking mandamus.
File a writ petition.
Because that time filed it, Muller, but this.
Yeah.
Plus only these portions of 3 feet, Muller, let me be observed.
That you will, once you succeed in the suit, then you will have the relief. Please come.
And one observation may just request. This may not come in the way of my writ petition already filed against the municipal authority. That could be observed. That's.
My lords, kindly have it on tomorrow, my lords. The
You
wakalat
have no
being
say
discussed.
now. I have not filed any caveat. I'm
Sorry, my
disposing it off.
It was informed by the telephonically, my lords. It was
Why is he informing you telephonically without a
by the
notice?
respondent, my lords. Senior is out of
That's not a
station. Kindly
ground.
have it tomorrow, my
No,
lords.
no. You have no role now before ordering notice also. Yes. The
Kindly have it on tomorrow, my lords.
petitioner, I said you have no role. The petition is filed. Questioning an order passed in MA number 2 of 2026 by the JMFC at Turuvekere. Dated What is the date of the order in
It's the
MA?
date 10/7/2026, my lord. See the-
10/7/2026, whereby the court has confirmed the orders passed on I number 1 in OS number 235/2025 dated 26/2026 by the civil judge and JMSC at Turukere. The suit, the petitioner before this court is the plaintiff in the suit. He has filed OS number 235/2025 seeking the relief of declaration that the plaintiff has got right of easement by necessity on the western side of the scheduled property of the plaintiff, and also for consequential relief of permanent injunction against the defendant, restraining him and his men or anybody else from interfering with the scheduled property of the plaintiff and causing any damage to the property. Initially in the suit, an order of injunction was granted. It is a case of the defendant that the plaintiff that the defendant, without leaving the setback of 3 feet or proceeding with the construction. After the defendant has entered appearance, the trial court has vacated the interim injunction. Yeah, and that was carried in appeal. And the appellate court has also affirmed the findings of the trial court. While dismissing the appeal, the court has observed that the material placed on record discloses that the defendant has already commenced the construction and has invested substantial amounts towards the same. Granting an order of temporary injunction at this state would cause greater hardship and prejudice to the defendant than its refusal would cause to the plaintiff. And the court felt that the balance of convenience therefore does not lie in favor of the plaintiff. It is also observed by the court that if the construction is in violation of the provisions of the Town Municipal Act or the building bylaws, it is for the competent municipal authority to initiate appropriate proceedings in accordance with law. Such alleged statutory violations do not automatically create a civil right in favor of the plaintiff to restrain the defendant from raising construction in his own property. Next para. When counsel appearing for the petitioner submits that the petitioner has proceeded with the construction and he has placed the photographs to show that the constructions are made without leaving the setbacks. It is a case that the petitioner has already approached the municipal authorities and no action has been taken. If it is submitted that if the construction continues and is permitted to proceed with the construction, that the property of the petitioner will be damaged. And in those circumstances, the court ought to have granted an order of injunction. It is submitted that both the trial court and the appellate court has failed to consider the submission of the contentions raised on behalf of the petitioner and its proper perspective. Next, having heard the counsel for the petitioner, there is the material on record. According to the petitioner, the defendant is making construction without leaving the setbacks. The appellate court has observed that if the defendant is making the construction without leaving the setbacks, you should have approached the concerned local authority and he cannot come before the court. And further, the defendant has already made the construction and at this stage, the court cannot injunct the defendant from making the construction. And also, there is no balance of convenience and prima facie case in favor of the petitioner. And in fact, if the construction is stopped, that would cause a lot of hardship to the defendant. The order of the appellate court has rightly considered and passed orders. Now, after the construction is completed, now the order that can be, if the petitioner succeeds in his suit, then the court would pass an order provided if any mandatory injunction is sought, or else at this juncture, the petitioner is not entitled for any order in those circumstances. This court do not find any reason to interfere with the orders passed by the trial court which is affirmed by the appellate court. Accordingly, this court is passing the following order. This court do not find any reasons to interfere with the order impugned dated so and so in MA number and confirmed the order in so and so. However, it is made clear that this will not come in the way of this order will not come in the way of the petitioner in seeking appropriate relief from the municipal authorities.
Please, grateful.
Case number 26, Rajesh Gowda for petitioner.
The first appellate court has been allowed the IA1. under
First
section-
appellate court?
Allowed the IA number 1 under section 5 of the Limitation Act. But the petitioner as a plaintiff filed a
The
suit
delay,
of 1 year, 6 months, 23 days. But the petitioner has filed a suit for specific performance, my lord, and defendant has been appeared and they filed a written statement. On 19/6/2020, the suit came to be decreed. On 25/9/2023, the defendants filed wakalat in the execution petition. After lapse of 16 months, they filed a appeal before the appellate court, my lord. The reason assigned, my lord, in page number 43, my lord, para number 4. 43, para number 4. I submit that whenever asked the previous advocate, he
but
conveyed.
even before the trial court also they were ex parte.
No, they appeared. They filed the written
It's a
statement.
contested matter.
No, they are not contested. They filed written statement only. Thereafter, they are not appeared. 2 advocates has been appeared for the defendants. None of them cross-examined the plaintiff, my lord.
Yes.
But in para 4, page number 43, my lord.
43.
43, para
This is
4.
the affidavit.
This is the reason by the
No, 43 is the affidavit.
section 5 application reason, my lord.
That's what affidavit filed by them.
Yes, affidavit filed by them. I submit that whenever asked the previous advocate, he conveyed to me that the case is still continuing and the case is pending. Without asking the advocate, recently I contacted the present advocate and after verifying the same, the said suit was already disposed of 19/6/2023. After discussing with my family, I applied the certified copies. The certified copies delivered on 12/6/2024, but the judgment was passed on 19/6/2023. Hence, the limitation for filing of the appeal was over to condone that because of the financial, so I could not file the appeal. This is the reason.
Come to the order.
My lord, in page number, my lord, 19. Para 16, my lord. It is pertinent to note that the trial court passed judgment on 19/6/2023 and the appellant filed appeal on 11/2/2025. There is a delay of 1 year, 6 months, 23 days. Hence, this court opinions that it is necessary to pass an order requiring the appellants to pay the other parties such.
Please come. And also the petitioner submits that there is a delay of 1 year, 6 months, 23 days. The respondents herein has filed an IA to condone the delay in filing the appeal. And the court, while condoning the delay, has failed to give any reasons when the delay is inordinate. And having appeared before the executing court after the delay when they have appeared and no reasons were stated, the court has still condoned the delay. Considering the same, they shall be stay of all further proceedings. So and so notice the hand summons 4th August. Yes.
Great.
27, Rajeshwara, TN.
My application for production of the records by the defendant referred to in the written statement is rejected by the Honorable Trial Court, my lords.
Where is that?
Lords, the order, my lords, will find at page 35, my lords.
$35.
Please, please. At page 39 is the point number 2, my lords.
Let's read that.
Under IA number 7, the plaintiff is seeking for directing the defendant to produce the various documents mentioned in the said application, which are kata of the suit shall property and other documents referred to in the written statement, and also copies of which are produced with the written statement. In the affidavit annexed to IA number 7, the plaintiff has stated that these documents are necessary to be looked into by him before he can lead evidence effectively. That without the said documents being produced, it is very difficult for him to proceed with the suit. It is also stated that already the plaintiff has given notice dated so and so under Order 11, Rule 16 of CPC, calling upon the defendant to produce the documents. Since the defendant has failed to produce the said documents for his inspection, it has been forced to file the present application for issue of necessary direction. The defendant in the objection has contended that the said documents are not at all relevant for deciding the issues involved in the present suit, which is filed for injunction. The plaintiff, only in order to drag on the proceedings, has come up with these applications. Therefore, he prays to dismiss them. Order 11, Rule 15 CPC speaks that every party to a suit shall be entitled at or before the settlement of issue to give notice to any other party in whose pleadings or affidavits reference is made to any document, or who has entered any document in any list annexed to this pleadings, to produce such document for the inspection of the party giving such notice. As provisions of Order 11, Rule 18 CPC, when any party omits to produce a document, the aggrieved party can file an application to the court to issue necessary direction. Therefore, the court, if satisfied that such documents are necessary for deciding the suit, can issue direction to the concerned party for producing the said document for inspection. In the case on hand, the plaintiff has come with the suit for injunction on the basis of lease agreement executed by wife and daughter of original owner R. Shankar. Defendant claims to be now owner of the suitable property on the basis of registered sale deed executed by concerned authorities in his favor on 21/7/2000. Under IA number 7, the plaintiff is seeking for production of kata of the suitable property, revenue documents, tax paid receipts, notice, loan clearance letter.
Come to para 22.
Therefore, at this stage, this court does not find any ground to issue directions to the defendant for producing the documents mentioned in IA number 7. Moreover, though the plaintiff claims to have issued notice of production of the documents in the year 2019 till 2024, he has not filed any application to direct the defendant to produce the same. It is only in the year 2024, that is IA number 7 is 17 is 7 is filed. He has not explained why there has been such delay. Thus, there is no grounds made out for issuing direction as sought in the IA number 7.
This application is filed in the year 2024.
2024.
Please come. The petitioner is, the petitioner plaintiff is before this court agreed with the rejection of an IA that's filed under Order 11, Rule 16, to direct the defendants to produce the documents that came to be dismissed by the court only on the ground that the notice for production of the documents is of the year 2019 until 2024. He has not filed any application to direct the defendants to produce the same land counts for the petitioner submits that. Those documents are very much crucial for the purpose of deciding the dispute, notice, interim stay of all further proceedings. Yes, fourth. Yes, next.
Cell number 28. Ramesh Kumar.
I represent petitioner counsel. Filed a suit for specific performance. In the year 2023, the file is missing before the trial court.
So,
where the file could not be traced, I had more number of applications.
What happened? Suit is filed?
Suit for specific performance. Where the file before the trial court is misplaced. I request any member to request the file to trace out the file. File could not be traced out. Where now in the month of July 7/7 to 3/26, the respondent 1/2/24 alienated the property. I am seeking only a mandamus to trace out the file to consider my applications. That I had filed an impleading application also. At 10/7/2020, I had made an application for advancement application. Thereafter also file is not traced out. In page number 24, trial court order sheet, the file is misplacing, it is there.
When was it misplaced?
In the court itself.
When? From when?
On 28/11/2023.
From
Page
then
number
it is-
24.
From then it is not.
Not traced out.
The petition is falsing the following prayer. Land counsel for the petitioner submits that the file is missing from the year 2023.
28/11/2023.
28/11,
2023.
22,
23.
23, the file is missing. And the petitioner has filed an application at Order 1, Rule 10 to implead the purchases of the property. And it is submitted that now they are making construction.
Alienation has been taken place.
It is submitted that the properties are alienated. And as he has made repeated requests in spite of the same, the court has not taken any action, and which made the petitioner to come before the court, considering the submission of the land counsel for the petitioner. And the fact, and particularly the submission that right from the year 2023, the file is missing. This court deems it appropriate to dispose of this writ petition. The trial court shall trace out the missing file in OS number 1056 of 2023 on the file of the Secretary Senior Civilian JMF State Devanhalli, and shall consider the application filed under Order 1, Rule 10(2) as expeditiously as possible.
I filed 39 Rule 1 and 2 application not to alienate. That application is also pending. That application.
And other applications that are pending shall be considered as expeditiously as possible. Yes, next.
Cell number 29, Vishwanath NS.
Frame, any time frame. Time frame.
Within 4 weeks, within 8 weeks. Yes. Yes.
Petitioner.
In that, application for injunction to be considered within 8 weeks, not thereafter order 1 rule 10(2). Yes, yes,
Appearing for the petitioner.
yes.
The plaintiff's writ petition challenging the order of the learned trial court. Annexure G, wherein only summons has been issued, being
Where
agreed
is
by
that? Page number?
96.
What is the suit for?
Suit for bare injunction.
Please
There is an order by this honorable court in a writ petition in respect of the land which I am claiming ownership over the property, the adjacent land which is not subject matter of acquisition, and the acquisition as far as the defendant's land is concerned, it has become final. As far as the petitioner's application, writ petition is concerned, once writ petition was allowed and the acquisition was quashed, on an appeal by the cooperative society, it was allowed and remanded the
No, what
matter.
we will do is we'll ask the court to decide this within a week. We'll ask the trial court to decide it within a week. Your application for injunction.
Till then, let there not be any.
I'll ask them, 1 week is not a long period, and without whether the notices are served on them or not, it will
I
be
will only
decided.
take 1 minute of your lordship.
No, but the difficulty is, again, granting injunction here, sending the matter and all that exercise I'm not doing.
There is an order by the division bench, my lord, in my favor.
I understand. That should have been considered by the trial court, which is not considered. We'll ask the court to do it.
But
But
that is the reason for not, when there is
this
a
order
protect-
is passed on 29/6/2026.
Yes.
You have come before this court after a month. I'm saying only a week, but no injunction from this court. Will not prejudge the issue. The
I
present.
just want to bring to the notice of the court, my lord, so that
No, I
there is,
understand.
there
You may be
is
having
an
a-
order of the division bench to protect my interest.
That
The learned judge, without looking into it,
That's what I'm
issued the
asking him.
notice.
I'm
That is,
asking
my
him-
lord,
I'm
my
asking-
grievance before the
I'm
court.
asking him to do it within a week, without notwithstanding the fact that the notices are served on the respondents. Whatever, no, the court can consider, the trial court should also consider it. No, it is like granting injunction, sending it back and all this exercise we shouldn't do. That is what I strongly feel.
Lord, I agree, but there is an order of this honorable division bench that has been ignored, my lord, is my grievance.
That is not recorded to understand for this court.
I have stated so.
No, if that is why I am saying the court should pass an order, a reasoned order. If it grants, doesn't grant, you will get a remedy.
I thought I will persuade your lordship, my lord, to
because
consider.
that
When
is
there is an order of division
Talk-
bench to protect my interest, ignorance of the order passed by this honorable court is
Because-
requires interference.
because it is not an order at all. It is just issuing suit summons.
That's the reason I am aggrieved.
That's the reason why I am saying you
If-
should
if-
go before the trial court.
If the division bench order was taken into consideration, there is no other option except to grant an injunction in my favor. But failure to take into consideration the order of the division bench,
Because
I
the-
feel I am aggrieved and therefore I am seeking protection at the hands of this honorable court.
Yes, please come. The present petition is filed. Agreed with the order passed in notice number 25635 of 2026 in I number 1, where the court has issued the suit summons. Land Senior Counsel representing the counsel for the petitioner submits that in respect of this property, there is an order by the division bench, and the court ought to have considered the same and ought to have granted the injunction as prayed for. And the court, without granting injunction, ought not to have passing an order on the merits of it in the light of the order of the division bench of this court, ought not to have issued suit summons which made the petition to come before the court. It is a submission of the Senior Counsel that the interim order as granted by the trial court shall be, the interim injunction shall be granted by this court pending consultation by the trial court. Next paragraph. Having heard the Senior Counsel peruse the material on record. When an application is for seeking ad interim injunction, it's a duty of the court to pass orders on the merits of the matter instead of issuing the suit summons. It is a contention of the Senior Counsel that there is an order by a division bench of this court. If that is the case and if that is argued before the trial court ought to have granted reasons if the trial court is not inclined to grant an injunction or to have ought to have rejected the same by giving reasons, but it cannot issue suit summons in this manner without deciding the same. If the orders are passed, the affected party would have a remedy and would have a remedy. Considering all these aspects, though even this court is not inclined to go into the merits of the matter, it is reiterated with the senior counsel that there is an order by a division bench of this court. Even even in that case, this court exercising the jurisdiction under 227 will ask the trial court to do what the court is supposed to do when an application is filed, and this court will not pass an order and direct the respondents to come before the court and enlarge the entire scope of the litigation. In that view of the matter, in the light of, and also a division bench of this court, a coordinate bench of this court in WP number so and so has passed an order. In the light of the submission of the Senior Counsel and in the light of the order passed by a coordinated bench, this court is passing the following order. The writ petition is disposed of, directing the trial court to consider the application, the CH number 1 filed with the petitioner in accordance with law within a period of 1 week from the date of receipt of the copy of the order, notwithstanding the fact that the notices are not served on the defendants.
Obliged.
Cell number 30.
Lord, it is not writ petition, Lord, writ appeal.
Writ appeal.
Page 70.
No, I'm saying this, I said division bench, not writ petition, I'm referring to this.
Writ appeal, Lord. Writ petition was allowed. Matter was taken up in the appeal and
division
it is
bench
now
is-
remanded.
Yes,
Page 73 is the order.
yes, yes,
30, HP Banu Prakash.
yes.
For respond to this matter.
Yes.
My Lordship, we challenge the order passed by the trial court on the amendment application. The defendant has.
Court has allowed the amendment. Court has allowed the amendment.
No. Dismiss my application.
You are the plaintiff.
Yes, no, I am the defendant.
What is the suit for?
Suit for declaration,
Which year is this filed?
2007, my Lordship.
2007.
7.
What is the amendment now you want to see?
Only for, not mentioned in the two deeds. In the written, I can't see the paranum in
Come
page
to your
number
affidavit.
101.
No, come to your affidavit. It's your affidavit.
103. Page number. Page number.
Page number 103. Yes.
I state that I am the GP holder of the Srimati Girija and daughter of Anniyappa and the said Sushilama, late Anjanappa. I know the fact of I am just swearing this affidavit so and so. Paranumber, I state that after receiving the summons from the Honorable Court, the above suit, I have filed the return statement and at the time of filing the return statement.
So what is the prejudice to you if this application is ordered?
This suit for declaration and possession, suit in the year 2007. Nothing prevented to file in the year.
That is, they are not in this position.
And also, this coordination already given a direction to trial, given a direction to trial. If the trial within.
No, that
6
is
months.
true. These documents are not in his possession. These documents are not in his possession because he is not a party to these documents.
Yes, he is a partner. Kindly see the trial court order, Your Honor.
Come to the affidavit. Affidavit. At
Yes.
page number 103, paragraph number 2.
I said after receiving the summons from the Honorable Court in the above suit, I have filed the return statement at the time of filing the return statement, the sale agreement dated, already it has been marked, Your Honor. XB D6. Those the agreement of sale and memorandum of understanding, already those.
The defendant in the suit.
Yes.
He's a defendant in the suit. What he says is, entered between the plaintiff and Bailamma Prasanna Kumara so and so in favor of one so and so is not understanding dated. All these documents are pertaining to you.
No, man. Already they have produced. Those documents have been marked.
Then why does he want those
Kindly
documents
see
again?
the trial court order, Your Honor. My lord, kindly see the.
But that contention is not taken in my return statement.
115,
That's why I filed it.
In page 115.
Para 9. It is worth to note here that defendant number 4 has been examined as a DW4 on 3/10/2015 itself. In para 10 of the examination in chief DW4, it is mentioned about agreement dated 12/7/95 and memorandum of understanding dated
What is the
12/7/19
no,
by
if you
general power of party order of
not
who
mentioned,
examined
you're
as a
not-
DW5 in our examination chief filed in 38/2016.
if you have not mentioned it, what is, why you need to mention it now?
Instead by not taken in the return statement, that's why in future they have filed any appeal, both sides. Pleading is very important.
You're just saying that you're
Defendant
just-
have taken any amendment at any stage of
Already
the
19
suit.
years
may
are
actually
lapsed, Your
amend.
Honor.
Not
It's a
after-
liberty to defendant to take
Not after
defense.
15
Plaintiff
years,
is a
any
senior
amendment
citizen.
after 15 years. Now, I thought, looking at this paragraph, you wanted to place this document.
Yeah, yes, my lord.
Already
You've already placed the document.
Plate document is not mentioned in the return statement, that's why.
What is that you are mentioning? Let us read from your affidavit. What do you want to mention?
who examined a DW5 in our examination.
Let him. Yes.
My application, my lord, my lord,
I am
application.
looking at your application.
In added the following amendment, the plaintiff admitted that confirmed the sale deed executed by the Bailama Prasanna Kumar in favor of the B.N. Ramachandra and Taman, and also admitted accept the position of the defendant and their sale transaction between the plaintiff and Bailama. Prasanna Kumara, Tamanna, Ramachandra, defendant, plaintiff are entered memorandum of understanding along with the Bailama, Prasanna Kumara, Tamanna, B.M. Ramachandra, Ramegowda, and B.K. Narayan Swamy. The same was witnessed by the witness. The sale agreement dated 12/7/95 and the memorandum of understanding 12/7/95 executed them in favor of Ramegowda and B.K. Narayan Swamy. The plaintiff had accepted the ownership of the survey number 71 measuring about 36 guntas, and B.M. Ramchandra, Tammanna and defendant who are purchased the site from the B.M. Ramchandra and Tammanna. The plaintiff number 2 Rajanna received the entire consideration from the Ramegowda and B.K. Narayan Swamy and put his signature along with his mother Muninamba received the amount of ₹2,50,000 in respect of their share.
Yes, please
And
come
stated.
to. Yes, I have seen. Come to the order. Order impure.
$112.
$112.
$112.
$112.
100.
Yes.
114 reasons. It is worth note that here that it is a matter of the year 2007 on 21/1/2006. The matter was posted for our judgment. Meanwhile, the defendant have filed the writ petition 1376/26 before this Honorable Court of Karnataka challenging the order dated 12/12/25 passed by this court on application filed by the defendant under 26 Rule 10 of CBC. The Honorable Court disposed the said writ petition observing liberty to however reserve for the in favor of the defendant and plaintiff to adduce the additional evidence relation to all the aspect matter including the D6 and 7. It is noted that D6 and 7 are the agreement of sale memorandum of understanding dated 12/7/1995. Now the defendant come up with a present application on the ground that at the time of filing the return statement, this document were not in the custody of the defendant. While discussing the above case, Ramegowda and B.K. Narayanaswamy handed over this document. Those documents have been confronted during the course of the cross-examination of the PW. Hence, the defendant were unable to mention about these two documents in their written statement. It is worth note here that the defendant of 4 has been examined as a DW4 on 3.
I have seen. What is to be done?
That's why they have produced the document. But return statement, after filing the return statement, you have this document is taken by some other person. That's why he filed an amendment application. The cause of action is not changed. The defendant have raised file a return statement, any statement. Actually. There is no new cause of action.
Agreed with orders passed to 9 number 1 of 2026 and notice number 2595 of 2007 by the Principal Civil and Session Judge, Bangalore. Dated 6/4/2026. The plaintiff is before, the defendant is before this court. The respondent herein has filed a suit for declaration.
Declaration and possession.
Declaration and possession. When the suit is posted for arguments,
Earlier it was
earlier the
posted
suit
for
was
judgment.
posted for judgment. At that time, the defendant has filed a writ petition before this court, and the matter, then the order was, and the writ petition is disposed of, permitting the parties to adduce the evidence. Thereafter, now the matter is posted for arguments. At that stage, the present application is filed to amend the written statement stating that about the documents dated, sale agreement dated 12/7/1995 and memorandum of understanding dated 12/7/1995. They have not mentioned in the written statement, and hence by way of this amendment, they want to want to add those paragraphs to the written statement that came to be dismissed by the court by order impugned. The court, while dismissing the application, has discussed about the earlier writ petition filed and the suit that is filed for that is when the matter is posted for judgment.
Earlier writ petition is with regard to the signature referred to the foreign.
The court has observed that Exhibit D6 and D7 are agreements of sale and memorandum of understanding dated 12/7/1995. Now defendants come up with present application on the ground that at the time of filing written statement, these documents were not in custody of the defendant. While discussing about case, Ramagowda and B.K. Narayanaswamy handed over these documents, and those documents have been confronted during cross-examination of PW1. Hence, they are now unable to mention these two documents in their written statement. Court has observed that the defendant number 4 has been examined as DW4 on 3/10/2015 itself. In para 10 of the examination chief of DW4, it is mentioned about agreement dated 12/7/1995 and memorandum of understanding dated 12/7/1995. The general power of attorney holder of defendant number 5, who examined that DW5 in her examination in chief filed on 30/8/2016, has also mentioned about these two documents. And likewise, the general power of attorney holder of defendant number 6, who examined as DW6 in a examination in chief, mentioned about these documents. Under these circumstances, the contention of the applicant that recently they came to know about this, and as such they could not seek the amendment. Amendment has no cannot be considered, and accordingly rejected the application. Next, file and counsel appearing for the petitioner submits that the defendant can amend the pleadings any number of times, and there
Any
cannot
stage,
be
any stage of
any number of times at
Any
any
number-
stage
any
of the proceedings, and there is no bar for the same. It is submitted that the amendment that is sought, that he is seeking now, will not change the nature of the proceedings. And in those circumstances, the court ought not to have dismissed the application only on the ground that these facts are known to the petitioner way back in the year 2016 and under subsequent stages when it is during the course of evidence. It is submitted that when an application is filed under Order 6 Rule 17, the court has to liberally allow the amendments. Next part. Land counsel appearing for the respondent submits that already a coordinate bench of this court has directed the court to dispose of the suit within a period of
6 months.
6 months.
And this order was passed on.
4/2/2026.
The order was passed on 4/2/2026. It is submitted that this application is only filed to drag on the proceedings. The court has rightly considered and rightly observed that all these pleadings are very much available before the court, and at a belated stage, this application is filed. Next paragraph. Having heard the land counsel, the petitioner peruse the material on record. This is suit for declaration and possession of the year 2007. Now, earlier already the suit was when the suit was posted for judgment. At that point of time, a writ petition is filed, and now the matter is at the stage of evidence, at the stage of
Arguments on merits.
at the stage of arguments on merits. Now, the petitioner has come up with this application stating that he wants to amend the written statement and a particular facts were not stated in his written statement, and according to him, he can make the amendment any number of times being a defendant, and no prejudice is caused. This court is not able to appreciate any of the submissions that are made on behalf of the petitioner. The suit of year 2007, when the defendant wants to amend the written statement, it is after the amendment to CPC, either of the parties, if they want to amend the amend the pleadings, they have to state before the court that in spite of due diligence, they could not make the amendment, make an application at an appropriate point of time. From the pleadings on record and also a perusal of the order passed by the trial court, it is very much evident that all these facts are very much on record right from the year 2016, and in those circumstances, and also considering the peculiar the facts of the case where the matter earlier is posted for judgment and now it is posted for argument, this court do not find any reasons to interfere with the order passed by the court. Accordingly dismissed.
Cell number 31, Dharmesh A for petitioner.
Second defendant's application for transfer.
Direct petition is not listed, Mills.
Another petition not listed.
Third petition is not listed.
Where is that number?
Mills WP number 19.
Write on a paper, I'll take up on Monday. List these three matters on Monday.
If one of the matters is heard, then perhaps the same
issue.
order would follow
Same
each other.
issue, same point, Mills.
Because-
We are all sailing together, Mills. The contesting party is not before the court. It's the father and son in the suit, Mills. I let them argue, but it's
Yes. Come to
Shall
the
I?
order.
So suit for partition, my lord, wherein the rights are claimed on the basis of a registered will executed by the great grandfather of the plaintiff. The second defendant is the father of the plaintiff, my lord. He filed an application seeking his transposition as the second plaintiff in the suit. The reason which is quotes in the application is that he wants to file a better pleading.
Let's see.
Please,
On
my lord.
perusal of the accompanying affidavit.
The order, my lord. The reasoning is at page 32, my lord. Para 7 says about the.
Why you should be transposed as a
No,
plaintiff?
I'm the one opposing, my lord. I'm the only one who filed objections to the application, my lord, saying that my interest is in conflict with the second
You're
defendant.
the plaintiff.
I'm the plaintiff.
Who files an application?
Second defendant files an application seeking transposition.
For what reason?
He says that he wants to, his presence as a plaintiff would be, I'll just read the relevant portion, my lord. He says that there is the bill in question would be better explained, he being as a plaintiff. It's a suit for partition, my lord, wherein I base my claim on the basis of a registered will. There are previous proceedings which have been litigated between the second defendant and the other defendants who are brothers, my lord. Siblings inter se, my lord. I'm no way a party to the previous litigations. My suit is for partition. I derive a right from the will, my lord.
if I may, in a nutshell, Mills.
Anyway, we have to issue notice to the.
Please.
And
The
counsel
impugned
for
order
the-
may be stayed, Mills. Let
and
the
counsel
suits
for the,
continue.
Petitioner submits that when an application is filed by the defendant to transpose him as a plaintiff, the court without recording any reasons has allowed the application. Considering the same, there shall be stay of all further proceedings pursuant to the order. dated-
Not further proceedings,
If the
only
order,
the order-
impugned dated so and so, the operation of the order dated so and so is stayed till the next date of hearing. List along with, give the number.
Please.
But as respondents 3 to 47, my lord, they would not be necessary parties, my lord. I'm
A
just
memo
filing.
is filed seeking dispensation of notice to 3 to 47.
3 to 47, my lord.
Notice to respondents 1 and 2.
Just one, my lord. Two is appearing, my lord.
1.
One, my lord.
Even
yes.
respondent one senior, learned senior, Shri H.R. Kannan Krishnam, he is appearing on behalf of the other.
He appears for respondent 1.
No, my lord. Respond number 1 will have to be
He
notified.
says, are you appearing for respondent number 1?
No, Mila.
No, he appears for respond number 3, my lord.
Yes.
Respond 3.
This
He's for
respondent number
respondent
one
three.
notice, you appear for two.
I'm appearing for two.
Notice to respondent hand summons memo shall be filed by 4th of August.
Please. Grateful, my lords.
Cell number,
List along with so and so, that number. Yes.
Please.
number 32.
Appear for the petitioner.
For the
My lord,
respondent, Your Lordship.
this arises out of an order in execution. My lord, there was arbitration, an award was passed against me. I came up in appeal. There was a modification of the order. Then we came up in appeal to this court. Both parties, there is no stay. They took out execution. I have no dispute about that. They took out execution. They made a claim of 14 crores. I am not even contesting that amount. The appeal is there. Ultimately, whatever we decide. What happens is then they make an application for attachment. There are 262 apartments, out of which 100 belong to them, 162 belongs to me. They take out an application for attachment, and the trial court, what it does is, by one order says attach and issue proclamation. That can't be done. Under 2154 attachment agbeku, then they should call upon me, and proclamation nalli, there's a particular format in Appendix E, Form 29, all the details are due. Then the court under 2164 has to say whether it is necessary to sell all 162 apartments. Your claim is only for 14 crores. Instead of that, the court says, issues proclamation for the entire 162 apartments, which is about 162 crores.
Your Lordship,
Point out, my lord.
Your Lordship, proclamation of sale has not yet been issued. We are also not pressing on it. As of now, only attachment has been, attachment order has been,
I'll make it, I'll clarify this order.
there is no
As
such.
far
Yes,
as-
clarify the order.
No, no, as far as attachment is concerned, the court will not interfere.
No, Your Lordship, if your
I won't.
if your
Let
Lordship
proclamation be stopped, my lord.
Page number,
180.
Your Lordship, the 180, to hear regarding issuance of proclamation of attachment and sale for publication.
180, my lord. Please see, my lord. Please see 181. DHR by so and so, issue attachment and sale proclamation.
Sale proclamation is not issued.
It's issued, can't be issued, my lord.
I mean, I'm not.
Unless the court under 21.
no, where is the order impugned?
My lord, they don't give us the file, my lord. The file doesn't come out of the court. I'm not able to get a certified copy. In fact, I have picked out copies from the, my lord, we have made the application. I picked out printouts, my lord. All the day's orders are on printouts because the file is not being sent to the copying branch. Every 2 days the case is there. The files are not coming to us.
Yes, in the next page, there is an order of sale proclamation.
Your Lordship,
Next page at 181.
but we have not taken any proclamation
maybe-
pursuant to that. Yeah, proclamation, it may be ordered that it may be, I'll file the separate application for proclamation. As of now.
Whatever
attachment-
process they have to take, let them take.
Attachment need
But-
not be.
Interfere.
Interfere? No, I'm not asking for interference with that.
Then I'll dispose of this writ.
Yes,
Much
please
obliged.
You're the
dispose.
only respondent.
I've filed caveat for respondent 6. However, in
About
the
the other
tri-
respondents.
I appear for all the respondents before the trial court except ninth
So you
respondent,
take notice for all of them, shall I record
except
it?
ninth respondent.
Ninth respondent, who is
Ninth
the,
respondent is JDR 2.
Ninth, I think, is sailing with the petitioner, maybe.
They're
It's our
sailing with the
people
petition, but
may
they
not
are-
be
they are
concerned.
not-
Dispense, I'll file a memo to dispense with notice to ninth,
a memo is filed seeking dispensation of notice to respondent number,
9.
respondent
Shweta.
number 9, dispensed with. Land counsel appearing for the caveator R6
R6.
submits that he has instructions to file wakalat from 1 to 5.
1
Also-
to 8.
1 to 8.
1 to 8. 1 to 8. The petitioner is before this court. To questioning the order dated 1/6/2026 and the order dated 6/6, 1/6/2026 and 6/6, both you are asking.
Yes, madam. But what happened is
Dated
continuously.
1/6/2026, on 1/6/2026 is the attachment order.
Attachment.
1/6/2026 and the order dated 6/6/2026 passed in commercial execution number 427 of 2025 on the file of the additional district and session judge, Bangalore. The senior counsel appearing for the, representing the counsel for the petitioner submits that. The court by order dated 1st June 2026 has issued an attachment, has issued a warrant, has passed an order whereby an application filed under order 21 rule 64 at this section 156 one of the CPC filed with the DHR to attach a immobile property for sale is allowed in Schedule B is allowed. JDR is directed to furnish particulars of the B schedule properties as provided under Order 21 Rule 66 of CPC. And the court has passed an order to hear regarding issuance of proclamation of attachment and sale for publication. It is submitted that thereafter they would find an order dated 27/6/2025, whereby the court has issued attachment and sale for proclamation of B schedule property of the JDR if the charges are paid, and to submit a report. Call on 27/6/2026. When senior counsel submits that such a procedure is not available to the court, and the court ought not to have issued the proclamation. Further, it is without following the procedure as contemplated under order
21 rule 64.
Under order 21 rule 64. It is submitted that they couldn't even have a copy of the order, as the matter is listed day to day.
Virtually day to day, not
Day
getting.
to day, and they could not even get a copy of the order. Land counsel appearing for respondents 1 to 8.
1 to 8.
1 to 8 submits that in fact, they have not paid any process charge, that then only the proclamation.
They have only done.
Order itself can't be done unless.
It is submitted that they have not paid any process. They are not insisting for any proclamation, insisting for any, they have not sought for any proclamation.
Attachment happened just last week. So
Attachment has
next
happened
date is on
recent.
Monday and I'll file application.
And
necessary application.
and they have to file an appropriate application. It is submitted that as far as the order of attachment is concerned, as there is no stay in the pending appeal, they have filed the execution, and that attachment cannot be, there is no irregularity with the said order passed by the court. Shall record your submission that you are not pressing upon attachment.
Attachment, I'm not there.
No, shall I
Attachment is there,
record it,
but
I'm saying?
subsequent attachment, there are a lot of processes to be followed.
It is submitted that by the
They simply
senior
can't just
counsel
say-
that he is not insisting on he is not going into the merits of the order of attachment. However, is only concerned, the petition is only concerned with the manner in which the proclamation order is passed. Is passed. Considering the submission of both the parties, this court deems it appropriate to set aside this order dated 27/6/2026.
6/6/2026.
7/6/2026.
No, that is not.
6/6/2026.
Yes.
Order dated 6/6/2026, and the court shall follow the procedure under order 21 rule 64.
54 to 66.
While issuing the proclamation, the court shall follow the procedure as contemplated under the CPC, accordingly disposed of. Yes.
79, due to my ill health, not able to
In
attend.
this case,
79, serial number.
first list or second list?
First list.
No
First list.
mentionings I'm going to take. Only I'm taking that for,
My lordship,
yes.
79, not able, no representation, non-compliance office objection. Due to my ill health, not appear. Hence placed for 1 week time, serial number 79, compliance office objection.
No, morning you said something else for withdrawal or.
Withdrawal 80, serial number converted to writ petition to civil revision petition, serial number 80. My petition, serial number 79 by proxy. Serial number 17, 1 week time to comply the office objection. Serial number 80 is converted to.
Office objection shall be complied within a week. 80.
80 is converted to writ petition.
80. Memo is filed seeking to convert this
Writ petition
writ
to civil.
petition into a
Civil revision petition.
into a CRP. Accordingly, the memo is taken on record, and the writ petition is the petition is permitted to convert this into a so and so for statistics.
My lords,
Within a
one
period
sub
of-
number, my lords,
Serial
list
number
number,
1 week
my
from
lords
the
number,
publication.
list 2, serial
The
number
lordship,
30, my lords.
serial
It has
number
been posted
35.
for judgments, my
The
lords.
lordship, may I have my
Lords,
call
once-
numbers?
ಆಪರ್ಚುನಿಟಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಇನ್ನೇನ್ ಮಾಡೋಣ ಸರ್?
ಹೌದು.
ಕೇಳಿಸ್ಬೇಕಲ್ಲ ಸರ್ ಅಟ್ಲೀಸ್ಟ್ ಲಿಸ್ಟ್ ನಂಬರ್
ಫಸ್ಟ್ ಲಿಸ್ಟ್
ಭಾರಿ ಹಿಂಸೆ ಆಗೋದು.
Court officer? Court officer?
ಹೇಳ್ಬಿಡಿ ಹೇಳು ನೀನೆ.
ನಂದು ಅದೇ ಸರ್, ಯಾವುದು ಒಳ್ಳೆ ಬುದ್ಧಿ ಇಲ್ಲ. ನಮ್ದು ಅದೇ ಸರ್.
ಸರ್ ಏನ್ ಡೇಟ್ ಇದೆ ಆ ಡೇಟ್ ಬರ್ದು ಕಳಿಸಿ ಸರ್ ಅಷ್ಟು. ಸರ್
ಅಲ್ಲಿ ಯಾರಿದ್ದಾರೆ ಆನ್ ರೆಕಾರ್ಡ್?
ರೀಚ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ಡೇಟ್ ಹೋಗುತ್ತೆ
ಇಲ್ಲಿಂದೆಲ್ಲ ಆನ್ಲೈನ್
ಸರ್. ಇದ್ರಲ್ಲಿ 86 ಸ್ಟೇಟಸ್ ಇದೆ ಸರ್, ನೋಡು ನಾವು ಹೇಳಕ್ಕಾಗಲ್ಲ ರೀಚ್ ಆಗುತ್ತಾ ಅಂತ. ರೀಚ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಡೇಟ್ ಅಸೈನ್ ಆಗುತ್ತೆ. ಅದೇನಂದ್ರೆ ನೀವು ತುಂಬಾ ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಅರ್ಜೆನ್ಸಿದು ಮೆಮೊ ಅದೇ ಇವಾಗ ಕೊಟ್ಟಿದಾರಲ್ಲ ಆ ತರ ಬರೀರಿ ಇನ್ ಡೀಟೇಲ್ ಬರ್ಕೊಡಿ ಅಷ್ಟೇ. We will place it before the court, but dates ಹೋಗುತ್ತೆ. According to the board, we will assign the dates, whatever the urgency you have to plead. ಅದನ್ನೇ ಸರ್ ಎಷ್ಟು ಸರಿ ಲಿಸ್ಟ್ ಆಗಿದೆ, ಯಾಕೆ ರೀಚ್ ಆಗಿಲ್ಲ, ವಾಟ್ ಈಸ್ ಯುವರ್ ಅರ್ಜೆನ್ಸಿ ಅದನ್ನ ಬರ್ದ್ಬಿಟ್ಟು ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಸೈನ್ಡ್ ಯಾವ ಡೇಟ್ ಇದೆ, ಕೋರ್ಟ್ ಯಾವ ಡೇಟ್ ಅಸೈನ್ ಮಾಡಿದೀವಿ, ವಾಟ್ ಈಸ್ ಯುವರ್ ಅರ್ಜೆನ್ಸಿ ಅಂತ ಬರೀ. ಇವತ್ತು ಸಂಜೆಗೆ ಗೊತ್ತಾಗುತ್ತೆ. ಸರ್
ಶಾರ್ಟ್ ಇಟ್ಕೊಳ್ಬೋದು ಮೇಡಮ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
Your Lordship, if I may mention a matter in list two, my interim order is at stake. That's why I'm mentioning the matter, my lords. My lords, an interim order was granted to me on 1st
Why are you
June.
mentioning now?
My lords,
I've already rejected the mentionings in the morning.
my lords, only because my interim order at stake and there's a clarification with respect to office note. That's the only reason I'm mentioning it, my lords.
Why should you mention it now? It should be in the morning.
My lords,
Have you not seen the cause list?
my lords, I attempted to mention in the morning, but however, I wasn't able
No,
to.
because I have not rejected, I have rejected everything. So that doesn't mean that I will hear it now at 2:30. Please make a mention on Monday. Yes, please call the list.
Your Lordship, serial number 44, my lord. I mean, permitted to withdraw the revision.
40?
44, my lord.
Memo is seeking to withdraw the petition.
Please.
Memo is taken on record and dismissed as withdrawn.
Please.
Yes.
Apologies, my lords. My lords, the matter is listed today. My matter is listed today, my lords.
Where is it?
My lords, list 2, serial number 13, there's an office note that says that I've not filed the compliance memo with respect to hand summons. The same has been done yesterday, my lords.
So why it should be taken today?
My lords, only to clarify the office
Why it
objection.
can't be taken up some other day?
My lords, because my interim order at stake. That's the only reason. I
We'll
apologize.
see. Not necessary. List it on Monday.
Please, my lords.
13 ಅಲ್ಲ? Which number? 213.
Yes. How many are there? 2:30 matters. Hmm? Where is that? Yes.
230 matter, cell number 82, Manjunath KS for petitioner, BR Vishwanath.
Lord, and for the petitioner defendant.
Yes.
My application under Order 7, Rule 11D was rejected by the trial court, against which I am before your lordship. Admittedly, there were 4 alienation on or before 20th of December
Before we
2004.
proceed with the matter, please come to your affidavits in support of the IA.
Please, my lord.
Page number.
'76. Approved, stay.
70.
Your lordship is referring to my application as under IA number 27, my lord. Yes, my lord. Page 56. My lord, the operative portion at 57, my lord. Ink page 57. May I read, my lord? I state that, should I read from the preamble or from
Page 58.
page 59, please, my lord.
58.
58, please, my lord. I further submit that suit properties, stolen properties item number 2 to 9 are the self-acquired property of my father, late B.M. Shamanna. I state that the marriage of the daughters were performed and their entire family was maintained by our father, and after his death, we continue to take care of the family of the plaintiffs. In fact, immovable properties were also acquired by our father in the name of female members of the family, which were sold by them to live lavish lifestyle, have come up with this false and frivolous suit to harass us. I further submit that my father B.M. Shamanna and my mother Srimati Sharadamma, myself and my daughter, elder brother Nagaraju and younger brother Raghu Kumar entered into registered partition deed dated 15/10/1975, registered as so and so at page so and so before the SRO Basungudi, Bangalore, in respect of our family properties. In the above said partition deed, A scheduled property allotted to the share of my father B.M. Shamanna, B scheduled property allotted to the share of my mother Sharadamma, C scheduled property allotted to the share of my elder brother Nagaraju, D scheduled property allotted to my share, and E scheduled property allotted to my younger brother Raghu Kumar. Subsequently, myself and my brothers Nagaraju and Raghu Kumar have entered into registered partition deed dated 23/9/1985, registered so and so, volume so and so,
in respect of property bearing municipal number 7, 7/1, 7/2 situated at.
Yes, you have stated so many things in the
Please.
application.
Please.
Is it stated by the plaintiff in the plaint?
My lord may kindly appreciate, though no doubt that the same has not been averred, but in page 32, the amended plaint of the plaintiff available before your lordship at in page 32 makes it clear that he admits that there was partition deed in the year 1979, precisely on 15/12/1979. May I request your lordship to kindly turn to in page 32 of the amended plaint.
Yes.
The very first last three line, first.
So this amended plaint was available to the court.
Please.
Where the order was passed.
Please.
Yes.
I think your lordship, and I will read the page 33 first line itself. Let's
Yes.
start from that. After the death, second line.
Yes.
After the death of the said B.M. Shamanna, the brothers of the plaintiffs entered into a deed of partition dated
You're reading-
15/12/1979.
You're reading page number.
Page 32, my lord. Operative
Yes.
portion where I'm reading. Second line. I think your lordship got it.
Yes.
After the death of the said B.M. Shamanna, the brother of the plaintiffs entered into a deed of partition dated 15/12/1979 in respect of the above mentioned 17 acres 20 guntas of land without including the plaintiff.
Yes.
This
That's
was
only in respect of item number 2 of the suit schedule properties, my lord. There are several other properties. That property also we say that, my lord, subsequently also it continued in the name of Mr. Shamanna, and it was continued as a joint family property. Keeping apart that, my lord, the partition was in respect of item number 2 of the suit schedule property only. There are 9 items of the suit schedule property. Hence, my lord, even assuming that there was a partition with regard to that property, the plaint cannot be dismissed partially, my lord.
My lord, so far as that portion is concerned, it is admitted. But the fact remains that when we adduce the evidence, exhibit D1.
We will not go to exhibit D1.
My lord,
we are only concerned with plaint and the documents.
That's
filed
what
along
I'm
with-
submitting, my lord.
Exhibit
In the-
D1 will not be filed along with the plaint.
My lord, amended plaint also speaks about the partition. If one partition is proved before your lordship, that is as on 20th of December 2004, that is the cutoff date, the alienation is proved.
In respect of one property, that is what he is submitting. You have anything to submit, please submit on that. According to him, it is only in respect of one property.
Item number-
Now, because of that, we can't reject the plaint in part.
My lord, no, it's not correct. I will submit, my lord. If I am permitted to take out that exhibit D15, which was marked in the course of evidence, what is D15?
Mr. Counsel, Mr. Counsel, please
Mentioned.
understand what can't be looked into by the court. You say that you please look into exhibit D1. Why will the court look into exhibit D1?
No, we are referring to that 15/12/1979
Then
partition deed.
it will be proved at during the course of trial, not now. How can the defendant's document be looked into on an order 7?
No,
Rule 11
but the
petition?
admitted fact, 15/12/1979 registered
Still,
partition is an
we can't
admitted
look at the
fact.
document. We will not look at the document. So you please tell the court, basing on the plaint and the plaint documents, how the suit can be, how the plaint has to be rejected.
My lord, my grounds F may kindly be seen. In page.
You can argue that. Why should the grounds be looked into?
My lord, here I have made a reference to that one, quoting, my learned friend was quoting this decision of the Supreme Court, wherein I have traversed that judgment, and there is an interpretation in that context. F may kindly be seen.
Yes.
In page 10.
Yes.
My learned friend was referring to the Supreme Court decision wherein Apex Court was pleased to hold that at honorable, may I read, my lord? F. The Honorable Supreme Court, while entertaining application filed under Order 7 Rule 11 DCPC, was pleased to observe that it is also necessary sometimes to consider the documents annexed to the plaint for a holistic and comprehensive reading of the plaint.
That is what I said. For that, there is no judgment required. That's what I said.
Yes, my lord.
The exhibit D1 is not the document filed along with the plaint.
It was not filed along with the plaint, but it is an admitted fact.
Yes, I have. I have taken, I
It
understood
is not
your
that they
submission.
have produced it, they have admitted the facts.
Yes, next. What is the other submission?
My lord, the law contemplates that if there is one alienation as on the cutoff date, that is 20th of December 2004, alienation is proved, disposition is already proved. If that is the case, the daughters cannot come to the court. That is the ruling of the court. My lord, may kindly appreciate in the case of.
The judgment is not required. That is also settled proposition. I know that.
Yes.
Yes, section 6. Yes.
My lord, even otherwise also, the learned trial judge had an access to all the documents at the time of reading I disposing IA number 27 before her. It is not that we have gone to the court afresh without reading the evidence. There was an occasion for the learned trial judge to look into all the documents, irrespective of the fact whether the plaintiff has admitted some of the documents or not. So far as partition deed dated 15/12/1979 is admitted. To that extent, I am seeking your lordship's indulgence. But so far as other documents are concerned,
I've take 1979 document. As admitted in the plaint, not as per the document. As admitted in the plaint, that is in respect of one property. Then what happens? I have to reject the plaint in respect of that property. Is it permissible?
my lord, it's not the question of one property, my lord. It is in respect of entire one. In fact, Shamanna was holding many other properties apart from this property.
Yes.
We are concerning with alienation.
Yes.
In that context, I am seeking your lordship's indulgence. Order 7 rule 11D is attracted to that extent.
Yes. Yes. Anything else?
My lord, apart from that, Exhibit PD19, a registered partition dated 23/9/1985, wherein the daughters, the plaintiff before your lordship, respond number 1 and 2, were the signatory contesting consenting witness to those documents. Though the document is marked before the court, they have suppressed these material facts. Apart from admitting the partition deed dated 15/12/1979, they have also suppressed many facts, though they were the consenting witness to that document. That is Exhibit D19, partition deed dated 23/9/1985, which fact cannot be disputed by the other side. My lord, there is no property left for partition. There were 4 alienation, my lord. One is 15/10/1975, Exhibit D7. 15/12/1979, Exhibit D15. Exhibit D19, 23/9/1985. Exhibit D22, a will dated. Mother has executed will in favor of the present petitioner before your lordship, dated 14/9/1988. So all this alienation has taken place well before the cutoff date, that is 20th of December 2004. In that context, though they are well aware of it, they deliberately suppress this material fact, come up before the trial court for partition. Whereas this Sound Court was pleased to hold that since there is already an admitted fact as on that date, that is 15/12/1979, this Sound Court was pleased to hold that it is maintainable. CRP is maintainable. In that context, the coordinate bench of the Sound Court was pleased to hold that. I think observation of His Lordship Justice Devdas may kindly be looked into.
You don't have to. I understood your submission.
Yes, ma'am.
No judgments are required for that. Yes.
This is how things.
Yes, please come. The present writ petition is filed. Present CRP is filed. Agreed with the orders passed on I number 27 in OS number 2041 of 2006, dated 25th July 2025 by the by the CCH number 68, Bangalore. The petitioner before this court is a plaintiff in the suit. There is a defendant in the suit. Respondent herein has filed a suit seeking partition. Where is the plaint?
You know, the plate is at ink page. Page 27, my lord.
Page?
27, relevant portion is at 32. Annexure B.
Had filed a suit. Suit for partition. That where do you get the prayer? I'm not able to find it. Where is the prayer?
Page 11, my lord. Ink page 11. My petition CRP.
Yes.
Ink page 11, my lord.
Page 11.
Ink page 11.
What is the running page number?
Correct, my lord. Ink page 11. Running page aged, ink page 11.
What is 11 according to him? Plaint. You don't have the papers?
I have.
And where is the plaint?
Plaint. So certified copy.
His lordship is asking for our CRP. Plain copy, na?
Amended.
That is at page number 33.
Yes, certified copy itself.
A judgment and decree. The cause of each of the, what is this prayer?
No, I have furnished this.
No suit seeking partition,
One
nothing.
seventh share I have sought. Amended plaint, Kotala.
That is here at page 33, amended plaint only.
But prayer I have, but they might not have furnished. 1/7 share I have paid for.
It goes up to 37, my lord, amended plaint.
Ante ಕೊಟ್ನಲ್ಲ.
As stated in the amended plaint copy, it says that the plaintiff prays the court.
In page 33.
Be pleased to pass judgment and decree declaring that the cause of each of the plaintiff have 1/7 share in the suit scheduled property and put them in possession of their share. The defendant herein, the defendant who is a petitioner herein, filed an IA under order 7 rule 11, seeking rejection of the plaint. It is the case that there was a registered partition dated 15/10/1975. In the said partition date, A scheduled property allotted to the share of the defendant's father and B scheduled property is allotted to the mother. C scheduled property is allotted to the share of the brother, elder brother, and D scheduled properties are allotted to the share of the defendant, and E scheduled property is allotted to the younger brother. Thereafter, they have entered into a registered partition deed dated 23/9/1985. Under the above partition deed, A scheduled property allotted to the elder brother, B scheduled property to the defendant's share, and C scheduled property allotted to the share of the younger brother. The plaintiff, the defendant number 1, or the consenting witnesses to the registered partition deed dated 23/9/1985. it is submitted that all these transactions have taken place before the cutoff date in the 2004. And in view of Section 6 of the Succession Act, the petitioner, the plaintiff cannot maintain the suit. The trial court, by order impugned, had dismissed the said application. While dismissing the application, the court has observed that it is the case that in view of Section 6(1) of the Hindu Succession Act, the suit is not maintainable. The court observed that on perusal of the arguments in the plaint, nothing is brought to show that the suit is not maintainable under Section 6(1) of the Hindu Succession Act. Even though in the written statement filed by the defendant number 3, there are various allegations and contentions which goes to show that the suit is not maintainable as contended by the defendant number 3, but as rightly relied upon by the advocate for the plaintiff in civil appeal number 15255 of 2023, wherein the apex court has observed that while considering the question of rejection of the plaint, it is the plaint alone which has to be read meaningfully and not any amendment in the written statement. It is also necessary sometimes to consider the documents annexed to the plaint for a holistic and comprehensive reading of the plaint in order to decide whether the plaint ought to be rejected or not. In view of the same, as there is no mention about any of these facts in the written in the plaint, the court cannot go into all those issues and dismiss the application. Then counsel appearing for the petitioner has drawn the attention of this court that in the amended plaint, in fact, they have accepted that after the death of said B.M. Shamanna, the brothers of the plaintiffs entered into a deed of partition dated 15/12/1979 in respect of the land measuring 17 acres 20 guntas without including the plaintiffs. The same was registered before the sub-registrar, Bangalore South. It is submitted that the admission of the plaintiff is clear in the amended amended plaint that in view of the same, as they are aware of these transactions, and once there is a partition, which is much prior, and that several transactions have taken place pursuant to the said partition, they cannot come before the court. It is a contention of the learned counsel for the plaintiff that there are several documents before the court. They filed, in fact, what is that?
Exhibit D15.
D15.
D7, first D7. no?
D7.
Dated 15/10/1975.
The plaintiff is also a signatory, consenting parties.
That is D19.
D19.
23/9/1985.
Deny the same. It is submitted that the court has failed to consider all these aspects and only on the ground that at the time of considering the application under Order 6 rule, under Order 7 rule 11, only the plaint has to be looked into, had dismissed the petition. Next part. Land counsel.
May make one submission, Lord. Irrespective of the properties mentioned, if one document is admitted, that suffice the requirement of Order 7 rule 11 DCPC. In
It
that
is submitted
context,
that-
I am
it is
seeking lordship
submitted that
indulgence.
If one document is accepted, that itself would be sufficient. And the court ought to have considered the application on the merits of it, basing on the said application. Next para. When counsel appearing for the respondent, plaintiff submits that the counsel for the defendant has relied on the amended plaint, and that admission, even if it has to be considered by the court, it is in respect of plaint.
Item number 2 only.
Plaint item number 2, scheduled property. And it is submitted that basing on that, the entire plaint cannot be rejected. The trial court rightly held that basing on the amendments made in the written statement and the documents filed along with the written statement, the court cannot consider an application under Order 7 rule 11. Further, as a bare reading of the plaint shows that there is a cause of action and that is not barred by any law. and the court has rightly dismissed the application filed under Order 7 Rule 11. Next para, having other counsels on either side, there is a material on record. The plaintiff, according to the plaintiff, there is a prior partition and several transactions have taken place before the cutoff date in the year 2004. As such, there is a bar, and as it is protected under Section 6 of the Succession Act, the plaintiff suit is not maintainable. In support of it, he has drawn the attention of the court to the amended plaint and as rightly submitted by the counsel for the respondent defendant. This is pertaining to suit item number 2 of the suit schedule properties. If this document any of the document is not before the court, as the same was not filed along with the plaint. However, there is an assertion there is an averment in the plaint. Basing on the said averment, the court cannot reject the entire suit, entire plaint. It is well settled that while considering an application under Order 7 Rule 11, the court has to look at the plaint and the documents that are filed along with the plaint, and it cannot look into any other document. The submission that the entire documents are before the court ought to have looked at the same is the said submission has to be rejected, as that is contrary to the settled law. In the considered
That is
opinion
settled
of
law
the
is
court.
very well stated at
It
6
is over. Your submissions are over. It's my art. I'm dictating the judgment. You shouldn't interfere. It is against settled law. Settled law. The trial court has rightly held that the application under Order 7 Rule 11 cannot be rejected. The application under Order 7 Rule 11 cannot be considered, and rightly rejected the application as there are no merits, and in the considered opinion of the court, there are no grounds to interfere. Accordingly dismissed.
Cell number 83, Rakesh V. Bhatt.
Suppression of tax.
Yes.
There is one in this case. It will pass for 2 minutes, my lord. Senior is held up, hotel number 8.
But in this case, but the miscellaneous petition came to be allowed on the ground that, my lord, that page number 25, my lord.
Yes.
Para number 25.
What is this miscellaneous?
My lord, ex parte decree is challenged, my lord, by the defendant before the trial court under Order 9 Rule 13, my lord, stating that the suit was decreed, ex parte decreed on the ground that though notice was sent to them, that was refused by them. The endorsement which had come through postal endorsement was refused. Their case was that they have never refused. They have not received any notice. On that ground, my lord, they filed miscellaneous petition.
What is the suit for?
Lord, suit for declaration and injunction.
Which year it is filed?
2017.
When was it decreed?
Lord, the suit came to be decreed
6/3/2023.
Suit for declaration.
Suit for declaration and injunction, bro. And they
read.
filed miscellaneous petition on 8/6/2023.
Let's read para 25.
25. It is pertinent to note that during the cross-examination of PW1, she has categorically admitted that the address mentioned in Exhibit P7 is proper address. That is the notice for which we had sent, court had sent the notice. Is a proper address of petitioner, and in the normal court, courts, notice sent to the said address reaches to the petitioner. The documentary evidence though indicates that suit summons issued to petitioner respondent in OS number 1595/2017 has been returned as refused by addressee. However, it is a well settled principle of law. The presumption of service on refused endorsement is a rebuttable presumption of fact, not a conclusive proof of law. The petitioner has entered the witness box as PW1 and stated under oath that she never had knowledge of the suit, nor did she refuse suit summons. By doing so,
If it is a rebuttable presumption, then it has to be done by them.
Please, my lord. My lord, Supreme Court judgment is there, my lord, and clearly their judgment where it says that burden of proof is on them. There are 3 enactments, my lord, where that presumption is there. Evidence Act Section 14.
That's what, if the court gives a finding, you should have placed a burden on them to prove it.
Reverse burden is placed on me.
Without doing it,
Reverse burden is placed on me.
yes.
By doing so, the initial burden shifted back to the respondents to prove actual delivery of the suit summons, and petitioner in fact refused it. Para 26. To substantiate that postal person had tendered the suit summons to the petitioner and she refused it, the respondent made no effort to examine concerned postal person. The testimony of the postal person became pivotal to identify the petitioner and alleged fact of her refusal of the suit summons by her. The petitioner has deposed before
Yes,
the court.
I've seen.
Lord, it is covered by judgment, Lord.
Yes.
Lord, the first judgment, Lord, is on the presumption of Supreme Court judgment, Lord. Page number 6.
Para number?
Para number 11. States, my lord, the presumption under section 114 of the Indian Evidence Act. The normal course of things, if post goes, my lord, then the presumption is there.
Yes,
Lord,
next.
kindly take, my lord, page number 10, that is another Supreme Court judgment, Gujarat Electricity Board versus Atmaram. Similar facts and circumstances, Lord. The relevant portion is at page number 15. And these judgments were placed on record before the trial court also, my lord. None of them were considered. Para number 50, page number 15, para number 8, in page number 7, in para number 7, my lord, page number 15.
Yes.
8 line, after in between, my lord, 24/4/1974, it is written down around 10 lines, my lord.
Yes.
It was further pleaded that the respondent has refused to accept the registered letter and the same has been returned back by postal authorities with an endorsement that the addressee refused to accept the same. It was also in the rejoinder affidavit, the respondent denied the aforesaid allegation and asserted that letter has not been tendered to him and he never refused to accept the registered cover and postal endorsement was wrong and incorrect. This was also similar contention that was taken. Para number 8, that contention, my lord, the court considered. Sixth line, my lord. The burden to rebut the presumption lies on the party challenging the factum of service. In the instant case, the respondent failed to discharge this burden as he failed to place material before the court to show that the endorsement made by the postal authority was wrong and incorrect. Thereafter, mere denial made by the respondent in the circumstances of the case was not sufficient to rebut the presumption.
Yes, next one.
Related. Next is Allahabad High Court judgment, where the question was as to who has to tender the evidence of the postal authority to rebut the presumption.
Para number?
Para number 41 and 42, page number 27. Even in this case, the trial court initially held that the burden was on the defendant.
Some running pages are there. What is the number?
Page number 27, my lord. 27.
Oh.
Running page number 27, para number 41.
Yes.
If I am permitted to read this. In the present case, the revisional court has taken a different view after considering 3 enactments, my lord, Post Act as well as the other acts. Different view so as to reverse the finding of the trial court in the respect of service of notice only on the ground that plaintiff landlord ought to have examined postman, and unless he is so examined, his endorsement of refusal cannot be treated as to be an evidence to draw a presumption in favor of the service upon tenant when the tenant simply denies service upon him. He has found that the address given on the registered letter was correct, yet only on the ground that postman having not been examined by landlord, the revisional court in the holding that endorsement of refusal cannot be treated as an evidence to draw presumption of service has acted wholly illegal, and aforesaid view taken by the revisional court in view of exposition of law discussed herein above cannot sustain. When an endorsement made by the postman by virtue of section 14 of 1898 Act, that is Post Act, is to be treated as a prima facie evidence of correctness of endorsement, this is a statutory presumption of evidence and cannot be rebutted by the addressee by adducing adequate can be rebutted by the addressee by adducing adequate evidence, failing which it is addressee who will fail and not the sender. It is thus for the addressee to examine the postman to demonstrate that the endorsement made by him postman is not correct, and mere fact that sender could not identify the postman would make no difference since it is wholly irrelevant. Further, my lord, another judgment is also on the same aspect.
Yes. Yes.
But actually, one fundamental issue which I had to raise, my lord, was the petitioner here, the plaintiff has not come here seeking setting aside of the
Who
miscellaneous.
is he?
He's a subsequent purchaser post
I am a party to
miscellaneous.
the, they have only made me a party to the miscellaneous petition.
No, the restored suit I made him a party.
No,
In the miscellaneous also.
in the miscellaneous only they have made me a
Miscellaneous.
party.
So he's not the plaintiff has accepted this verdict. In such a situation, Lord, the plaintiff now his suit as to declaration, he has to test it, and it is contested. The question is identity of properties. I have title. My stream of title comes from a certain origin. They claim that their title is on a different number.
What do you say on
Matter
that?
has to be
So
by
far
default.
as
How can you
this
get
is
a
concerned,
declaration?
Lord, suit is declaration, suit for declaration is decreed. Thereafter, my lord,
No, that is, that is his suit.
Yes.
my lord,
Plaintiff, you are,
plaintiff
no,
suit.
you are one of the defendant.
No, my lord, I am also, I am a subsequent purchaser. What
Now
happens?
defendant.
Suit for plaintiff files suit for declaration. Suit is decreed, declaration is given. Thereafter, he sells the property in my favor. After selling of this property in my favor, when after my name is entered in the revenue records, thereafter they file this miscellaneous petition, making me also a party. Then they seek an injunction against me that not to alienate the property. For all that, my lord, they had no qualm. At that point of time, they said that I am a necessary party to these proceedings. They made me a party to the miscellaneous petition. When I suffered an order in the miscellaneous petition and I filed this appeal, now they say I am not a necessary party. The appeal filed by me is not maintainable.
5/7/23, my lord. 5/7/23. The miscellaneous is served on the original plaintiff.
Yes.
On 26/7/23, they purchase. After the miscellaneous is filed and after it is served on the plaintiff, he purchases, he sells this property on 26/7/23. After the miscellaneous notice is served. Contest.
Consider this.
Please,
Yes, what is it?
please, publish.
Bill number 84. Is that true?
I appear for respondent number 2 in this matter. Kindly seek for an adjournment of 1 week, my lord. Senior counsel is available today.
There is no urgency, my lord. I consent. I have an interim order. It may be leisurely consent.
List this matter in the month of September.
My lord.
Interim orders needed.
Because it's difficult, please understand to the court to hear the matters again and again. I'm not able to complete one list. Every day morning, 100 people are, 100 advocates want memos. So that's why I'm telling, once it is out of the list, it is out of the list. I can't, same matter, I can't keep on hearing. List on 2nd of September.
Great.
Interim order earlier granted is extended.
Bill number
Delete from this 230 list.
Yes.
Hmm.
Bill number 85.
So appear for the petitioner. It's question of reckoning 120 days in filing written statement in a commercial court matter. my lords.
Give that. 2025 matter.
Please, my lords. There is an interim order of stay, my lords.
Oh.
Now,
Yes.
suit is stayed.
Commercial suit?
Commercial suit, my lords. Commercial suit. Because what happened was, suit summons were served on 1/5/24 on us, but it did not accompany with the plaint. The plaint was accompanied by the summons through the ameen that was served, my lords, on 23/5/2024. If 23/5/2024 is reckoned, my lords, that 120 days end on 20th September 2024, my lords.
When did you file?
I filed it on 20th September 2024, my lords. The court says it's not 20th September, it is 21st September. And secondly, it says, my lords, I have not said anything.
So if the court says 21st September, then we have to take it as 21st September.
Reckoning is not correct.
No. Even if that is reckoned from 23/5/2024, according to you, 120 days is 20th September 2020. But you filed a day after.
No, I filed it on 21st only, 20th only. Court says on that date is 121 days.
Oh,
Please, ma'am.
what do you say?
No. That is not the one.
Let's kindly see, my lords.
Lord, what happened? So he says that he has sent the return statement on 120th day through email to the court. That's what their contention. From 23rd September, May 2024, you deduct that first day, it falls on 20th September 2024 is 120 days. He says on that day I've sent the return statement along with the truth of facts and other things duly notarized at Ooty through email. That email copy is
No.
not produced.
It says about filing, isn't it? Not sending, signing. Not the signing the return statement and sending. When they say 120 days, this is about filing in the registry.
And what happened was on 3/9/2024, I filed an application under section 148. Kindly grant me 8 weeks time to file my return statement. That application was allowed by the Honorable Court and posted the matter to a next day, 21st September 2024, my lords. The matter was posted for filing for the next date on 21st September 2024, my lords. My
Yes.
application for extension of written statement was allowed on 3/9/2024, my lords.
Then why if the matter is not listed, you can't file the written statement in the section?
He was in Ooty, my lords. We were in Ooty, my lords.
But what to do? When there is a specific timeline, you have to adhere to that. Any judgments saying that even under the Commercial Courts Act also, all this, because it is only 1 day delay, we have
The
to
question of delay doesn't arise, my lords.
It is.
Because
you have
there's no
not-
provision for condonation of delay. Beyond 120 days, no time.
You have not filed this written statement by 20th September. You filed it on 21st September. There is a delay of 1 more day. We will not consider all these emails, sending it, signing it. Have you filed it or not is the question.
Lords, may I pass on the
Even they have not filed.
order sheet.
Take that.
No, even they have not filed that the return statement on the green sheet of papers on 21st. They filed it on 21/10.
Yes. What is to be looked into?
My lords, kindly see 3/9/24
Like-
order sheet, my lords.
3/9/24.
Page
Yes.
number 12.
3/9. I
Next
don't find
page
it.
page over. 11, page number 11 is 3/9/24. Page number 12, my lords.
Page number 12.
Plaintiff and
3/9.
3/9. Plaintiff and counsel are absent. The counsel for the defendants filed IA number 4 under 148 CPC to grant further time for filing written statement. Heard allowed. Heard both sides on IA number 2. Defendants filed citations. Call on for orders on 17/9/24, my lords. Not ready. Want of a stenographer. Call on 21/9/24, my lords. So on 21/9/24, this is what the office notes, my lords. Written statement through email to this office and same is put up herewith. The defendant number 3 sent letter along with memo of adoption through mail. Same is put up here.
What is the procedure in the commercial courts? How do you file the written statement?
Plus e-filing is also there, my lords. E-filing is also permitted. And kindly see the order of the court on 21st September, my lords. Case called out. Office has put up note that defendant 1 and 2 have sent the written statement to this court through email. Printouts have been taken by the office. Same are kept in the file. Counsel for the defendant is also present.
So that's the mode of filing the written statement in commercial court.
No.
Email is permitted, my lords.
There is
It's
no
not
such
that it's
thing
not,
at all. Let him produce it.
That's not.
Or you will let him produce that email copy what he has sent and what court has received. They could have produced that before the
Please
Honorable
send
Court.
what is that you have sent?
Yes.
By way of email. Does this matter at 2:30 on 29th? On 30th July? Yes.
Interim order.
Interim order granted.
Yes.
Is continued. Number 33. V. Manjunath Prasad.
But landlord has let out the first premises to me as a tenant, and the adjacent bit of land was there. Code authorities have allotted the same to the landlord. The
Come to
same
your
also.
prayer first, let me understand. What are you seeking? To take up any action to disconnect the electrification existing the scheduled premises, set aside the recommendation of the first respondent, vigilance stated, What is this prayer?
My prayer is to not to disconnect the electrification since port
No,
4205
where
is
do you
not.
get this vigilance, CESC vigilance?
Yes, my lord, he is the
report?
authority. He is the, we visited this spot and initiated the, no, we visited this spot and initiated the notice upon us.
So you will question that order before this court.
No, my lord, what happened?
You will not go to them.
My lord, he cannot, he initiated under 4205. Kindly, we please read this, I am permitted
Yes,
to read.
Mr. Devraj, what is?
That vigilance was inspected,
Huh.
found not the unauthorized extension of the load.
Mm.
Therefore, vigilance has recommended to the assessing officer assess the quantify the electricity.
Mm.
Then procedure has to be followed. But in for this, that annexure that which has been challenged is the internal communication.
That's what I'm saying.
Yes, after that it is yesterday, the provisional demand notice has been issued to the consumer saying that this is a back billing. 15 days time has been given to file objections, or otherwise 30 days you pay amount and regularize what that unauthorized extension is there. That is the notice which has been issued that have.
But you have to question.
That I have served to copy to him also.
That's what happened. At the time of filing the petition, this transaction was not held.
Anyhow, now it has come.
4205 made it.
Understand.
My lord,
Again, as the internal correspondent, you cannot file a writ
My lord,
petition.
4205 made it very clear and the forthwith it has to be disconnected by the vigilance. As such, we filed the writ petition. In the meantime, the internal
Yes, please
correspondence
come.
filed. I request
The
your
writ
lordship
petition
to
is filed.
take the present
Writ
recommendation
petition
and
is
file
filed, seeking
and
the following prayer.
dispose the
Land counsel
accordingly.
for the petitioner. Huh?
Already they have issued another notice to landlord. The same has to be taken on record. I'm ready to
Yes,
pay
take
the.
that. The
And dispose it accordingly, your lordship.
the respondent, the writ petition is filed.
I'm ready to pay the
Seeking
back bill.
Seeing the following prayer. After filing of the note, this court has ordered notice to, has directed Mr. Devraj to take notice on behalf of BESCOM.
SESCOM, Chamundeshwari.
SESCOM. Land counsel for the, counsel for the respondent on instructions submits that the petitioner is seeking the
Smashing of the annexure.
Annexure, any the internal
it is submitted that the proceedings dated 10/7/2026 is an internal correspondence and questioning that he cannot file a writ petition. It is submitted that basing on a report by the Assistant Executive Engineer,
Vigilance.
CESC Vigilance, Mysore, they have issued a notice to the landlord on 22nd July 2026. What it says?
That it says that 15 days time to file objection to this notice, or otherwise to pay that back billing charges of rupees 41,107, or to regularize that unauthorized extension load.
They have issued a show cause notice to pay the,
to file objections.
to file the objections
And
or
class 4202, please.
or file the, or pay the amount of rupees
42,107 rupees.
42,107 rupees. It is submitted that.
Under class
Now
42.
the petitioner has to, petitioner oblique the landlord has to respond to the same. And after receiving the response of the petitioner, they will take appropriate action. It is submitted that till such time, the respondent will not resort to, they will not take any coercive steps. Next, considering the fact that already a notice is issued, the petitioner shall respond to the same. And after receiving the response, the respondent shall pass appropriate orders in accordance with law. Till the appropriate orders are passed, the respondent shall not take any coercive steps.
Timeline to submit reply that within 2 weeks.
No, just now you have given, as per that.
Yes, sir.
As per that.
I'm the tenant.
As per notice.
As per the notice.
34, cell number 34, Aniket, VC for petitioner.
Give it us.
Yes.
For the petitioner. Well, the petitioner is the JDR in the execution proceedings, my lord. The impugn order is arising out of an impleading application which was filed by the JDR, wherein the parties sought to be impleaded are parties to the compromise petition. The situation, the nutshell of the facts here, my lord, the DHRs in this petition, in the execution, only are 2, whereas the compromise petition contained other 4 also. The application which was filed was to implead the remaining 4 so that the real issue can be inquired.
The decree that is sought to be executed is a compromise decree.
Please, madam.
How many are the parties in a compromise decree?
My lord, kindly, the same will be at page 72, my lord. The verification I'm showing how many are there.
70?
72.
Hmm.
No, my lord.
There are about 5 parties.
Please, my lord. Now, DHR 1 and 2 are Sir Rafiullah Beg and Farah Beg. Zabiullah Beg and Farah. These two are the DHRs, my lord. The remaining, my lord, that is
Zabibullah
Nikhil,
Beg and
Farah Beg. Rafi,
where is
sorry.
he?
Farah Rafi, my lord.
He's not there in this
In the
compromise.
bottom, my lord. First line bottom. Mrs. Farah. Now, these two are the DHRs. my lord. I am saying that they form part of a Rafi and Co entity, which are basically together the family members.
No, I can see plaintiff number 4.
Please.
Zabibullah Beg.
Please.
And other one is
My lord, other one is Rafiullah Beg. my lord.
Rahil Beg.
Please.
Or Rafi Beg. There are-
Farah Rafi is one DHR number 2 and DHR number 1 is Zabibullah Beg.
Hmm.
Now only these two are filed the petition, my lord. Now the remaining petition DHR.
What is the nature of the compromise decree?
My lord, the nature of the compromise petition is that as far as the certain undivided interest is concerned, my lord, it was divided. As far as the developer, I retained few, and the remaining parties remained the few. Now, pursuant to the compromise petition, my lord, there was further agreements entered into. That is after the award, when it said that since it was undivided interest was divided, the actual amount of apartments which was to be segregated and how many units were entered into. Now, during that time, whatever expenses and expenses that I incurred, it was agreed that there was a reserve of 15 apartments. Now, these 15 apartments, I am holding on to it. Today, they have come by filing this execution petition, asking to return of those 15 apartments in the absence of the others. That is all I am saying, my lord.
No. When what is now sought to be executed is a compromise decree.
Please.
Whoever are parties to the compromise will be the parties.
Everyone are
And
not.
any other agreements you have entered in between, how the court will look into all that?
I am only giving the nature as to what all has happened, but the fact remains is, my lord, all the DHRs are not there before this court, before the trial court. All I am saying, let them be implemented. I have filed an application under 47 for inquiry for the very reason that the remaining people are not on record. I have executed a sale deed against a third party who has also filed an application as an objector. In view of that, my lord, there's an inquiry application pending. All I'm saying, if they come on record, the inquiry can be completed. And they have filed an affidavit, my lord, saying that why they should not be.
You are the developer.
Please, my lord.
As per the decree, so 1 is entitled to this, 2 is entitled to this, and 3 is entitled. That everybody's right is crystallized. In that case,
pursuant to the compromise petition.
Pursuant to the compromise.
Please.
That compromise, everybody, whoever is aggrieved, if according to now, for example, you as far as 1, 3, plaintiff number 1 and 3 is concerned, you have already satisfied the decrees. And 2 and 4, you have not satisfied the decree.
My lord, I am not saying that they are. It's only them. It is the remaining also.
That is what I am asking. Why should they be?
My lord, the reason is because I am questioning that affidavit. I am questioning that affidavit doesn't
come
even.
Come to the order, impugned. I understood.
My lord, the compromise petition had only undivided interest. Now, the pursuant to that, how many units meets and bounds were not
Let's
done.
see the compromise decree.
No, that is at page.
Page 60 is the table.
Page number?
60. I'm sorry to interject. 60.
52 onwards is the petition.
Yes, very clearly demarcating who gets what.
Undivided interest in the larger extent.
65,180.4.
65,180.4.
Yes, the units are mentioned in the 4th column, it's 5th column.
130 flats.
Yes, 130 flats goes to them. That is to the petitioner here. 4 flats goes to Nikhil Construction, who's another developer, it's not related. 58 flats plus 10 flats come to our
130 flats out of?
My lords, totally.
Kindly come to page 60 of the compromise petition.
Yes, page 60.
I'm looking at page 60.
Yes, my lord. Now, we are only concerned of
number.
number 3, my lord, that is Rafi and Co. Rafi and Co, with the DHRs are forming part of Rafi and Co. They get 58 flats plus 10 of 2 bedroom and then 10 flats of 1 bedroom. Now, out of that, my lord, there was a.
So there is no independent entitlement.
No, my lord. all collectively, then pursuant to it, there was an interest sharing agreement.
No,
where
all of these plaintiffs are, they're referred to as Rafi and Co.
Please, now Rafi and Co has
Family
been,
members.
as per this compromise petition, it is only one person who is authorized on their behalf to act on behalf. And internally, they will do the arrangement. That during that time, a lot 15 units were kept aside. All I'm saying is now, along with this 15 units.
Come to the order.
No, the order will start at page 33, my lord. The reasoning starts from page 5. Now, besides the repetition of the pleadings, my lord, the actual part starts from para 9. These judgments, which the Honorable Trial Court has referred to at page 42, is not referred by either of the parties. Now, relying on these two judgments, my lord, it goes on to again to say that while I have disputed that the affidavits relied by them or rather produced by them is not valid because it's not probably notarized.
Yes, what is?
Well, it's fairly simple. There are 6 owners who are all family members. Now, a compromise decree is passed before the Lok Adalat saying that out of all these apartments, some apartments go to them, some apartments go to Nikhil Construction, some apartments go to the family. The family inter se, my lords, have organized it in such a way that I get, my lords, 44 apartments. Now, it is no dispute that he has already satisfied the other family members. Only 15 apartments now have to be given to us. That, my lords, is stated in the execution petition.
No, what is the difficulty if they are there before the court?
No, I filed affidavits. My lords, this is all. My lords, this is a delaying tactic. I'll point out, my lords, what the issue is. I have filed affidavits of all my family members saying that I have fully satisfied with the decree. My lords may see he has not produced those affidavits.
If they are parties to the execution proceedings, how it is going to delay the process?
My lords, what will happen is this. These individuals now are not in Bangalore. Now notice has to go. My lords, the execution is pending for 3 years. There's a direction from a coordinate bench saying it has to be done within 6 months owing to the order of Rahul S. Shah. To avoid all that, now new applications are being filed. 8, my lords, applications are pending in an execution.
No, you can say that, you can give their email addresses. Within no time, you can file your wakalat
my lords, may I just
before
point
the
out,
court.
legally, my lords, is not permissible. I'll just point out, my lords may just see this memo for a moment.
Take that.
My lords may just see this for a moment.
Why it is not legally permissible?
I'll point out. I'll point out from order 22 rule 15.
In the nature of this kind of the compromise.
Let me point that out.
Very much necessary that all of them should be parties.
My lords may just see page number 1. Each of those individuals, my lords, have filed affidavits duly notarized. Rafi Beg says, page number 1, I state that I am one of the several joint and absolute owners of so and so. My lords may see paragraph number 2. I state I have been made aware that certain owners of the aforementioned property are filing legal proceedings in order to recover possession of 15 apartments in building numbers 4 and 5. This is one portion which has to be given. 3, I state I have already received my share of the apartments from the other owners and I do not have any claim in the 15 apartments building numbers 4 and 5 in the Ranka colony. Hence, I will not be arrayed as a plaintiff. However, I unequivocally support the claim of the plaintiffs / other owners. The husband of one of the decree holders was.
No, I understand that they have given affidavits.
Then my lords will see the next page, page number 2. Asrafullah Beg has also filed this affidavit. This is not produced by them in the petition.
No,
page number 3.
My oversight was not produced.
No, it can't be oversight. That's the basis of the order. The basis of the order, these affidavits.
We have a memo ready.
Then my lords will see page number 3.
In fact, this affidavit is not even
let me just
properly
finish.
notarized.
Let me just finish. Page number 3. Rahil Beg, who my lords is the son of Fasi Beg, so and so. He also files an affidavit. Then page number 4. Gajendra Char also files the same affidavit, saying that, see, this is a case wherein all other decree holders have been satisfied. There is no reason for them to be brought in as decree holders in the execution. The only 2 people who are aggrieved, my lords, are the 2 decree holders here who have filed the execution petition because 15 apartments have to come to them. Now, my lords, what the court says is that, see, look here, they have filed affidavits, duly notarized affidavits saying that they are fully satisfied. Why should they be brought for no reason? There's no dispute at all with so far as them being satisfied. They're filing affidavits saying that has been done. Now, my lords, what had happened was.
Now, tomorrow they say that I have not filed the affidavit.
No, that's not the case. That's not the case. These are all affidavits filed.
They might say.
Respectfully, my lord.
Why should we complicate things?
We're not. My lords may just.
Easy ways, let all of them be before the court.
No, my lords.
The court decide.
The difficulty is this. My lords may just see order 20.
There is something which the court is not able to understand and see.
Two legal issues which has to be overcome by the other side. One, in an execution, when I am the decree holder, my lords, can they, my lords, impose upon me that there are other decree holders have to be brought in?
Because the decree is of that nature.
No, my lords may see order 22.
There are about 65 apartments.
My lords may see order 22 rule 15. Please kindly have a look at order 22 rule 15.
He's the judgment debtor. Whatever the complications or the implications of this, he has to face it.
Absolutely. Absolutely, ma'am.
It is a very simple exercise. If you're not acceptable to that, I don't understand why it is. When all of you are before the court, whatever the order, instead of filing these affidavits.
They are saying they've been satisfied fully, my lords. Now, to impose upon the plaintiff, who is dominus litis effectively, to say, no, no, you include other plaintiffs also, my lords, in my humble submission, is not legally reasonable.
Execution proceedings.
Even in execution, my lords,
Yes.
in a suit, if he has,
No,
if
that
he is
would
considered to
be
be
a,
dominus
that
litis,
would be a quietus.
my lords may just see order 22, rule 15.
Order?
22,
Yes.
rule 15. Just for a moment, my lords.
Yes.
Application for execution by joint decree holders.
Hmm.
1. Where a decree has been passed jointly in favor of more persons than one.
Hmm.
Any one or more of such persons may, unless the decree imposes any condition to the contrary, only if the decree imposes a condition, apply for the execution of the whole decree for the benefit of them all, or where any of them has died for the benefit of the survivors and legal representatives of the deceased. All I'm saying is this. There are, my lord, 6 decree holders. Admittedly, 6 decree holders.
It
Now,
is not filed on their behalf.
no, not at all. 4 of them have said, I have completely received all my share.
That's where the distinction is. No.
Affidavits have been filed.
Huh?
Affidavits have been filed.
Affidavits can't.
And
be-
order
they can't
22 rule
take-
15 says that any one person can file if he is aggrieved. If he satisfies in part.
I understand that is precisely what I have asked in the beginning.
Yes.
But considering the compromise decree
Yes.
and what is the nature of it.
Yes.
For that, the presence of all the parties is required.
Lords, we
Let the
see-
court decide when they are before the court.
My lords, that will delay proceedings even further. My lords, let me put it this way, my lords. Let me look at it very, very straightforward. If they are saying that the other 4 people need to be there for them to give the 4 apartments, are they saying then that they're ready to give the 15 apartments? He's not ready to give the 15 apartments. He's saying you bring them, then we will see.
That is the second part where the inquiry
that
is
cannot be.
pending. I
See,
have
that
filed a
cannot be.
specific application for inquiry because third party interest is created. The
This is
person
not
who is
a
not a
case.
DHR today has executed a sale deed against a third party who has also filed an objector application. All I'm
This
saying,
is
let
the-
the
this is
inquiry
the
happen.
complicate. This is what he's
Because
trying
in
to
their
complicate.
absence, these 2 DHRs are
Then you, both of you will settle whatever the future complications that are going to arise as far as the issue before this court. I'll allow the writ petition.
My lords, may just one judgment, my lords, I'll just
Yes.
place.
Yes, yes.
I'll just cite that judgment, my lords. My lords may consider that. Also on housekeeping, my lords, this is an order 1 rule 10 application. A writ petition is not maintainable. A CRP is what had to be filed. Just housekeeping, my lords, I'm pointing that out. The judgment of Andhra Pradesh High Court. I'll just-
How it is, how the, why a CRP? What will happen if this application is not allowed?
The writ is not maintainable. Under 115, they have to file a CRP. That is a requirement. Even in fact, this court has also held previously on an
Let's see
impleading
that.
application.
Yes.
Can I show, my lords, the first judgment on the issue of impleading in an execution petition, my lords? This is the division bench, my lords, of the single judge of the Andhra Pradesh High Court. This is in Jaganti Lakshmi Rajan versus Kolla Rama Rao. My lords may see
Yes.
paragraph number 10. Para 10.
Yes,
The next question is whether Order 1 Rule 10 has application to all proceedings other than suits and appeals. A division bench of this court in Sardar Ali Khan versus S Deputy Collector. The scope and application of Order 1 Rule 10 is to add parties necessary or proper to enable the court to effectually and completely adjudicate all the questions which are involved in a case. The use of the words at any stage of the proceeding in Sub-Rule 2 of Rule 10 in Order 1 manifests that the power vested in the court under that provision can be exercised only when the proceedings before it are alive and still pending. In other words, the application of Order 1 Rule 10 should be confined only to cases where any proceedings are pending before the court. The very purpose and object of this provision being to make any party a defendant or respondent or plaintiff or appellant in a proceeding in order to enable the court to make an effective and complete adjudication itself of all the disputes in the case is over. This provision cannot be made use by any party. The division bench, in order to come to the said conclusion, relied on a decision reported in Lingamal versus so-and-so. Therefore, we have no hesitation to hold that an application to implead as parties to the execution petition is not maintainable after disposal of the suit. Now, insofar as revision petition, my lords, there is a judgment of this honorable court. My lords may see that as well.
Yes.
My lords, that is in Ashwatthama versus Vijay Raghava. This is a 1998 judgment, my lords. I just pass this on.
Yes.
My lords, may see just para 1. Revision is under section 115 of the Code of Civil Procedure from the order dated so-and-so passed in FTP proceedings, allowing the impleadment of the respondent as defendant number 4. this was, CRP was preferred, my lords. My lords may just see para 9, 10 and 11, where it says a revision is maintainable. I have applied my mind to the contentions raised by the learned counsel for the parties. The first essential condition to be established is whether the order allowing impleadment of a party under Order 1 Rule 10 can be said to amount to a case decided. The expression case decided is an important factor, which is one of the essential conditions to be established before the jurisdiction of this court can be agitated or called for being exercised. Under section 115 of the code, explanation to section 115 is provided. I won't read that. The court in the case of Muhammad Ali versus Dawood Basha has laid down as under. The order and explanation is not used in the general ordinary sense of the term. The expression order has been defined in the code with a subsection 14 of section 2 of the CPC. Under section 14 of section 2, that order means the formal expression of any decision of a civil court which is not a decree. This definition of expression order has to be taken into view when it is required to be considered whether a particular order amounts to a case decided. Because it is well established, well settled principle of rule of interpretation that if words or expressions used in the act are defined in the act as per definition clause therefore, then for the interpretation of the words and expression used and defined in the act, we must look into the definitions given therein. We are not concerned with any presumed legislative intent. The exception to this general rule are cases where context or subject otherwise requires. Therefore, the expression order used in explanation to section 115 of the code and must mean the expression of any decision of a civil court which is not a decree. Thus, considered an order amounting to a decision of some right or dispute as to a right, even if interlocutory in nature, may amount to be a case decided under 115. That's all under 115. The decision means and postulates there must be a dispute with regard to certain rights may be.
The court has extracted the judgment in some other case.
Yes, I'm pointing out the extract of the other judgment, my lords, in Muhammad Ali versus Dawood Basha, which goes into this question of whether in an impleadment application, whether it constitutes an order which has attained finality or not. Because under section 115, considering the fact that this is an order, he had to have filed a section 115 CRP, not a writ petition, my lords, under 227. It's only supervisory jurisdiction as to how, my lords, whether they have gone beyond jurisdiction or not. Unlike a CRP, for this consideration to be looked at, it had to be, my lords, just housekeeping. It comes before the same bench, I completely admit, but he had to have filed a CRP is what I'm saying. That's what, my lords, this honorable court also holds. All I'm saying, lords.
No, when 115 is invoked and when 227 is invoked,
my lords,
forget about this.
Yes, let me point.
Read the plain language that is employed in 115.
Yes. I'll just digress for a moment, academic interest. If before the commercial court there is a matter, let's assume an impleadment application, because revision is specifically barred under the Commercial Courts Act, then 227 may be the only remedy available, my lords, if it is maintainable under 227. In this case, the 115 is not barred. It is from, my lords, a regular civil suit.
We are not on commercial court or a regular suit.
Yes.
You are on a point in an execution petition, Order 1 Rule 10 is filed and that is dismissed.
Yes.
According to you, the remedy is CRP.
Correct.
So that is under 115. So what is 115
My two submissions, my lord. One is Order 1 Rule 10 is not applicable in execution proceedings. The second submission is,
that we will see.
The second submission is, my lords may see 115. There is no reason why this order would not fall under 115 is a simple submission.
Yes.
If my lords will see 1151.
1 minute. Yes.
The High Court may call for the record of any case which has been decided by any court subordinate to such High Court and in which no appeal lies thereto. In this case, no appeal lies under Order 1 Rule 10. And if such subordinate court appears, A, to have exercised a jurisdiction not vested in it by law, B, to have failed to exercise a jurisdiction so vested, C, to have acted in the exercise of its jurisdiction illegally or with material irregularity, the High Court may make such order.
Provided.
Yes, I'll come to that. The High Court may make such order in the case as it thinks fit, provided that the High Court shall not, under this section, vary or reverse any order made or any order deciding an issue in the course of a suit or other proceedings, except where the order, if it had been made in favor of the party applying for revision, would have finally disposed of the suit or other proceedings. So this proviso will only apply if that order has finally decided the suit. That doesn't apply here.
That's why it is a writ petition.
No. This proviso, my lords, is an exception, saying that provided that the High Court shall not, under this section, vary or reverse any order made or any order deciding an issue. So this limitation only applies if that order happens to finally decide the case. That is the reason, my lords, this judgment of the Karnataka High Court, my lords, looks at that aspect and says that the impleading has to be a revision. And in fact, it was a revision which was filed.
Yes. Anything?
All I'm saying, my lords, is this. There's no necessity, my lords, for them to be made parties. I am the only decree holder who's aggrieved. Now, by delaying issuing notice to all of them, my lords, in my humble submission, my lords, would defeat the purpose of an execution. There's multiple judgment from Rahul S. Shah, my lords, to Periyamal, says within 6 months execution has to be disposed of. I come to the court, I get a direction, my lords, the direction is also expired because they filed 8 applications.
The compromise decree or that is the memo that is filed before the court is very clear about what is your property, what is others' property, then what proposition you're submitting might be true, but not in a case of this nature, where Rafi and company, there are about 4 people, just say 65,000 or 65 units. Where are those 65 units? How is it? There should be, execution should be a complete
May I show my lords the execution petition for a moment, my lord? Before my lords considers this matter on merits, my lords may just see the execution petition. I've made a
it is not, it is, we have to look at not the execution petition. We have to look at the compromise decree that is passed.
No,
How
this
it
is
has
in
to be
line with the
executed.
compromise decree. May I just point that out? Just for a moment, a
Yes.
moment. My lords may see the execution petition at page 159.
Yes.
My lords may come to page number 164 onwards.
Yes.
164, my lords, is what is stated in the compromise petition, 1, 2, and 3. Rafi and Co. 58 flats and 10 flats. My lords may see
58
that.
flats.
Yes, yes.
58 flats, 2-bedroom flats, 10 flats, 1-bedroom flats.
Yes,
That's what
my lords
it
may
says.
now come to 14, my lords. 14.
40.
14. The next paragraph.
14.
Yes. The said allotment of flats is done to the decree holders as per the table below. No dispute about this. My lords may see this. Rafi Beg 5 flats. Rahil Beg 5 flats. Asrafullah Beg 11 flats. Now Zabiullah Beg and Farha Rafi, who are the decree holders who have filed the execution, 44 flats, out of which only 15 are not given.
Where is he getting this?
No dispute on that. Gajendra Achar 3 flats. This is the division.
Where
My lord
is
may
he
see
getting
from
this
his
division?
objections, has he denied
This is what precisely I'm asking you from the beginning.
No, I was not allowed to submit. He was
No,
submitting.
you have shown me that the other table, and
I
there
had
it
to
is
show
not
my
there.
lords the other table. This is the division, my lords. They're not disputing it. All I'm saying, my lords, is this.
This
My
is
lords
part
may
of
see the
his
bona
execution.
fides. May see the bona fides. See the decree holder
No,
since
no, no.
2014.
No, after this table, not required. Yes.
My lord, this table is a creation of him. my lord.
No.
This is not part of the this is not part of the compromise petition.
No.
Please
He's
show where
blowing
is
hot
it-
and cold.
Where is it in the compromise petition? This is subsequent agreements which I have said, let the inquiry happen.
At least there should be clarity on facts.
No.
Is it part of the compromise decree or this is something which you're showing before the court?
My lords will see the objections he has filed. He has produced those objections. Has he denied this, my lords?
No, it's not about my objections.
No,
The
it has to
compromise
be.
Petition doesn't talk about.
No, my lords will
serial
see
number.
this.
I'm just asking you one simple question, Mr. Counsel.
It
Is
is-
it part of the compromise decree?
My lords, what had happened was, let me point out.
First of all, you have to answer, then you can submit whatever you want.
Yes and no, my lords, yes and no.
Is it a part of the compromise decree?
The second table is not part of the compromise decree.
Then
However, he has produced a document himself saying that the second table is the correct table between the families. That is what I'm trying to point out. My lords, he is admitting that. He is admitting that
Where
the
is
50.
that?
Yes. My lords may see the documents which he has produced.
Page number?
Just one moment, please.
No, these are the documents which I'm saying, let the inquiry, let the
No.
trial
It
court
cannot
take
be
up.
both ways.
Because at one side, they don't produce these documents. I have produced these documents. They have not, this
My lords
15
may come to-
apartments are entitled to everyone.
Forget about the parties. Counsel should submit the facts.
I am
That is
saying it's
precisely
not
what I'm saying.
Much required.
Has he produced a document to show this table? Yes.
Yes.
My lords may
Where is
see
that
page
subject?
115. my lords. Page 115. 115. This is a document produced by my learned friend, not by me. The document starts, my lords, at page 112. And I'll show his pleadings where he is saying that this is a document executed at page 112. It's an internal area sharing agreement, which he has also signed. My lords, his signatures at page 113, Ranka Developers. The internal arrangement, my lords, is at page 115.
Yes, please come. The petition is, the
My lord,
petitioner
these
judgment.
contentions has been stated in the trial court that these agreements are not reliable on him.
No.
Now today they are saying I have
He has
it.
produced
I
it.
have been time and
Petitioner.
again saying this 15 units are reserved
Agreed
units.
with orders
And
passed
it
in
can
I
only be
number
entitled
8,
after 2028. They are prematurely trying to come and take it.
CCH 22, Bangalore. In execution number 25202 2023, date 22nd June 2026. The petitioner is before this court. The parties, where is that compromise decree?
My lords, compromise decree starts at page 52.
The parties have entered into a compromise in OS number 15048 of 2006. Dated
My lords, the compromise petition is dated 3/2/2014.
3/2/2014.
It's
As
before
per
the
this-
Lok Adalat.
Before the Lok Adalat, as
If
per
I
the
may,
same.
one correction, my lord. Just earlier to that particular document, my lord, para number at 114, it clearly says why these 15 apartments I am holding on to it. Today
that
they are
may be
coming-
different.
That is what I am
That
saying.
has nothing to do with the
They are-
pleading.
It's premature for them to come and take up this contention. I am entitled to hold this till 2028.
That you
That
agitate.
is exactly what I am saying.
That you tell the
That is
court.
anyway open.
My lord, I filed my application for inquiry because third party interest.
That's a
has been
separate
created.
application, my lords, nothing to do
I
with
mean
the
that
pleading.
because this third party interest has been created by the other DHRs who are not on record. Today they're by clever drafting, they're saying 15 they're entitled to. Why am I holding on to this?
Yes, please
15?
come. The Rafi and Company, which has the undivided interest in the larger extent, is 29,291. Super built-up area 60,200 square feet. That is 30.29%. Units in building, it's 58 flats, 2-bedroom flats, 10 flats, 1-bedroom flats. Thereafter, it is a case of the plaintiffs are where is the, just now I've seen that,
Which one, my lords? The table, my lords?
not the table. The parties, names of the parties.
In
My lords, page 68, if I'm not mistaken.
72 is the verification one, but kindly have a look at.
The original suit is filed
Yeah,
by
54, my lord.
Mrs. Nickel Construction Company Private Limited, Mr. Rafi Beg, Mr. Rahil Beg, Mr. Jaibullah Beg, Ashrafullah Beg, and versus, and the defendant is Ranka Developers.
No, also Farah Beg, one more person, Mrs. Farah Beg.
That name is
Farah
not
Rafi.
here.
Kindly look at page 54, my lord, that narrations where I had filed a suit, they had filed a suit, and then the compromise petitions.
I think everything is a confusion in this case, or both of you trying to
That is
confuse the
exactly
court.
what I said, let the inquiry happen.
When I asked you, who are the parties to the compromise, you have to point out
My
from the
lords,
Page
pleadings.
54.
No, page 72 is very clear, my lords. My lords may just look at 72
All
and
other parties.
the signatures are very clear. My lords, 72 has all the signatures with the names. Ranka Developers, who my learned friend represents, Nikhil Constructions, my lords, who's an independent developer, Rafi Beg, my lords.
So there are about 4 suits.
Yes, yes.
OS number 15049 of 2006 is filed by Ranka Developers Private Limited. And OS number 15050 of 2006 is also filed by Ranka Developers. And all the 4, and OS number 15051 of 2006 is also by Ranka Developers. And OS number 1784843 of 2005 is by Nickel Constructions Company Private Limited.
Yes.
In OS number 17843 of 2005, Rahil Beg, Zabibullah Beg, Asafullah Beg have Rafi Beg, Rahil Beg, Zabibullah Beg, and Asrafullah Beg have instituted OS number 17843 of 2005. In the compromise that is entered, the compromise clearly states what are the shares to the respective parties. When it comes to this, it is when it comes to these 4 parties, that is the plaintiffs in 17843 of 2005, it is referred to as Mr. Rafi and Party.
Rafi and Co.
Rafi and Co.
Rafi and Co.
It is mentioned as Rafi and Co. Now, the present execution petition is filed by, what are the parties?
Well, it's the 2 parties are Zabiullah Beg and Farha Rafi.
Where is he? Where is a party to the suit?
They are parties to the suit. My lords may see page number. My lords, page number 54.
Yes, I'm at page
Paragraph
54.
number 2, my lords.
Yes, I'm there.
Yes, Rafi Beg, Rahil Beg, Zabiullah Beg is mentioned there, my lords.
Where is the other person?
Yes, Farha Rafi, my lords, is at page 55, the first line. Next page, page 55, Farha Rafi, first line. They're all part of different suits, my lord. They were clubbed together and compromise entered into for all the suits together.
Hence Rafi and Co.
That's why it was, for ease of reference, it was called as Rafi and Co.
No, Rafi and Co. How many are Rafi and Co?
6 people in total, my lords. That is also mentioned.
Where?
The last line of para 4, my lord, at page 54.
Yes. It continues from para 4 to the next page at page 55.
So now it is filed by Mr.
Filed by Zabiullah Beg and Farha Rafi.
The execution is filed by Mr. Farah Rafi and
Zabiullah Beg.
Zabibullah Beg. The petitioner herein, who is the judgment debtor, has filed an application under Order 1 Rule 10 to implead the other members of Safi and Co. That came to be dismissed by order impugned. While dismissing the application, where is the order? The court has observed that
33, my lord.
court has relied on the judgments of the apex court.
These judgments are pertaining to third party being implicated.
The controversy in the application, there is no dispute with respect to the compromise decree dated 3/2/2014, passed in voice number 15048 of 2006 and voice number 15049 of 2006 and voice number 15050, 15051 of 2006 and voice number 17843 of 2025. In between the judgment debtor, decree holder and the proposed parties entailed in the current application, and there is no dispute as per the compromise decree of all the suits. The judgment debtor is liable to the decree holder. But the proposed parties of the entailed in the present application are all necessary and proper party to the present execution petition or not is a prerogative right of the decree holder and not to the judgment debtor. Admittedly, the decree holder is the master of his execution petition and not the judgment debtor. Further, the current application came to be filed at the stage of executing the decree. If at all and once the execution petition is bad for non-joint of necessary or proper party, the same plea under objection could be raised by judgment debtor on addressing his argument at the stage of merits of the execution petition. Further, if at all once the judgment debtor is not able to realize the decree in the absence of proposed parties entailed in the application, the judgment debtor can realize the decree as per section 88 of CPC. Further, since the applicant judgment debtor have the present application in the stage of executing the decree against them, the same application will not survive as per the judgment of the apex honorable high court. Hence, the same application on its prima facie disclosed at the very application filed just to stall the execution proceedings. Rather, they have no prima facie on its face and accordingly rejected the application. In counsel appearing for the petitioner, the judgment debtor submits that when all the parties, when in the compromise decree, the shares of Rafi and Co is mentioned, and there are about 5 people in when it is mentioned as Rafi and Co. It is submitted that all the parties are ought to be parties to the execution proceedings. Without the presence of those parties, it cannot be decided. It is submitted that some of them have sold the properties to third parties.
That is their contention.
No. Why do
That
they?
subsequently, my lord, they remain out of these 5.
Yes.
They have filed I mean, there's a sale deed which entered, there's an objector filed application
It is
also.
submitted that the properties were sold and that person has filed as filed an application in the execution as an objector. It is submitted that their presence is very much necessary to adjudicate the dispute between the parties. The judgment that is relied on by the court to dismiss this application has no application to the facts of the case. It is submitted that unless and until all those parties are impleaded in the judgment in the execution proceedings, there cannot be any finality to this litigation. Next paragraph. Then counsel appearing for, you are appearing for
For the decree holders.
the decree holder.
Caveat is here.
decree hold, they are R1 and R2 before this court.
Please. Yes.
The decree holders R1 and R2 on KPIT submits that. The Rafi and Co comprises of 5 people, and out of that, 3 persons have filed their affidavits before the court stating that as per their entitlement, where is that
Four have filed.
entitlement?
Millards, I'm sorry, 6 people in total.
6 people.
Yes, 6 people in total.
6
Four have
people.
filed, yeah.
4 of them have filed the affidavits, and as per their, where is that table?
Table, my lords, is at page number 165 of the execution petition. And also
It is
forthcoming.
submitted that they have, that as per their entitlement, as per their arrangement, Rafi Beg has to have 5, Rahil Beg 5, Ashrafullah Beg 11, Zaibullah Beg and Mrs. Farha 44, and Mr. Gajendra Achar 3 flats. And the 4 of them have filed their affidavits before the court stating that they have received their respective flats. Now only the execution is filed on behalf of Zabibullah Beg and
Farha Rafi.
and
Farha
Farha.
Rafi, who are together in that.
But I have disputed this affidavit because it doesn't contain the diary entry.
Mr. Farha, that they have to, and that 44 flats have to be, for the said 44 flats, the execution is filed. It is submitted that. It is the execution petition filed by the decree holder, and who was supposed to be the parties to the said execution proceedings. That is for the petitioner to decide, and the defendant cannot say that who are supposed to be the parties to the proceedings. It is submitted that the court has rightly considered the fact that the present petition is filed only to drag on the proceedings. It is submitted that there is no, in fact, what is that you are saying that he has filed the objection wherein he has accepted your.
Yes, my lords, page 211.
It is submitted that.
In their objections, my lords, page
In their
211.
objections, it is stated that.
They make a reference to that document, that internal area sharing agreement.
No, where do you get that? Page number 2?
211 of the petition, my lords.
211. It is submitted that.
Well,
It's not 211.
No, 211 is their response to my execution petition, that table. And they make a reference to that agreement.
Where do you get that?
Yes, page 211, paragraph 45, third line, my lords.
It is submitted that when this table is produced by the petitioner in the execution proceedings, the petitioner herein has filed their objections to that, wherein they have stated that
My lords will see the mention, clause 2 of the internal area sharing agreement, which he refers to. It was mutually agreed that out of 68 flats, the decree holder is allotted 4.
as per clause 2 of the internal area sharing agreement, it was mutually agreed inter alia that out of the 68 flats, the decree holder number 1 is allotted 4 flats out of 68, and the decree holder number 2, along with Mr. Rafi Beg, are allotted 29 flats, and out of the 68 flats allotted to Rafi and Co. Further, the conjoint reading of clause 14 of the compromise petition, clause 7, 8, and annex 2A of the area sharing agreement.
But the reserve unit also.
Huh?
There's a reason why I was holding on to this.
That is a
Reserve
different issue.
units are yet to be allotted between Rafi and Co. Therefore, the decree holders are not entitled to execute the decree dated 3/2/2014. It is submitted by the land council for the respondent that they have in fact have accepted for the internal arrangement. And when the other co-sharers have no difficulty and they have filed an affidavit only with an intention to harass the decree holder and to protract the proceedings, the present application is they have filed this application. Next, having heard the counsels on either side, there is a material on record. The compromise decree that is entered, and also the internal arrangement between the Rafi and Co. and where the petitioner is also a signatory, there is no dispute upon the shares of the respective parties. Out of 6 parties, 2 are before the court and 4 persons have filed their affidavit stating that they have no objection and they have got their respective shares, and whatever, and the remaining share, whatever the decree hold, in the execution petitioner decree holders have filed, they have no objection. When that is when such affidavits are filed before the court, according to the judgment letter, all the parties should be parties to the proceedings. Even if any person files an application as an objector under our 21 Rule 97, it's for the court to decide the same on the merits of the case. That cannot be a reason for the court. If such an application is filed and if that has to be decided, then the court can take appropriate step. As far as passing as far as this petition is concerned, the other parties of Rafi and Co are not the necessary parties, and the court has rightly dismissed the application. And this court finds no reason to.
Respectfully, Madam, the issue here is that I am holding, there is a third party interest created by the other DHS who are not party. All I'm saying that please let them come on record, the inquiry may happen.
Next.
My lord, that contention has not been taken, my lord.
What is that?
My lord, the contention of third party interest, the sale deed which is there, my lord, is executed by Nikhil Construction, who is represented by the DHRs who are not present before this court. I am saying implead them so that the inquiry can, because today if I hand over this 15 properties, my lord, I am still I am exposed to this litigation, and that's exactly why that compromise petition was entered into, my lord.
The court will decide that.
My lord, then they have
Objector petition.
My lord, the objector application is one thing, my lord. I am end of the day also aggrieved by the whole proceedings because I am also having
Yes,
undivided.
I pass order.
My lord, my only request is, my lord, let them be impleaded. That can be decided thereafter, my lord. If today, if they are not, because it's only going to set a precedent.
Yes, next.
my lord.
All the contentions are left open to the parties. Yes, next. Yes.
Execution petition, lords, is for execution of a compromise. Now they have filed an application for recall of certain order where an inquiry has to be held. Earlier they were before your lordship, this honorable could dismiss their petition with a cost of 1 lakh. Again, similar application is filed.
What is the order passed by the court?
Recalling the earlier order, which has been confirmed by this honorable court.
One wrong thing happened. Thing is, the advocate on record name has been wrongly shown in the cause. It is HV Praveen Gowda, but it has been HV Praveen Gowda, but in a cause days, it is showing HU Praveen. It is very difficult to track down the.
No, we will do that. Now you're here. No, you want adjournment on that?
On Monday. Therefore, I am humbly seeking this.
Monday. The registry is
No,
directed to, the name of the council shall be printed as HV Praveen Gowda. Praveen Gowda, list is matter on Monday in the first list. Yes, 36.
Number 36. 36. Praveen HV.
Referring to the caveat, I was served a copy of this number day before yesterday. I have to file no objections to it.
No objections are, that's a primary hearing. We have to hear him. Yes.
The only difficulty is that I wasn't able to get too much of instructions from my client. My client was not able to give me instructions because I only got it day before yesterday.
The
If
urgency,
they add on Monday also, I'm fine. But at least a day's accommodation has been just.
once he is done, Malas,
No, tell me,
Plus the
what is the urgency?
urgency. Malas have been impleaded as a judgment debtor in an execution petition, Malas, after 23 years of possessing the
Correct.
property.
What is happening by
Attachment
Monday?
order has been passed against.
Monday, what's happening?
Malas, 25th is the matter.
Let them not precipitate the.
If they undertake, Malas, I don't have.
Yes, Monday. In the first list. Yes, next.
Cell number for admission, cell number 37.
Malas, let them undertake not to precipitate.
He said so. Not required to record it.
Please.
Yes. 37.
It is a suit for partition. It's an application seeking stay for further proceedings in OS number 3226 of 26. The trial court has dismissed the application.
On what
orders
ground the plaintiff has to be rejected?
On cause of action and limitations. I'll review the facts, my lords.
Come to that application filed by you. Please come to the application.
Yes, my lords. Page number 27.
Page number
27.
Yes. Yes.
Yes. Page number 5, paragraph number 5, my lords. The said Jairam and Jyotiamal had 3 children by name Rajendran, Chandra and Mahesh Kumar, who are no more. Coming to the 7th paragraph, Jairam had died in the year of 1987, leaving behind his wife and children. The said Jyotiamal had died in the year of 1995. Later in the Rajendra and Chandra, the first and second child, died in the year of 1999. The last son by name of Mahesh Kumar had passed away recently and in the year of 2010.
All these questions, how the court can decide on an order 7 to 11?
My lords, in the plaint, my lords, the para number 14, the cause of action of the above suit arises from 15/4/2021. The period from the period of 1999, almost a decade, 25 years.
So the court will decide whether it is a question of law and fact.
Yes, my lords, but my application was rejected.
Court will decide it during the course of trial, not now.
True, my lords. The cause of action.
That's why the court has rejected.
Yes, my lords. But the cause of action, it doesn't arise because the partition was happened in the year of 2006.
That is your
my lords.
case. That is not the plaintiff's case.
Yes, but they have suppressed the fact in the plaint, my lords.
Suppression of facts is not a ground for rejection of plaint.
Yes, my lords. But
Yes.
the limitation, when it comes to the limitation, they could have,
Which
they had
question
all
of
the
fact and
rights to
law?
occur.
Dismissed. Yes, next.
Please.
Cell number 38. V. Vinod Reddy.
Yes.
We have filed this is suit for specific performance.
Hmm?
Suit for specific performance.
Oh.
We have filed an application, my lord, under 7 Rule 11D, read with section 151 for rejection of the plaint on the ground that, my lord, on the 2 grounds, my lord. One is, my lord, the suit is barred by law, my lord, section 61 of the Karnataka Land Reforms Act, wherein, my lord, the agreement has been executed within 15 years from the non-alienation period. That came to be, section 61 says that, my lord, agreement cannot be executed within that period, non-alienation period, my lord. That is one. Another one is,
Come to your application, I'll understand.
application
what-
is at, my lord, page number 63, affidavit.
63.
Yes, ma'am.
Hmm.
Page number 2, my lord, is the suit scheduled property originally acquired by the defendant number 1 and 2 under the grant by the government wide order so and so, and the Tahsildar of Shidalghata has issued the grant certificate in favor of the defendants
No,
on
no,
1
you
and
have
2.
stated so. It is the case of the plaintiff at para 4 of the plaintiff. He says so, that it is, it's a grant.
Yes, my lord, plaintiffs, in the plaint itself, they have said that it is granted land. At the plaint, my lord, at the para number 10 is clearly said.
Page number?
Plaint, page number 15, my lord, para number 4.
Hmm.
It is further submitted that the suit scheduled property originally acquired by the defendant number 1 and 2 under the grant in the grant made by the government and so and so defendants are not belongs to the scheduled caste and scheduled tribes. The Tahsildar Shidalghata has issued the grant certificate in favor of the defendants 1 and 2 on 18/5/2004. This is the admissions in the plaint, my lord. Within 7 years, the agreement has been entered into. That is on 11/3/2011, my lord.
You having executed an agreement of sale, now you come before the court and say that it is barred by so and so law.
Yes, my lord. One is that, my lord. Another one, another point is that, my lord, under our 23 Rule 3A.
Hmm.
Well, they have sought for second prayer in the suit, my lord, at page number 18.
What is that?
Page number 19, my lord. D. Declare
they
that the alleged compromise decree in respect to the suit property herein is not binding on the plaintiffs and is void and ab
Yes, I have seen that. Please come to the order now.
order. Yes. Well, reasoning starts at page number 72, my lord.
Mm.
Point number 1. The appellant defendant number 7 submit that the plaintiff has filed suit for specific performance of the contract. It has submitted that the plaintiff seeks relief of the specific performance of the contract on alleged agreement of sale dated 11/3/2011 and also seeking to declare that the compromise decree is not binding on the plaintiffs. It has contended by the plaintiffs that the suit schedule property acquired by the defendant number 1 and 2 under the grant made by the government under number so and so accordingly got mutated the suit property in favor of defendant number 1 and 2. There has prohibition clause under the grant that from the restraining from the period of 15 years to alienate the suit said grant property, but within this period of 7 years.
That is answered by the court. What about the other contention? The other contention that
The
they have
other
sought
contention-
another relief.
The court has not answered for this Mellard, and the court has answered Mellard at page number 7, Mellard.
Page number?
7, in 75, internal page 75, Mellard, ink page number 7. In view of the said section 61/1 of the said act, wherein the legislatures have not incorporated the word agreement for sale and.
That I have seen.
Yes, Mellard.
I'm asking you about the other contention.
The
which
other
you raised.
contention they have not considered.
When counsel for the petitioner submits that.
The other contention has been not considered.
Where is, in your application, let us see? Where did you say?
Application. Page 64, page number 64.
Where did you say so? Please.
64. 65, Mellard. It is well settled in the down, Mellard, in para number 5. In bold letters, it is there underlined, Mellard. It is well settled that the no independent suit can be filed for setting aside a compromise decree on the ground that the compromise was not.
He is not a party to the compromise.
He is not the party.
Then why can't he file that it is not binding on him when he is not a party to that?
Why he can't file, Mellard, because there is bar under the 23 rule 3, Mellard.
He is not a party to the proceedings.
Yes, Mellard, even then also. 23 rule 3, Mellard, but says that, Mellard.
A party to the compromise cannot file a suit.
Yes, Mellard. 3A, Mellard, kindly see.
Read it.
3A, bar to the suit. No suit shall lie to set aside a decree on the ground that the compromise on which the decree is based was not lawful. That is, Mellard.
But he is not a party.
Yes, Mellard, he is not a party. This is suit for partition, Mellard. He won't become he is not a family member also.
This is not a ground for rejecting the
It is
plea.
ground, Mellard. I have passed the judgments.
According to you, what you should do?
And the amount which has earnest amount may be returnable to him.
Not specific performance.
Yes.
According to you, specific performance is one aspect. The second thing what you say is, the suit is, he cannot question a compromise decree.
Yes, my lord.
To which he is
He-
not a
By
party.
filing the separate suit.
He is not a party to the compromise.
Yes, my lord, even otherwise, the Supreme Court itself said that. My lord.
Give that. Hmm.
23, Rule 3A, my lord.
Mm.
This is AR 2020 Supreme Court 2/111. Compromise decree challenged by the stranger permissibility. Decree passed on and compromise cannot be challenged by the stranger to proceedings in separate suit in view of the specific bar under Rule 3A of the 23. Specifically, they have said, my lord, stranger cannot be challenged.
Please read what is the order of the court? where is the finding on this?
My lord, 17 paras,
Para number?
17, my lord. 17.
Yes.
Finality of a decision is an underlying principle of all the adjudication forms. Thus, certain of the further litigation should never be the basis of the compromise between the parties. Rule 3A of Orders 23 CPC put a specific bar that no suit shall lie to set aside a decree on the ground that the compromise on which the decree is based was not lawful. The scheme of Order 23 Rule 3 CPC is to avoid multiplicity of the litigation and permit parties to amicably come to the settlement which is lawful, is in writing and a voluntary act on the part of the parties. The court can be instrumental in having an agreement compromise effected and finally attached to the same. The court should never be party to the imposition of a compromise upon an unwilling party still open to the question on an application under the proviso of Rule 3 Order 23 CPC before the court. And
What you have read in the head note, where do you find it?
Note 22, my lord. 22. Para number 22, my lord. In other words, the appellant can only claim through his predecessor's Sampataya to the extent of rights and remedies available to Sampataya in reference to the compromise decree merely because the appellant was not party to
These
the
are the facts of that case. The facts of that case, that is what.
merely because he is not the party to that case.
That's not the judgment. Any other judgment? Yes.
Another one is
A party to a consent decree based on a compromise
I mean, the
So and so
statute itself clearly says
has to approach the same court.
yes,
Hmm. Yes.
the next one, my lord, live law 2022, my lord, SC 143. The head note, my lord, Code of Civil Procedure 98, under Order 23, Rule 3, a party to a consent decree based on the compromise to challenge the compromise decree on the ground that the decree was not lawful, that is, was void or voidable, has to be approached. The same court which recorded the compromise and a separate suit challenging the consent decree has been held to be not maintainable.
That is all between the parties.
Between the parties, he is not the party, he is not at all family
That is
member.
what, he is not a party. That's why he is saying it is not binding on him.
My lord, he is, the stranger also cannot challenge in they must go to the same court and they should do that.
No.
My lord, here, my lord, kindly see, this is also in respect of the specific performance suit itself, my lord.
Yes.
Kindly see at para number. Here also they have asked for only not binding on them. They have not sought for any set aside of the judgment, my lord. But at para 10, my lord, the
Yes.
same judgment.
Yes.
Now, so far as the submissions on behalf of the plaintiff that the plaintiff has not specifically prayed for setting aside the compromise decree. And what is prayed is to declare that the compromise decree is not binding on him and that for the other reliefs sought, the suit was not barred and still the suit would be maintainable is concerned. The aforesaid cannot be accepted. Because matter they have drafting is in clever and
Give
for
those
that
two
sake it has
judgments.
been not.
Yes, please come. Here number 14, agreed with order passed in I number 14, was number 49 of 2018 by the senior civil judge and JMS said Siddhal Katha, dated 15 February 2026. The defendant is before this court. The respondent herein, who is the defendant in the suit, has filed a suit seeking specific performance of an agreement of sale and also the relief that seeking a specific performance of an agreement of sale and declare that the compromise decree in respect of suit property is not binding on the plaintiff and is void and void ab initio. In that, the defendant has filed an application under order 7 to 11. One is that the property is a grant in respect of the said property, there cannot be alienation for a period of 15 years. And further, a decree, the relief of, the relief that the compromise decree is not binding on the plaintiff, on the plaintiff. For that, a separate suit cannot be filed. That came to be dismissed by order impugned. While dismissing the application, the court has considered Section 23 of the Contract Act and also Section 61 of the Karnataka Land Reforms Act, and observe that wherein the legislatures have not incorporated the word agreement of sale, considering the contention of defendant number 7, the agreement of sale is not amount the sale transaction or not create any title to the concerned parties. Therefore, the contention raised by defendant number 7, the plaint is not maintainable, is not acceptable in nature. Therefore, the application by the defendant number 7 is not liable for consideration. Hence, the application filed by the defendant number 7 is dismissed. Along with that, the other contention with regard to the maintainability of the suit is not considered by the court. Land counsel for the land counsel for the petitioner submits that the suit is not, he has executed an agreement of sale, but as it is a grant, the same is not as there is a bar of alienation for a period of 15 years, the same is not enforceable. And number 2, the plaintiff is not a party to the compromise, and he cannot seek a relief that the said compromise decree obtained by the parties is not binding on them. In support of his case, he relies on orders passed by the Apex Court in Civil Appeal number 439 of 2022, Civil Appeal number 440 to 441 of 2022, in case of Sri Surya Developers and Promoters versus N. Sailesh Prasad and others. Another one, along with Mrs. Raja Pushpa Properties Private Limited versus N. Sailesh Prasad and others. He relied on paragraph number
17 and 22. 17 and paragraphs.
Justice Sanjeev Khanna's judgment.
8, 10 and 6 Miller.
8, 10 and 6 extract. Land Council has also relied on another judgment passed by the Apex Court in case of Triloknath Singh versus Anirudh Singh, reported in AR 2020 Supreme Court 2111. In this, he has relied on paragraph number 22.
17 and 22.
He has relied on 17 and 22.
One submission. So far as section 61 is concerned, I am relying on 2 judgments.
Take that. Yes, where is it?
On the head note, my lord, in the year 2019 Supreme Court 4654, my lord. The specific performance of the contract agreement to sell predecessor entitled executed registered mortgage deeds in favor of the plaintiff grant of suit property is of the year 1983 and the transfer is question of 1990, wherein is within the period of 15 years.
Yes.
Agreement executed during non-alienation period of 15 years is illegal and hit by section 61 of the act. Predecessor in the title and plaintiff are equally responsible for the illegal agreement. Suit for specific performance of not maintainable maxim ex rupee causa non other actio. Applicability maxim in the peri decision so and so etc. Positions is applicable. Here also they say that both people are made mistake. But even then, my lord, they say that, my lord, the suit is not maintainable.
Sir.
Another judgment, my lord.
Justice Anchadi's judgment.
Yes, my lord.
Take all that.
In this
Land
also, they have
Council
made for the
petitioner
refund of the amount.
There is an agreement of sale and there is an order of non-annihilation and within 15 days, for 15 years, it is executed. But where did they say so with regard to when was the grant and when was it is when it is alienated in the plaint?
The plaint, the para 10 itself fixes.
Where did they give the dates?
Para number 4, my lord. It It is further submitted that the suit scheduled property originally acquired by defendant number 1 and 2 under the grant in general made by the government, wide order so and so. And the grant last in 3 lines from
And
the
agreement
back.
of sale is
18/5/2024. Mala?
Agreement of sale is when?
Agreement of sale is in the 2011, 11/3/2011, within 7 years.
Submitted that a grant was issued in favor of the defendants on 18/5/2024. And the agreement of sale is issued on 11/3/2021. Is on judgment of the apex court in case of Narayanamma and others versus Govindappa and others, reported in 2019 SCC 4654, wherein the apex court has held that agreement executed during the non-alienation period of 15 years is illegal, as hit by section 61 of the Act. Predecessor and title and the plaintiff are equally responsible for illegal agreement, and suit for such performance is not maintainable, and this aspect was not considered. Hence, there shall be stay of all further proceedings. Notice to the respondent, same.
But another judgment, Sanjeev
4th of
Enchant is,
August. 4th of August, yes.
wherein it is clearly held that much obliged.
My apologies, for the petitioner. 27th is the.
Where is the other side?
Malas, I will inform the other side, Malas. He just left. I will inform. Great.
Yes. What is that? Oh, 430 matter is there. Where is it? Yes, Mr.
Lord, there is one passage, my lord, there are no judgments on the point which my lords asked me to look at. There is one, my lord, passage in a book. My lord, that book is available only, my lord, on the net. I'm given to understand, my lord, if you give a requisition in the library, they'll give it. My lord, I'll supply it to the court, my lord. We need not wait for.
What about the other submissions? Any other submissions?
Any other submissions, my lord, is?
I have one submission.
Yes.
Anyway, we have completed only today. This is the
Take today, both the councils have filed their, the translated copy of the documents. Yes.
Another document we were able to lay our hands on was, I have translated and have filed it.
Have you given him a copy of it?
Yes, that's it. Give it to me.
Which indicates that the mother of the
Give that.
second petitioner. It's not in that compilation, not, it was filed in the court, I mean, filed in the office. I'm not sure whether it's been tagged along. Yeah.
For that also there is a translation.
Yes, of course. This only indicates the mother of the second petitioner was appointed to serve meals. In Kannada, we call it Annadana. Only to that, not even to distribute prasada. Because they claim that after the father,
3 generations.
the mother was doing it and subsequently the petitioner is asking. This document indicates, has the original, but I just produced the original also, which indicates that she was appointed only to serve the Annadana rice.
When was it? Before that, you please give the copy of yours. It's not available, I think. Let's just. It is not available in the file itself. Look at it.
The first document after the memo. Third name.
Subhadramma.
Yes, madam. 229 to 1994.
That is Vetana means the 1500.
On top, it is melodic.
For how many years she worked like that?
9 years, I'm told.
Oh.
On top itself, the first line says, Sri Sati Subramanya Swami Devalayada Annadana Naukarala Vivara. whoever the list of employees were appointed for the purpose of serving the meal. And I have other correspondences also. It is of the same thing to indicate that this Adinaranappa himself was appointed only to do distribute the prasada in the year 1984. Page number 6. That too, this was only a recommendation which was made, but then we don't have documents to indicate whether the recommendation.
Commissioner has accepted one.
Yes, I have produced the translation of all. I'll produce the entire original with the flags, so that my lord may. That's all. I don't want to add anything.
Yes.
In my comparison, page 4 was.
Take the comp.
Today I that not asked us whether before after the Adinaranappa, whether it is continuing to the. Proceed kindly to page 4, document number 5. Document 2 will also.
Document number 2.
Document number 2. Type copy, translated copy at page 7. It is.
Yes.
One T and Guru Raj. Lordship, thereafter, it is not continued with her family.
Panchakajaya Prasada.
Please,
and,
Panchakajaya Prasad. Lordship, as per the report, executive officer, permission is hereby granted to Sri T N Guru Raj.
This is when 28/9/1996.
Please, Lordship. So it is not, Lordship, continuously given to them. Please.
I have that. I put all the flags whichever I have. The third name.
Just know the proceedings you have passed on, Subhadramma.
Yes.
This 9997 is? So there was Sanam. Yes.
Great.
But regarding that.
There is a notes.
Skanda services, my lord, which they produced. My lord, I'm just filing an affidavit. It is an entirely different, my lord, activity, sir.
What is that service you're saying? Annadana.
No, my lord. This, my lord, they produced one auditor's report saying, my lord, that several crores of income is being generated. My lord, please look at document number 1. My lord, it is license to run the business of private security agency, Sri Skanda Services. Please see, my lord, I have given the license given by the government itself.
License by the controlling officer to run the business of private security agency.
Yes, my lord. That is Sri Skanda Services Agency. A picture is sought to be portrayed as if, my lord, this agency is involved in prasada manufacture and this is the amount that is. My lord, I have also filed a personal affidavit of the petition.
What is the income?
Saying that, my lord, this is the income, my lord, which is arising out of that. My lord, the income which, my lord, they temple themselves have, my lord, given in the compilation which my learned friend has filed.
No, you filed the affidavit. Where did you say that what is the amount you are deriving from that?
Lord, in this I have not said. I only said, my lord, whatever amount is indicated therein is from my lord, what amount is, my lord, derived. They themselves have filed one, my lord, document. I'll show that to my lords.
In whose documents it is?
My lord, in the documents filed by the special counsel, my lord.
Yes. What about this? Huh? Oh. Hmm.
In the, my lord, compilation which they have filed,
Yes.
my lord, page number 77.
Page number?
Document number 11, page number 77.
Yes.
What is the income, my lord, that is derived?
Mm.
My lord, they themselves have given this document.
Mm.
And my lord, what is the amount that is paid to the government?
Mm.
My lord, left-hand side, my lord, what the authority, my lord, is selling. Kalsakre Karjura on the left-hand side, page 77. Lord, they would report incomes of 31 lakhs and 53 lakhs for 2 years. My lord, right-hand side, about 20 items, my lord, they say it is given to private persons. There is no translation, my lord, of
Which
page
page?
79 is the translation.
Oh.
My lord, all these 20 items are given to private persons.
Mm.
And the amounts which are being paid for, my lord, towards sale of this, as my lord, revenue to the government is, my lord, 8,27,000 and 9,90,000.
40 lakhs. Annual sum of rupees 40 lakhs, end of it. According to records under official memorandum, page 80 I'm reading. Translated copy is there.
My lord, this is of, my lord, Annadana Seva, my lord. This is not of us. This is, my lord, daily there is feeding. They have produced accounts of that. Please see the heading itself. Total
79.
details of offering donations to Annadana Seva.
No, no.
No, this is not Annadana Seva, my lord.
Do you have the along with the copies? I'm not looking at, you are looking at the additional advocate general's one?
No,
The
my lord, what
documents of
my
additional advocate general or the senior counsel?
senior counsel, my lord.
No, that document I'm looking at.
Lord, page 80,
No, no, sir, sir. Sir, government copy.
ಇದು ನೀವು ಹಾಕಿರೋದಾ? Yes, my lord. Page 80, my lord, commences with the government of Karnataka.
Hmm.
My lord, page 80, my lord.
79 is the translation.
79 is the translation. 79 left-hand side, my lord, what the authority is, my lord, selling. Left-hand side, my lords will get.
Hmm.
And what is the income, my lord, that they are deriving from it?
Why these kind of papers are unconnected?
My lord, they have filed in 4 or 5 sets, my lord, on different dates.
Which set to be considered now? Where is that convenience compilation? Yes, Mr. Counsel?
This is not the way the manner.
No, whatever it is, because I am under the, now I am only looking at this one convenience compilation. I will not be looking at all the pages, all the papers.
I have filed one consolidated from my side.
Your
From-
side.
Yes, ma'am, from there.
Ah. So from that time, you please show me where is that?
My lord, they have served one thing today to me, my lord.
That is served by him, I think.
Yes, my lord, that's what. That is, my lord.
I just furnished that to honorable court now, my lord.
Ah.
That's that along with the translated copy.
There is something in the convenience compilation given by the temple.
My lord, that they took back, my lord. that they took it back.
No, you have not given him the
That
copy
they took
today.
it back.
I have, sir.
Should be the same itself. There can't be any difference.
No, for him to address the court, it should be the same
I have
document.
Showing
No,
page
in that-
77, that 35 lakhs and 53 lakhs and 9 lakhs, 33 lakhs is what the temple has derived.
No,
for 2
what
years.
I am asking is, at page number 79.
Yes.
Today, what is given to me,
Yes,
it is a
ma'am.
letter dated 27/12/2021 to the executive officer.
Please, no, sir.
From the government of Karnataka.
Yes, my lord. The additional deputy commissioner, my lord, has
Ah.
written that.
So in that I am saying, please come to page 80.
Yes, my lord.
Hmm.
According to
And
the.
this is reference to K.S. Rangaraju and Hema.
Yes, my lord.
And Hema.
Yes, my lord.
At page 80.
Yes,
Please
my lord.
come to 80.
Yes, my lord. I saw what my lords were referring
It
to.
says 40 lakhs.
40 lakhs, yes, my lord.
For an annual sum of rupees
40 lakhs, yes. My lord. This is, my lord, the permission must be granted. This is a recommendation that is made, my lord, by the deputy commissioner to the executive officer, saying that I must be permitted to give all these, my lord, things.
Provided you pay 40 lakhs.
40 lakhs, yes.
Per annum. That's
Yes,
what it is.
yes.
Then now what is this you're relying on?
My lord, that learned advocate, my
Advocate
lord,
Gen. Page number 80, yes.
again, page number 79
Mm.
is the translation, my lord. The original document, my lords, will get it 77, which is in Kannada. My lord, translation, my lords, will get it in 79. Details of prasadam, my lord, please take the translation 79. Details of prasadam sold on behalf of Gati Subramanya Kshetra Development Authority. My lord, what they are selling, and my lord, what is the amount contributed to the temple front from prasadam sold on behalf of the authority. Then, my lord, 20 items on the right hand side, it is given to private persons. Amount contributed to the temple front from approximately 20 types of prasadam sold by private individuals is this.
Private individuals are the petitioners in our case. Out of the entire money what they have sold, they give government only 8 lakhs for the first year, that is 23-24, and for 25-26, 9 lakhs. Their entire thing is in crores, more than a crore. Out of that, what is paid to the government is this much. That is what we have indicated.
My lord, whatever is fixed as per government orders, my lord, it is they who fix the amounts that are to be paid. Even in the recommendation, my lords have seen, you please pay this amount, my lord, we paid the amount. My lord, how are, my lord, they in any manner concerned? Once, my lord, even in mining leases, my lord, they say, please pay so much of annuity to the government. Please pay so much of amount. Then after that, my lord, it is like, my lord, dog in the manger kind of an attitude. No doubt you are paying this much, but what is the profit you are doing? My lord, everywhere it happens, my lord. Sale of, my lord, mobile licenses. My lord, government collects whatever is the license fee. My lord.
We'll not equate that with the hereditary.
No, that is what they are equating. They are saying it is a commercial activity.
We'll not equate it with something called hereditary rights.
No, my lord, what I am trying to say is, my lord, these are all amounts which they have fixed. I am not contributing some arbitrary amount to the temple. My lord, these are each and every amount is something that is fixed by the government. And now, my lord, they find it convenient to say they are earning so much.
So whatever they're doing, whatever they have done by giving you all this, is it a religious function or a secular function?
My lord, I would put it like this. Like last time, my lord, I made a submission. My lord, they are entitled to regulate. Even today, my lord, I make a submission, my lord, they are entitled to regulate. For example, my lord, in the documents that they have.
Not about regulating.
Lord,
whatever you're doing,
yes,
whatever you're doing, that is, or whatever they're regulating, is it a secular function or a religious function?
My lord, it is a religious function. That is what, my lord, Shirur Math's judgment would say. My lord, all activities connected with the temple, my lord, including offering of anything to the, maybe pujas or offerings to the deity, all that becomes an essential practice. They are entitled to regulate it, but they are not entitled to ban it or, my lord, completely say that it must be stopped or discontinued. That is not how, my lord, Shirur Math case, my lord, the judgment came, 54 Supreme Court. Here also, my lord, they would say, please sell the prasada at 5 rupees. You must not sell prasada more than 100 grams. These are all restrictions which they are putting, my lord, which we don't find fault with. They say, please pay so much of annuity or annual income to the government or temple. My lord, we are doing it. These are all conditions imposed by them. They are all regulating. They have got the power to regulate. But my submission is they don't have the power to abolish it. It's my respectful submission to my lords.
Yeah.
Lord, I have written submissions. I'm just giving written submissions, my lord.
Yes, please give. This one. No, this two.
That one book, my lord, is there. I'll give a Xerox, serve it to them and give it to the court officer. My lord.
This one.
That is actually a very interesting question, my lord. There are two parts, my lord. In fact, whatever offerings are made to the god, my lord, in terms of jewel, that's also, my lord, Justice Mukherjee, my lord, he has written a book. It is there in that. It's not available anywhere, my lord. I have requested the library. They said, I'll give the relevant portion to the court officer, my lord.
This memo is filed by. Not the, no, Banu, additional advocate. So keep it in their compilation. in this compilation. And just pin it along with it so that there won't be unnecessary confusion. And as far as your documents, I will only be looking at this continuous compilation, nothing else.
Nothing else. Lordship, I have included that one judgment left out in the other day, Lordship, I included
One
that
minute.
also.
This is in,
Well, that is only affidavit, my lord. To say that, my lord, whatever does not pertain to this activity, that's all. It may not have any bearing on, my lord, what I am canvassing before, my lord.
yes.
Why we have to consider that was the document given by the first petitioner at the time of participating in the auction to say that what is this business about.
Yes.
Great.
Yes. I'll just hand over that book to the court officer. I'll inform the court. I'll serve
Any judgments you're relying on?
Yes, my lord. Judgment compilation is there. That also I'll give it to the court officer with paragraph number. I have not mentioned the paragraph number.
That you please mention.
I'll mention the paragraph number and give it
Paragraph number and your written submission.
written submissions I've already filed.
Where is that?
My lord, just now passed over.
That also, you please pin it, everything in that.
Written submissions, my lord, I have made references to the paragraph numbers,
So
but
what
here
you
I have
do
not.
is You make only the 3 sets. Everything, whatever they have filed in one set, so that it's easy for the court. What are you saying?
Lordship, other day, senior indicated that there is one
Affidavit
judgment, Lordship,
filed
it is
by the
not,
petitioner is taken on record. Yes.
Lordship, one judgment, it is not included in the compilation. I included that judgment also in the compilation.
No, it is there.
Please, Lordship, it is there.
You should have given him one copy also.
Lordship, it is there. Copy is there, my Lordship, and
Complete
Other
copy
side-
to him
Please,
with
Lordship.
all the numbers and all.
Please, Lordship, I have served it.
Yes, next.
Grateful.
The interim order may be extended.
Heard reserved, interim order extended.
Yes, my lord. Grateful, my lord. I'll just give it to the court officer tomorrow. I'll not bother the court.
Yes.
Grateful, my lord. Grateful for a detailed hearing. Grateful.
Lordship, I'm sincerely seeking apology, my Lordship, for that day.
Yes. We'll complete this admission.
May I seek your lordship's intervention for a minute, my lord. Serial number,
I have not yet completed.
oh, I'm sorry, my lord. I'm
I'll
sorry.
complete this 4 matters.
I'm sorry, my lord.
Is 40?
Cell number 40? Cell number 39.
39.
After tomorrow, 39.
Huh? 39?
University?
You want adjournment?
No, I've read it.
Yes.
Cell number
Yes.
no, 8 matters.
Petitioner filed an application for rejection of claim. There is no cause of action. In the meanwhile, a sister has filed a suit is for partition suit, which is pending before the second additional in Nenmangla. In the meanwhile, my daughters have also filed for suit for partition.
During your lifetime.
Now only, Your Honor.
Hmm.
Sister has filed a suit is for partition is in 2021. My 2 daughters has filed a suit is for partition for in 2024, for which I filing an application for rejection of claim. There is no cause of action. Right has to be adjudicated. For that, I filed an application for rejection of claim. The trial court has rejected, saying that a trial has to be conducted. This is the only.
Let's see that. Let us see that order. Where is the finding with regard to your
Page 46, para number 23.
Yes.
In view of the above, it is clear that the cause of action is a bundle of facts. It required detailed evidence in the order of proving through the case it is settled supra.
What is your specific case? Why the suit is not maintainable? Why the suit has to be rejected, plaint?
My sister has filed a suit is for.
Let us see your application. What did you say? Where is that affidavit?
Page number 15, page number 58, Your Honor. In AF para affidavit number
58.
58, Your Honor.
Yes.
Third para, ma'am. It is submitted. Apart from that, defendant who filed a suit is for partition in OS number before the honorable said it is pending The defendant number 4 is claiming as my sister in said suit. Accordingly, there is a share in his dispute. It is settled. Moreover, I have no definite share separately and co-person in this independently. In the meanwhile, my share is under the dispute in defendant number 4 suit. It is to be adjudicated in OS number 11.
All these things were stated in the plaint?
Yes, sir. I'm not a plaintiff.
You are not a plaintiff, you are a defendant.
Defendant.
What all the facts now you are stating about the suit that is filed by your sister?
I stated in this written statement.
Not you. It's a order 7 rule 11. It should be stated in the plaint. Whether it was stated in the plaint.
They're not stated in the plaintiff.
Then by what you plead in your written statement, how can the court consider all this?
The distinguishing of adjudicating of right is pending for that. In the meanwhile, how can you?
That is your case. Plaintiff did not say all that. Plaintiff just asked for it. According to you, some more suit is pending. Your rights are yet to be determined.
Yes.
That is not part of the plaint. If that is not part of the plaint, order 7 rule 11 cannot, the court cannot pass any orders considering your statement in the written statement.
The reason is order 7 rule 11D, there is no cause of action for determining of the right for which I seek.
Whatever is the cause of action, they have said so. That cause of action is right or wrong, you are filing a written statement and placing it before the court. That the court cannot look at under order 7 rule 11. Whether they have made out from the leading of the pleadings, a cause of action is made out or not. They have made out, they will make out generally any plaintiff is filed. So, calling the matter at 5 o'clock is not good for you. Dismiss. Next.
Cell number 40,
Not for the petitioner.
40.
Not for the petitioner.
Uttawadi Siddesh.
Lord, defendant's petition, my lord, on rejection of 7 to 11, my lord. Lord, my application is on.
What is the suit for?
A suit for damages for malicious prosecution, my lord.
Damages?
For malicious prosecution.
Malicious prosecution.
Please, my lord. Lord, my IA is on page number 42, my lord.
42?
Lord, affidavit is 44, my lord, para number 5. My lord, I give a complaint against an unknown persons, my lord. Lord, my son-in-law is a plaintiff. Lord, there being a dispute between my daughter and the son-in-law.
Let me look at affidavit. On what ground it has to be dismissed?
44, my lord, page number 44.
44?
My lord,
Yes,
para number 5,
which
my lord.
para?
Para number 5, my lord.
5.
Against unknown persons. Lord, he specifically admits. Against unknown persons, my lord. Now, such being a case, my lord, he won't be a maliciously prosecuted. Meanwhile, what has happened, my lord, he filed a petition before the honorable court, my lord, for quashing the petition. The petition comes to be allowed. We are stating that he was not named in the complaint. But subsequently, he initiated criminal proceedings for malicious prosecution. But there, my lord, it was acquitted. But judge over there, my lord, this is subsequent development, my lord, where, my lord, it was observed that he was not been injured or damaged, maliciously prosecuted. Whereas, my lord, police have filed a C report stating that the incident has happened, but we can't find out the unknown person. Such being a state, my lord, I filed this petition before the application before the trial court, my lord.
Come to the order.
My lord, order is at page number 24, two reasons, my lord. 23 is where, my lord, judge says. Para number 11, my lord. The plain further discloses that the plaintiff was compelled to approach the honorable court for quashing. The criminal proceedings and FIR was ultimately quashed. The averments taking face value do constitute a cause of action for damages. What they say, my lord. My lord, at page number 24, my lord, subsequently, my lord, at para number 13, they say, my lord, this being a mixed question of law and facts, that acquittal in 211 of IPC and quashing of FIR are material to be required in appreciation of evidence. My lord, both have been initiated for malicious prosecution, my lord.
No, your that complaint is quashed by the High Court.
My lord, with respect to this petitioner, yes, my lord, plaintiff. Plaintiff is quashed by the High Court.
is quashed.
Yes, my lord. But my lord, he institute after the quashing of the petition, my lord, he instituted malicious prosecution of criminal proceedings, my lord. Where I have been acquitted? Where the judge has taken the note?
So it is all the more, all these facts are before the court, all the order copy here and there, then it will be easy for the court to decide.
My lord, but
Just because
there is
he
no
said
cause of
that
action, my lord.
one sentence is given against unknown, that cannot be a ground to quash
But
the.
I have not given a complaint against him. If at all I have
Thereafter, who has registered against the complaint against him?
my lord, the police have registered a complaint against him. In my complaint, I have not. He himself in the plaint says a para number 9, extracted the entire complaint. He states.
Let's look at the plaint again.
Please, my lord. Plaint page number 26, it runs from.
Hmm.
Nine, my lord, at page number 36. My lord, he extracted the entire complaint, the police complaint as it is, my lord. In Kannada, my lord. Nowhere, my lord, I say he is an accused. I say an unknown persons have attacked me using his name. I have never stated him as an accused.
Please come. Then counsel for the petitioner submits that when in the suit for malicious, for damages for malicious prosecution. The plaint itself clearly states that the petitioner has not given any complaint against the plaintiff in the suit, against the plaintiff. This aspect is not considered by the court and there should be still called for the proceeding. Notice Hansaman, fourth. Yes.
Cell number 41.
Granted.
Please.
Cell number 41.
Appear for the petitioner. This is petitioner's revision petition. The suit was filed. The suit was filed for the recovery of possession under section 6 of the Special Relief Act. The court dismisses my suit on the ground. First ground is that you are not the original mortgagee. My case is I was put in possession as a mortgagee and
Issue notice.
Issue notice.
Will issue notice.
interim order.
What interim order?
Not to alter the nature of the property. That's what he has done it, and this court had granted earlier. Your Lordship may kindly see at page 61. At page this matter.
Take out hand summons and file a memo to that effect by 4th of August. If it is filed, list the matter on 5th.
Cell number 42. Krishna Gowda.
Petitioner.
Krishna Gowda B.
Suit for specific performance was filed, my lord.
Yes.
In that case, the defendant was served with the notice. He has not chosen to appear, my lord. Ex parte judgment and decree was passed. After the passing of the judgment decree, that is 8 years, the defendant's LRs, that is the wife and son, files a miscellaneous petition.
That is allowed. What is the delay? How much is the delay?
8 years.
Where is the affidavit filed by them?
By them, madam.
Suit was decreed during the lifetime of the defendant.
Lifetime of the defendant.
When was the decree?
Decree, madam, 24. 26/3/2014.
When he died?
He died on 24/5/2015.
Please come to the order. Where is where the court has discussed?
He condones the point number that is in the in page of page number 18, in page of 11 of the order. Point number 13, shall I read it, madam? As per the IA under section 5 of Limitation Act, there is a delay in filing this petition on perusal of the judgment and decree dated 26/3/2004.
Page, where is this present impugn order?
Present order. Page number 8, page number 8. The relevant portion I'm reading is in the page number 18 of the order. And the petitioners have got the knowledge of the judgment. No document is produced by the petitioners. In the affidavit, the first petitioner stated that the
It
petition.
is stated that the suit is decreed on 26/3/2014.
Yes, madam.
The first petitioner undergone the medical treatment
Yes, ma'am. He has undergone the
as an
treatment.
inpatient at Sri Jayadeva Institute of Cardiovascular Science
Yes,
and Research, Bangalore on 29/5/2014
After 3 months.
and 2/6/2014.
After 3 months of the judgment, he has
Yes.
shown. Madam. There is no document which was produced that as on date of the judgment or when the suit was pending, he was not feeling well. It was only after the 3 months of the passing of the judgment, the records which was produced, medical records.
Order notice.
What has happened, the court has taken day-to-day matter, madam. They allowed the petition and.
When was this order passed?
On 3/17. And we have asked.
When counsel for the petitioner submits that after a, what is that sound continuously? After it is submitted that it is submitted that after 8 years from the date of judgment and decree, an application is filed to set aside the ex parte order, ex parte judgment and decree, and the court without recording any reasons has set aside the same. Considering the same, there shall be stay of all further proceeding. Portion 2 so and so. The hand summons memo shall be filed by 7th of August, list the matter on 10th of August.
Cell number 43.
It's 43, I'm appearing to the
Take
I'm the
respondent.
appeal for the petitioner, my lords.
I'm led by a
Papers are
senior
served.
counsel. Led by a senior counsel. Matter involves substantial
Monday?
question of law.
Same submission was made on the last occasion.
It reached at same 4:55. That's why I made the submission. It's not that I'm asking time, laws. We are ready with the matter.
Monday it reaches at 5 o'clock also,
I
your
will
senior
report.
should be here.
Please, I will be.
Monday
My apologies for the thing.
in the first list.
Grateful.
45, let's see, list of the service of notice.
Cell number 45 of the service. Cell
Yes,
number
sir.
46. Kumar K.
Memo for withdrawal.
45, serial number 45, please, your lordship. Copy of the petition has been served on criminal law. Revision petition, please, your lordship. I undertake to file wakalat. My name may be shown.
So and so submits that, he has instructions to,
Ah,
you have instructions to file wakalat, or you have filed.
No, please, your lordship.
He has instructions to file wakalat, list the name, print the name of so and so. Next. 46.
I'm appearing for the.
It is stated that during the pendency of the writ petition, the disputes between the parties amicably settled. Hence, the memo is taken on record and dismissed as withdrawn. Yes, 47. Continuous, they're talking.
But before the trial court, the matter was disposed on 26/2/2026.
It is stated that the suit itself is disposed of, hence nothing suffices for consideration, accordingly dismissed.
Yes.
Memo is taken on record and dismissed as withdrawn. Yes, 48, list after service of
I've
notice.
taken the notices on the party as well as the advocate.
You appear for the petitioner.
I am up here for the petitioner.
You have already served,
I already served,
give that,
yes.
All the
Both-
respondents?
Both on the party as well as the
all
advocate.
the respondents or
All
only
the
one?
respondents, all the
How many respondents are there?
There are 4 respondents, my lord.
A memo is filed stating that as per the order passed by the court, hand summons were taken on all the respondents, on the respondents as well as the counsel appearing for the respondent, and he has filed a memo to that effect. Accordingly, notice to respondents 1 to 4
Yes.
is held sufficient. What about the next one?
My lord, the interim order may be extended. The last one, that is a writ petition 123 of 2026.
In all the matters, same
Same
respondents?
Same respondents, my lord. There
Yes,
is a connected
in
matters.
48.1, 48.2. And what about 48.3?
48 point also same, my lord.
But I think it is not, notice is not ordered in this matter.
Notice has not been ordered because the same, it was not tagged on the earlier occasion.
Yes, interim order is already there,
No, it is not there, my lord. It may be.
has to be heard.
Yes, my lord.
List this matter for preliminary hearing on Tuesday. Yes, for all the
Interim order,
matters.
interim order may be extended.
That's why I asked you whether there is an interim order.
There is an interim order in all that matters.
Look at it, if interim order is there, extend, if interim order is there, list in the month of September.
No, all-
Yes, next.
All the matters are interim.
49.
Serial number 49,
Huh.
the advocate was present, the respondent advocate. In this case, compromise petition is rejected. Suit for injunction was filed. Parties, we have agreed compromise petition is filed. That compromise is rejected because in that compromise, defendant is confirming the ownership of the property of the plaintiff. Only on that ground, my lord, it is rejected. We challenge it for this honorable court. My lord. Kindly have it tomorrow, my lord, because here afternoon. My lord.
No, what about R1 to R3 for?
That's for R1 to R3. R3
Yes.
advocate is appeared.
We'll have it on Tuesday.
Please.
List on Tuesday in the first list.
Cell number
50.
50.
I appear for, my lord, in this case, summons is served, but petition copy, despite request, my lord, they have not served. The
So you
copy.
appear for whom?
For respondents, all I undertake to take.
Respondents, how many?
9 respondents.
Respondent, Land Council so-and-so submits that he has instructions to appear on behalf of 1 to 9.
Please.
Land Council, the petition, sir, the copy of the writ petition. You have an interim order? Interim order earlier granted is extended. List this matter on 12th of August. Yes.
Cell number 51.
I'm for the petitioner.
Yes.
In this case, I have mentioned note regarding acts of objection that I have challenged the order of the 6 rule 17, your lordship, dismissal order, and I have mentioned regarding acts of objections. I have mentioned note as the respondent defendant has not filed objections to the said IS, your lordship.
No, office objection is you have not filed the objections.
No. Office is raised objection regarding the copy to furnish the copy of the
Objections filed by them,
but
that they have not filed.
Yes, your lordship.
Council submission with regard to the office objections as upheld. The post this matter for preliminary hearing on Wednesday. Yes.
Cell number 52.
Before responding, my lord, I am for petitioner, my lord. I've been challenged that DR been noticed, my lord.
My lords, before that, may I make one submission, my lords? Suit itself is disposed of before the trial court, my lords.
When?
No, my lord.
My lords, however, my lords, the judge has sought for transfer because stating that it is not before me, my lords. She has written a letter to the district judge, my lord, saying that both the petitioner and respondent are practicing advocates before me. Let the matter be transferred to some other court. He has to, my lords, approach
This
that.
matter on Monday.
My lord, one kind submission, my lord, for the urgency, my lord, since many dates I am waiting for that, kindly 2 minutes give me, my lord. My lord, I am a bar president, my lord, one of the bar president. One of the bar member been alleged that something has happened, misappropriation together with that general body meeting not been conducted like that, this. And he been complained to DR, my lord. Directly, they have been complained to DR been noticed to me. Subsequently, the members, what have been happened, they directly conducted the general body meeting, my lord, in the bar. Directly conducted the general body meeting and appointed a provisional president, my lord. And provisional president is acting now the powers, exercising the powers, my lord, in the bar. What has happened that we have been challenged before the same trial court, my lord. What has happened? The trial court heard the matter on IA number 1 and 2, and it is posted for orders, my lord. The same trial court have heard the IA number 1 and 2 and posted for orders, my lord. Subsequently, at the time of orders date, what has happened? Because both are practicing advocates, they've been quarreled before the judge, my lord. For the reason, what has happened? That judge requested to PDJ to transfer, my lord. I have no objection any of those things, my lord. Whatever the things has happened, if it is been transferred to other court, my lord, district court. The matter been transferred to district court. I have no objections about the transfer or anything, my lord. The reason is they've been without considering that, without taking prior permission of that, even the conducted general body meeting don't have right to conduct, because in the bylaw it is clearly mentioned that secretary or any member don't have any right to conduct the general body meeting. It is clearly mentioned. However, they conducted, even conducted itself is not valid, my lord, because they've been conducted 21/4/2026, but all the members, many 10, 15.
Who will decide it now?
DR, my lord, DR has to decide, even not deciding that they are acting.
We'll ask them to decide it.
No.
My lords, this becomes.
Whoever it is.
No, he is not DR, my lord. He's
not the DR. Whoever has to decide will decide.
For the reason, my lord, before deciding, the provisional president acting, exercising the powers.
Now the matter is, the order passed by the court is transferring it from there to the district judge. They will ask the district judge to pass orders. In between, this court will not pass any orders.
No, at least, no, my lord. That is my condition. I have no objection, my lord. Whatever the things.
I will ask the court to pass orders within a week.
Please, my lord. No,
You
till that at least 1 week, because what, my
Please
lord,
understand,
what has happened, my
I will
lord?
not grant those kind of interim orders. Let the court decide within a week. I will pass an order.
Please, my lord. Please.
Yes.
At least till 1 week, not to precipitate like that, my lord, because
1 week.
my lord,
I am not applying the, I mean, I'm not looking at the merits of the matter. Now, what is your case? What is the relief that you sought? Quash the order dated 8/6/2026, passed by the principal judge. Where is that order?
Page number 74, my lords.
70?
4.
What is that order?
The transfer petition.
District and sentence so and so regarding transfer of the suit before any other court, and office is hereby directed to write a letter to the Honorable Principal District and Session Judge at Tumkur regarding the same for further necessary action in this matter. What happened thereafter?
My lords, now the letter is being transferred to the principal district judge. It is before the principal district judge. She has to take a appropriate decision, my lords.
Where to which court it has to be
Please,
allotted?
fourth junior division, my lord.
It will be
has been
allotted, my
transferred.
lords.
PDJ has taken the addition. I have no objection, my lord, all these
Now,
things.
where is it pending now?
Fourth additional
We will direct fourth additional
civil judge and JMFC.
civil
Tumkur.
judge and JMFC.
Tumkur, my lord.
Tumkur, yes.
Tumkur.
The
My lord, I
petition-
have no objection. My humble submission is that, my lord, till that at least, because they have got time 1 month. Of course, my lord, I agreed.
Please let 1 week is not a big deal. I will this order.
However,
copy-
my lord, since 2
this
months they've been
order
dragged
copy-
and exercising the
Anyway,
powers in that bar, my lord. That is my request, my lord. Humble
this order
request before
copy
the
will be
honorable court is
uploaded
that, my lord.
by Monday evening. This order copy will be
At least,
uploaded
my lord,
by
1 day, it's enough. Honorable court can
Not-
take
not
decision
required.
1 week
I will
also,
not
my lord.
take. Please come. The petitioner is agreed by an order dated 8/6/2026, whereby the court, whereby the, which court is this? So the principal
Court.
civil judge and JMFC
Not
addressed a letter
civil.
to the district principal judge
Fourth additional civil judge and JMFC Tumkur.
for transfer of the case for further necessary action in this matter. This matter pertains to the dispute between the bar association, and it is submitted that expressing the difficulty, the lineage judge has asked the principal district and session judge to transfer this matter. It is a submission that now the matter is transferred to the fourth additional civil and civil judge and JMFC Tumkur. Then counsel for the petitioner submits that as there is as is a dispute between the members of the association, the governing body of the association, and he is questioning the action of some of the members contrary to the bylaws. There may be this court may direct the respondent not to precipitate the matter. Next paragraph. Then counsel appearing for the respondent submits that on this cause of action, on this order, there cannot be any, the present writ petition is not maintainable. It is submitted that already the matter is transferred and the court will hear the matter and pass appropriate orders. Next paragraph. Having heard the counsels on either side, there's a material on it. What is our question before this court is the proceedings rated 8/6/2026. This court do not find any reasons to interfere with the impugned proceedings, and the further submission that the court should pass some order till the matter is heard by the lineage judge, and that also this court finds no force in the said submission. Considering a sensitive issue of this nature, the court has to apply its mind and hear the parties, and basing on that, appropriate orders needs to be passed. But that cannot be by just a one-line order. Those issues cannot be decided by the court. By the court. Hence, in balancing the interests of both the parties, this court deems it appropriate to pass the following order. The writ petition is disposed of, directing the fourth additional civil judge and JMFC to dispose of the application, that's IA number
1 and 2, my lord.
1 and 2 within a period of 1 week from the date of receipt of the copy of the order. By Monday evening, upload this order.
Grateful.
Number 53.
But there is a subsisting interim order, my lords, request for
53.
There is
What
an
happened to
interim
the notice?
My lords, I have served upon defendant number 1, 2 and 4.
Why you have not filed acknowledgement?
My lords, it is filed today, my lords, in the registry. The other.
As you know, I'll say that interim order will be
I know,
vacated.
my lords, the other defendants refused in spite of serving it.
But you have to file a memo,
Lords, it is
whatever
filed, my
it
lords.
is.
Already it is filed in the registry.
Memo shall be filed by, interim order is extended if the memo is not filed by.
My lords, it is filed. There is an acknowledgement. It is filed today.
Interim order earlier granted is extended. This chapter service of notice is
Grateful.
54.
54, TP Muttanna.
54, my lord, one objection is there, that one writ petition is filed, since writ challenging more than 2 IAs, my lord.
What are the 2 IAs?
2 IAs is same, that one IA is my lord, that application for recalling that evidence of the evidence.
Reopen and recall.
Reopen and
Office
recall.
objection with regard to the maintainability is overruled.
My lord, this one interim order is required. Today this matter was there, my lord. then filed a memo stating that matter is coming up today. The learned single judge said, no, I will pass the order, sir.
The difficulty with this, with these matters is nobody is understanding. How is it possible for the court to hear? How many matters I can hear in a day?
That is true, my lord. That I
Every day
agree.
morning, 100 people coming and saying that, and you have to understand, if really there is something, what is happening is, now with these many people coming and making mentions, even when there is an urgency, I'm not hearing it. Because, and again, afternoon, going in the chamber, looking at these much of memos, and looking at the memos, giving the dates.
But
It's
even that-
practically impossible for the court.
Like, even that learned single judge would have appreciated it because this matter is pending and it's coming up. We could have urgent to 1 week.
Tell the court that it is coming up on Monday, the list.
Yes, ma'am.
Monday.
Thank
Monday in the
Very
first
fast.
list.
My lord, in this case, I am permitted to convert the writ petition
Take that
to CRP. My lord. Order under Order 7 Rule 11, rejection of application. Office raised objection with regard to the maintainability.
The writ petition is filed against an order rejecting an application order 7 to 11. Office has raised an objection with regard to maintainability. A memo is filed by the counsel of the petition seeking conversion. Memo is taken on record and the petition is permitted to convert this into a into the CRP within a period of 1 week from the date of receipt of the copy of the order for all statistical purposes. Yes, notice in 56.
I may be permitted to take notice to
And
trial
summons
because
on
one
the
day delay is
counsel.
there, my lords.
Huh?
Only 1 day delay is there, my lords.
Whatever it is.
I may be permitted to take notice to advocate.
Notice to the respondents. Hand summons. Memo shall be filed by 11th of August. If it is filed, list on 12th August.
Great. my lord.
Yes.
Serial number 57, my lord. I appear for the petitioner. My lord, what has happened is section 24, my lord, my application has been dismissed. And I am asked to go before the same judge against whom I have complained, my lord. There is a complaint against the presiding officer, my lord, on the administrative side. My lord, what has happened is now the Monday, the learned appellate court has slated the matter for final orders, my lord. And that is the urgency. Again, if I have to go back, my lord, there is an element of bias and there are plethora of materials that I have placed before the learned court. Your lordship may kindly come to page 26 for a moment now. The last 5 lines, my lord. These are the reasoning. Page 26 of the.
Which court is this?
This is the principal district judge, my lord, Bangalore Rural. The last 5 lines I may be permitted to, my lord. 26 months.
26.
That's the impugned order, my lord. That's the reasoning portion. My lord, hence the said fact goes to show that by the time the case was called, the petitioners might not be present in the court hall, and hence the trial judge might have passed the orders. My lord, what has happened is there was a conflict between the petitioner and the presiding officer, my lord, that led to a lot of skirmish, my lord. And subsequently, what has happened is when the petitioner was inside the court hall, the cause list, it was not listed, my lord. And the case has been called at 11:40 and is posted for orders. My lord, there are other materials, my lord. There is a convenience compilation that I have filed, my lord. Maybe time constraint of the court, my lord. I don't know whether your lordship is in a position to look into it. This complaint, my lord, is still pending adjudication, my lord. Now the section 24 application has been dismissed by the principal court, which means, my lord, I have to go back to the same court, my lord, on Monday. Monday it has been slated for final orders, my lord. If this CRP, my lord, is not heard, my lord.
What is it so grave allegations that you don't want to go before the judge?
No.
I should be
Yes,
convinced with
my
that.
lord.
Come to that. What
Yes.
is that complaint?
My lord, your lordship may kindly go to page 4, my lord, of the convenience compilation, my lord.
Yes.
My lord, para 8 onwards, my lord. I state upon the knowledge of the said incident, I was extremely surprised for the uncourteous conduct of the presiding officer, which is unheard of.
No. What I'm not able to understand
Yes,
is, on 6/4/2026, the appearing counsel sought for a passover. As the senior counsel was engaged in the matter, he is before however, the presiding officer, in a contumacious manner, rejected the request made
On
by
that day, my lord, may I.
No. Why should a party make all these allegations of it? The advocate was appearing. If the
No, what has happened, my lord, is on that day, the presiding officer said that he doesn't want to hear the matter. Please take the file out of my court because it is causing immense stress on him. on the presiding officer.
With these complaints.
No, it was before the complaint. And the presiding officer said that all matters have to be argued on or before 11:45 before this court. My lord, that is impossible. My lord, we agreed for the next day. My lord, what has happened in the next day, your lordship may kindly come to, my lord, page 8, my lord.
Yes.
The matter was not listed at all. The petitioner was present before the court hall. And at 11:40, my lord, without the case being called, my lord, it has been posted for orders recording the absence of the respondent. And in fact, the presiding officer threatened the petitioner saying that you prove your presence before the court hall. Lord, that is impossible to do that.
I'm not able to understand from this 8.1, what is there in 8.1?
No. On page 8, my lord, your lordship may come to page 8. The cause list extract I have produced, my lord.
Hmm.
Our case was not listed on that day. It could not have been called at 11:40, my lord. Previous day, the entire thing had happened.
Your case is not listed. What did the learned judge do?
Yes. At 11:40,
I'll call for a report from the concerned court about all these allegations.
please, there is a complaint already pending, my lord. I leave it to your lordship. I leave it to your
As
lordship.
an order on the judicial side,
Yes.
let me look at it. And as it is, the allegation that are made appears to be not so grave that the matter has to be removed from that court.
My lord, what has happened is with the dismissal of my section 24 application, my lord, the complaint has also become infructuous in sum and substance, my lord. And if there is no interim protection, my lord, what I am asking today is that, my lord, let the passing of the order be kept in abeyance. I am not even asking for
Suit of which year?
suit of 2023, my lord. I was 39(1) and 2 was ordered in my favor. That was challenged by the respondent in MA. In MA, all these things happened, my lord.
So it shouldn't be vacated.
No, I'm not against vacating. I was not given an opportunity to argue. I was not even given an opportunity to file my.
You yourself say the senior counsel is somewhere, senior counsel is some other
No, he
place
was
on some day.
inside the court hall. The court said that, man.
So
all
these
that I'm asking.
complaints against the judicial officers in a routine manner.
My lord, I'm the last person to do that, my lord. That what has happened, my lord. All that I'm asking today is let there be an order that the order may not be passed on Monday.
So now he's going to pass orders on
Orders on Monday.
So we should stay it today.
My lord,
Ultimately,
otherwise-
like that's what is the petition is successful
My lord,
in all these complaints.
may I put it this way, my lord. Let there be at least, my lord, to be kept in abeyance for 2 days. I may be permitted to.
I'll call for a report. I'm telling if any of this convenience compilation, any of the facts that are stated before the court are not supported by any material. I am telling it, I'm going to impose exemplary costs on the petitioner. If you're ready with that, I'll grant an order. But I'm making it very sure. I'm not taking it very casually. I will consider. I will ask for a report. There is some, whatever basis you have made, I've asked, I'll send a copy of
It's
this.
all born from the records, my lord.
With that kind of an illusion, we can't pass orders. If anything born out of record, you tell, definitely it's a case to interfere. Not like, just like that, these kind of allegations will not consider.
It is definitely not a bad allegation, my lord. I have also made certain
Then
inquiries.
if you say so, then it should be supported by something, because that is what we look at.
But even the section 24, my lord, order, impugned order, my lord, says on passed on assumptions, my lord. It
What
says might have
assumptions?
been.
Because there is no substance in what your case, your
The complaint is being
is.
investigated, my lord. That's what the other.
Then investigating the complaint.
The principal district judge, Bangalore Rural, my lord.
But these allegations, I can understand is something else. But these are not so grave that you can't go before the judge and argue.
My lord, the presiding officer told that he cannot hear the matter, my lord.
No, he's hearing it. No, that's your case that
No,
he
he's
shouldn't
not
hear now.
hearing. He's not hearing. He's passing the orders. He's passing the orders on
I'll
Monday.
ask him to hear. I'll say, give an opportunity to the petitioner to advance his arguments on Monday. That would be sufficient, if that is your problem.
Being an element of bias, my lord, I'm not on instruction.
You have
on that.
other courts. You have other courts. That is not the end. You can come here then. I will tell him to hear you. Let the petitioner be heard Respondent, you are the respondent in the MA.
I'm the respondent.
Respondent in the MA be heard on merits, and then the court should pass an order.
I do not have.
Because if.
No, I completely understand your lordship, where you are coming from.
Yes.
My lord, may I say this, my lord? I will seek instructions, my lord. The respondent is a heart patient, he is not before the, I will seek instructions. Your lordship may kindly have it on Tuesday. Let there be a direction. Monday in the matter.
I will not state. That's what I wanted to. Because let us not send any wrong signal to the
I am not
district
asking for
judiciary.
an order of stay, my lord. One day let the orders be kept in abeyance. That's what I'm asking. Let me have I don't want the benefit of, my lord, the order for even.
I will record all this. Learned counsel for the petitioner has stated that they have no confidence in the learned judge who is hearing the MA, and they sought for a transfer, and the same is rejected by the district judge. The learned district judge has passed an order saying that as a petitioner might have not appeared before the learned judge, and that's how the and on those grounds the case cannot be transferred. This court, on the face of it, as because it is not supported by any material, is not of is not able to appreciate any of the contentions that are advanced on behalf of the petitioner. However, it is stated that the matter is coming up, and it is stated that the learned judge is not ready to hear him on merits and going to pass an order on Monday. Then this court has expressed that the matter will be remanded. This court will pass an order directing the petitioner to appear before the learned judge, and the learned judge shall hear him and pass orders. For that, learned counsel for the petitioner submits that the petitioner submits that he'll get instructions. It is stated that the matter is coming up on Monday. Today, as the matter has reached at 5:39, and as there is no time for him to get instructions, let's this matter on Tuesday. Only on Monday, the court shall not proceed with the matter.
Greatly obliged.
So, number 58?
Yes, 59, some other day.
No, 58 and 59. 58 and 59.
Yes.
On these seven,
My
my
lord, list
sincere
number-
apologies, not 71.
list number two,
And it becomes
serial number
infructuous tomorrow because liquor licenses have been auctioned tomorrow, my lord. It's 10 a.m. in the morning. I will just pass on this. This is a liberty which is granted, my lord, by this.
So what do you want me to do now?
My lord, as long as my auction, my licenses are not included in the auction, I have no problem, my lord. It's tomorrow morning. They've included my auction license.
When did you? When was the cause of action arose?
My lord, cause of action, my lord, in 2026. It is when they.
When
1st
is the
July,
date?
1st July.
Where are we now?
My lord, to be very honest, my lord, we moved multiple memos, my lord.
No, multiple memos means when the matter, what has happened on the first day?
It is not a fresh matter, my lord. It's a pending matter where I was given liberty. May I just give this? I was given liberty. If they include my license in the auction, I was given liberty to move the court. They said that they will not be included.
What are
in
your
auctions.
instructions?
Let's kindly.
It is only two auctions, two licenses.
We are filing additional statement of objections, my lord.
So what I'll do is, I'll take it up on Tuesday.
Please.
Till Tuesday, not to take, no, not to finalize anything.
No. That can't be done. Kindly have it tomorrow at least.
So tomorrow
How
morning,
can I
10
have it
o'clock is the
tomorrow?
auction.
Tomorrow is Saturday.
My lord.
Friday. But tomorrow morning is the auction, my lord. 10 o'clock is the auction. So Haveri, my lord, if my two licenses
No, you
were
can
not
conduct
there,
the
I have no
auction a day
problem.
later
That's
also.
my only humble submission is to not to grant any interim order as such now.
You will instruct them?
Yes. Tomorrow it can be heard, my lord.
No, it will be done by the time.
What do you think tomorrow? Tomorrow, how can it be heard? Oh, this is what happens when you all come and unnecessary mention, then the court will not hear when the matter is
I understand,
necessary
my lord.
also.
Which is why I
That's
started
what
with
every
an
advocate
apology.
should understand.
I started with an apology, my lord, because this is
Yes.
the problem.
Kindly have it
My
tomorrow,
two
my lord.
auctions,
Kindly have it tomorrow, my lords, please.
two licenses.
In this matter, my lords, AAG will be appearing, my lords. That is the problem.
May I
So
just pass
for this
on?
case, court will have you will have a house motion tomorrow. And I'm also not available for your house motion.
There are 14 licenses.
Tomorrow is Friday.
Tomorrow morning, my lord, 10 o'clock.
Then we'll have it in the
My lord,
first
10
hour.
o'clock is when the auction starts. I have this schedule here.
But till 11 o'clock. I'll take it up at 10:30. I was under the impression as if like today's.
Yes, the auction is already fixed, my lords. That is the problem.
Everything, now just now you said tomorrow.
Yes, my lord, tomorrow it can be heard. But the
Then
auction,
what is
the
the-
auction, it's online auction, my lords. It will be starting at 10 o'clock itself.
I have the schedule here, my lord. My lords, may kindly see the schedule. This 10 Haveri, my lord, only 2 licenses in that. I'm not asking for the entire auction to be stalled. 2 licenses, because what I've already, that is why I sought for liberty, and liberty was granted to me. As long as they don't proceed with Haveri, I'm okay.
No, you intimate 10:30 we can, it takes hardly 5 minutes. That matter.
Please.
Till 11 o'clock, don't do anything.
No, my lords, that can be done. The whole auction proceedings will be,
How it is done, auction is?
Lords, already. No, moreover, my lords, they challenging the notification dated 3/11, my lords. And this, with respect to this notification, Supreme Court has already dismissed the notification, my lords.
That is not with
Rejected
me.
the application. So there was amendment brought to the notification as such in 5A rule, my lords.
We are completely different. That's why.
Inclusion
That's why
of
my lord,
unissued
run
quotas.
FGA. I am on a different footing altogether. I have, my lord, with regard to.
So, without even knowing what is his case, you're so desperately
No,
making
my lords.
submission.
The problem is,
May I just
I
clarify
lack
in 1
instructions, my
minute?
lords. I
Nothing
lack
more than that.
instructions. I lack instructions, my lords. Kindly have it in first list tomorrow, my lords.
That's what I said.
1 minute.
But you shouldn't do anything.
In 1 minute, may I say what the case is, my lord?
No, anyhow, it's okay, let them do whatever they want to. Just listen to the court. If I hear your matter and if I pass an order, what will happen?
No, the auction gets
My lord,
confirmed because
right now-
it's my license which is being auctioned. I have a subsidy. I
They
paid
don't have the
fee in
license.
2018. That is what they want to now, my lord.
So
They've not
according
been
to you,
Officer, my
according
lords.
to you, court cannot do anything after auction is done.
I'm not saying that at all.
That is what I am
My lord,
also
I would
saying.
say, my lord, the.
So,
Please.
what we can do today, we can do it tomorrow also. Let it be in the first list, on the top of the list, this matter.
10:30 because
Yes.
Haveri is last. At least that is my breather which I
Tomorrow,
get.
10:30.
Lordship,
My lords,
serial number 75, it is posted.
my
for
lords,
judgment,
my lords,
my lord.
in this matter, my lords,
75 posted for.
I will
second
not-
list, my lords,
And no signatures.
my lords, second list, 41st.
Number 2 may be taken up by this, my lord. Sir.
Sir.
Next to 11, sir.
ಮೇಡಮ್ ಎಲ್ಲ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಮೇಡಮ್ ಪಾಸ್ ಮಾಡ್ತಾರೆ ವಿತ್ ಇನ್ ಹಾಫ್
Madam,
ಅನ್ ಅವರ್ ಐ
48.
ವಿಲ್ ಅಪ್ಡೇಟ್ ನೀವೆಲ್ಲ ಲಿಸ್ಟ್ ಇದಲ್ಲಿ ನೋಡ್ಕೊಂಡು ಎಂಟ್ರಿ ಮಾಡಲ್ ಎಲ್ಲೆಲ್ಲಿದೆ ಎಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಸರ್ ವಾಟ್ ಎವರ್ ದ ಡೇಟ್ ಅಸೈನ್ಡ್ ಬೈ ದಿ ಲಾರ್ಡ್ಶಿಪ್ ವೇರ್ ಎವರ್ ದ ಇಂಟೀರಿಯರ್ ಆರ್ಡರ್ಸ್ ಆರ್ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಸ್ಟಿಲ್ ಟುಡೇ ಇನ್ ದೋಸ್ ಮ್ಯಾಟರ್ಸ್ ಮೇಡಮ್ ನಿಮ್ ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಬಂದಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಮಂಡೇ ಆರ್ ಟ್ಯೂಸ್ಡೇ ಐ ವಿಲ್ ಲಿಸ್ಟ್ ಇಟ್ ನಿಮ್ದು
Madam, serial number 73, urgent to them.
ಅದೇನೇ ಇವ್ರೆ ಸೋಮವಾರ ಅಲ್ಲ ಮಂಗಳವಾರ ಟ್ಯೂಸ್ಡೇ ಹೇಳಿದ್ದಾರೆ ಟ್ಯೂಸ್ಡೇ ಆರ್ ವೆಡ್ನಸ್ಡೇಗೆ ಆ ಡೇಟು ಇನ್ ಲಿಸ್ಟ್ 1 ಅಂತ ಹೇಳಿದ್ದಾರೆ ಐ ವಿಲ್ ಅಸೈನ್
Madam, 74.
ಫೈನಲೈಸ್ ಮಾಡ್ತಾರೆ ಇವ್ರೆ ಫೈನಲೈಸ್ ಮಾಡಿ ಲಿಸ್ಟ್ ಕಳ್ಸೋವರೆಗೂ ಗೊತ್ತಾಗಲ್ಲ ನನಗೆ
Madam, serial number 73 ಒಂದು ಅರ್ಜೆಂಟ್ ಇದೆ ಮಂಡೇ ಹಾಕಿ ಸರ್.
ನೀವು
Reserved for all.
ಇನ್ಫೆಕ್ಷಸ್ ಆಗಿರೋದು
ಟ್ರಯಲ್ ಕೊಡ್ತಿದ್ಲು ಆಯ್ತು ಇನ್ನೊಂದು ಬರ್ಸ್ಕೊಂಡು ಆಯ್ತು ಹಂಗ ಮಾಡಿ ಮಧ್ಯಾಹ್ನ ಸಾಯಂಕಾಲ ಬಿಸಿ ನೀವು ಮಧ್ಯಾಹ್ನ ಮೇಲೆ ಟ್ರೈ ಮಾಡಿ
ಅಲ್ಲಿ ಫೈನಲೈಸ್ ಮಾಡಿ ಕಳ್ಸೋವರೆಗೂ ಡೇಟ್ಸ್ ಗೊತ್ತಾಗಲ್ಲ. ಬೇರೆಯವರು ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಅಷ್ಟೇ.
Madam, one request, madam, serial number 73. There is urgency.
ಎಲ್ಲ ಮ್ಯಾಟರ್ಸ್ಗೂ ಡೇಟ್ಸ್ ಅಸೈನ್ ಆಗುತ್ತೆ. ಡೇಟ್ಸ್ ನ ಮೇಡಮ್ ಫೈನಲೈಸ್ ಮಾಡ್ಕೊಡ್ತಾರೆ. ಆಮೇಲೆ ನಾನು ಅದನ್ನೆಲ್ಲ ಡೇಟ್ಸ್ ಅಪ್ಡೇಟ್ ಮಾಡ್ತೀವಿ.
ಅದು 28 ಗೆ ರಿಸರ್ವ್ ಫಾರ್ ಆರ್ಡರ್ಸ್ ಆಗಿದೆ.
ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಎಲ್ಲೆಲ್ಲಿದೆ ಅದು ಎಕ್ಸ್ಟೆಂಡ್
ಎಂಟ್ರಿ ಮಾಡಲ್ಲ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ರಿಸರ್ವ್ ಫಾರ್ ಆರ್ಡರ್ಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ದಟ್ ಇಸ್ ವೈ ಮೇಲ್ ನಾಟ್ ನಾವು ಹೇಳ್ತಾ ಇರೋದು.
ಅದೇ ಸರ್, ಮೇಡಮ್ ಯಾವ ಡೇಟ್ ರಿಸರ್ವ್ ಮಾಡ್ತಾರೆ, ಯಾವ ಡೇಟ್ ಫೈನಲೈಸ್ ಮಾಡ್ತಾರೆ ಅಂತ ನಮಗೆ ಗೊತ್ತಿಲ್ಲ. ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ ನಿಮ್ದು?
73.
ಏನಾಗಿದೆ ಅದು?
ಅದು ರಿಸರ್ವ್ ಫಾರ್ ಆರ್ಡರ್ಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ನಾಳೆ 29th ಇದೆ. ದಟ್ ಇಸ್ ವೈ 27th ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಹಾಕಿದ್ರೆ ನಿಮಗೆ ಒಳ್ಳೇದಾಗುತ್ತೆ.
ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಅಲ್ಲ, ನಾನು ಐ ವಿಲ್ ಬ್ರಾಟ್ ಟು ದ ನೋಟಿಸ್ ಆಫ್ ದ ಮ್ಯಾಮ್.
ಹೌದು ಹೌದು.
ಹೌದಾ?
Tomorrow.
Yes.
ಅದು 70
ಏನ್ ಮೆಮೋಸ್ ಅದು? ಅಲ್ಲ ಇದು ಈ ತರ ಮೆಮೋಸ್ ಎಲ್ಲ ಇವಾಗ 10:30 ಕೊಡಿ, ಬೆಳಗ್ಗೆ 10:30 ಕೊಡ್ಬೇಕು. ಯಾವಾಗ ಸರ್ ಇದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಕೊಡ್ಬೇಕು. ಏನಾದ್ರು ಕಂಪೈಲೇಷನ್, ಈಗ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ನಾವ್ ಇವಾಗ ತಗೊಳಕ್ ಬರೋದಿಲ್ಲ. ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ. ನೌ ಯು ಆರ್ ಫೈಲಿಂಗ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್. ಹೌ ಕ್ಯಾನ್ ಐ ಟೇಕ್ ಇಟ್ ಸರ್? ಸೈಟೇಷನ್ಸ್ ಅಥವಾ ಬೇರೆ ಏನಾದ್ರು ಅಂದ್ರೆ ಐ ವಿಲ್, ನೀವು ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಕೊಡಿಯಪ್ಪ. ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಆದ್ರೆ ಯು ಸಬ್ಮಿಟ್ ಅಂಡ್ ಗಿವ್ ಟುಮಾರೋ ಮಾರ್ನಿಂಗ್. ಬೆಳಗ್ಗೆ ಬಂದು ಹೇಳಿ. ಅದೇ ಸರ್, ಡೇಟ್ಸ್ ಎಲ್ಲ ಫೈನಲೈಸ್ ಆಗಿ ಬರ್ಬೇಕು ಮೇಡಮ್ ಇಂದ. ನಾನು ಐ ಹ್ಯಾವ್ ಟು ವೇಟ್ ಫಾರ್ ಹಾಫ್ ಅನ್ ಅವರ್. ನಮಗೆ ಗೊತ್ತಿಲ್ಲ ಸರ್. ಯಾವ್ದು ಹೇಳಿ? 71 ಇಲ್ಲಿ ಹೇಳಿದ್ರು 10:30 ಅದು ತಗೋತಾರೆ ಮೇಡಮ್ ಬಂದಾಗ. ಅಂದ್ರೆ ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಅಂತ ಹೇಳಿ
10:30 ಗೆ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
ಇಲ್ಲ
ಇವ್ರೆ ಡೇಟ್ಸ್ ಎಲ್ಲ ನಾವು ಅಸೈನ್ ಮಾಡೋದಿಲ್ಲ ಗೊತ್ತಲ್ವಾ? ನಿನ್ನೆ ಬಿಕಾಸ್ ಆಫ್ ಯುವರ್ ರೆಸಲ್ಯೂಷನ್ ಯೆಸ್ಟರ್ಡೇ ಐ ಕಾಂಟ್ ಅಸೈನ್ ದ ಡೇಟ್ಸ್ ಅನ್ಲೆಸ್ ಇಟ್ ಈಸ್ ಫೈನಲೈಸ್ಡ್ ಬೈ ದಿ ಜಡ್ಜ್. ಅದು ನೀವೆಲ್ಲ ಅಲಿಗೇಷನ್ ಮಾಡಿದ್ದೀರಾ. ಕೋರ್ಟ್ ಆಫೀಸರ್ಸ್ ಡೇಟ್ಸ್ ಕೊಡ್ತಾರೆ, ಅವ್ರು ಕೊಡ್ತಾರೆ, ಇವ್ರು ಕೊಡ್ತಾರೆ ಅಂತೆಲ್ಲ ಗಲಾಟೆ ಆಗಿದೆ. ಅದಕ್ಕೆ ನಾವು ಅದು ಫೈನಲೈಸ್ ಆಗಿ ಬರ್ಬೇಕು. ಲಿಸ್ಟ್ ಫೈನಲೈಸ್ ಆಗೋವರೆಗೂ ನಾವು ಕೊಡೋದಿಲ್ಲ ಡೇಟ್ಸ್. ಮೇಡಮೇ ಫೈನಲೈಸ್ ಮಾಡ್ಕೊಡ್ತಾರೆ, ಕೊಟ್ಟಾದ್ಮೇಲೆ ಕೊಡ್ತೀರಿ. ನಾಳೆಗೆ ಯಾವುದು ಇಲ್ಲ ಸರ್. ನಾಳೆಗೆ ನೋ ಮ್ಯಾಟರ್ಸ್ ಇನ್ ದಿಸ್ ಲಿಸ್ಟ್ ಆರ್ ರಿಪೀಟೆಡ್ ಟುಮಾರೋ. ದೇರ್ ಇಸ್ ಡೈರೆಕ್ಷನ್. ಮೇಡಮ್ ವಿಲ್ ಫೈನಲೈಸ್ ದ ಡೇಟ್ಸ್ ಅಂಡ್ ಸೆಂಡ್ ಇಟ್ ಬ್ಯಾಕ್ ಟು ಮೀ. ನಮಗೆ ಗೊತ್ತಿಲ್ಲ ಸರ್. ಮೇಡಮ್ ಡೇಟ್ ಕೊಡ್ತಾರೆ, ಮೇಡಮ್ ಮತ್ತೇ ಹೋಗೋದು. ಮೇಡಮ್ ಫೈನಲೈಸ್ ಮಾಡಿ ಕಳ್ಸಿದ್ಮೇಲೆ ನಾವು ಡೇಟ್ಸ್ ಅಸೈನ್ ಮಾಡೋದು. ನಾನು ಹೇಳಿದ್ದೀನಿ ಮೇಡಮ್, ವಿ ವಿಲ್ ನಾಟ್, ಬಿಕಾಸ್ ಅದು ನಿನ್ನೆ ಎಲ್ಲ ಗಲಾಟೆ ಆಗಿದೆ ಅವ್ರ ಅಸೋಸಿಯೇಷನ್ ಅಲ್ಲಿ. ನಾವು ಮಾಡೋದಿಲ್ಲ ಅದು. ನಾವು ನಮ್ದೆಲ್ಲ ಅದ್ರಲ್ಲಿ ಏನು ಇಂಟರ್ಫಿಯರೆನ್ಸ್ ಇರಲ್ಲ. ಅವ್ರು ಫೈನಲೈಸ್ ಮಾಡಿ ಕಳ್ಸಿದ್ಮೇಲೆ ನಾನು ಡೇಟ್ಸ್ ಕೊಡ್ತೀನಿ ಸರ್. ಐ ಹ್ಯಾವ್ ಟು ವೇಟ್ ಫಾರ್ ಹಾಫ್ ಅನ್ ಅವರ್. ವೇಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದಾರೆ. ಬೆಳಗ್ಗೆ 2:30 ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಬೆಳಗ್ಗೆ ಬಂದು ಆಕ್ಷನ್ ಇವತ್ತೇ ಇದೆ ಅಂತ ಹೇಳಿ 2:30 ಅಂತ ಮೂವ್ ಮಾಡಿ ಸರ್.